4 ತಾನೆ. ಏನು ಬರ್ತಾ ಇಲ್ವಲ್ಲ?
ಬರುತ್ತೆ. for list number 2. ಏನಿದು?
This is what I am reading.
What is this?
ರಾಜೇಶ್ ಸಾಹೇಬ್ರು ಬಂದ್ರಾ?
ಪ್ರಶ್ನೆ ನಾಳೆನೇ ಬರ್ತದೆ ಕೊಡಿ. To respond number 6, my lords. But instead of, my lords, in the online checking, my lords, it has been, instead of 12 it has been, my lords, 12-3 ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ. So tomorrow
ಎಂಟ್ರಿ ಮಾಡಲಿಲ್ವಾ?
ಇಲ್ಲ, ಅದು because of entry model, my lordship was posted on 12-2, my lords, by serving the copy to respond number 6.
ಸೊ ಎಂಟ್ರಿ ಮಾಡಲ್ ಕೊಟ್ಟಿಲ್ಲ.
Please.
One APMC matter, APMC matter, wherein the petitioner has made a requisitions for transfer of the license. Instead of either rejection or approval of that requisition, they have ordered for forfeiture. Tomorrow.
ಇದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Please.
ಬರೀ 230 ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ.
Please.
Adjournments.
Lordship, 230 matter, Lordship.
ಏನು?
Lord, the examination fees pay ಮಾಡಿದ್ರಿ. Examination commence ಆಗಿದೆ ಸ್ವಾಮಿ.
ನಿಮಗೆ ಚಾನ್ಸ್ ಸಿಗೋದು ಮೆನ್ಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ. ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ.
PC ಲಿದ್ರು
ಯಾರು?
ಶಿವರುದ್ರ ಸರ್.
ಏನ್ ಮಿಸ್ಟರ್ ಶಿವರುದ್ರ, ಯು ವಾಂಟ್ ಟು ಮೆನ್ಷನ್ ಎ ಮ್ಯಾಟರ್, ನಾಟ್ ದ ಜೂನಿಯರ್. ಮಿಸ್ಟರ್ ಶಿವರುದ್ರ,
ಸರ್, ಶಿವರುದ್ರ ಸರ್.
ಏನ್ ಹೇಳಿ, ನೀವೇ ಹೇಳಿ.
Examinations of commences.
ಮ್ಯಾಟರ್ ಕರೀತಾರೆ.
Adjournments. 52, page 13, 53, page 14, 54 to 58.
My lord, serial number 58, FF of petitioner. I seek next week, my lord. Next week. Senior is
At the request of counsel for the petitioner, relist on ಇದು 13th March.
ಸರ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್, ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ.
ಅವ್ರಿಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಇದೇನು ಆಡಿಯೋ ಹೋಗ್ತಾ ಇಲ್ಲ, ಚೆಕ್ ಮಾಡಿ. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಶಿವರುದ್ರ? ಇಲ್ಲ ಕೇಳಿಸ್ತಾ ಇಲ್ಲಪ್ಪ, ಅವರು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Page 15, 59 to 63.
He'll have to speak above the dog's sound.
My lord, serial number 63, my lord. And for the respondent number 124, my lord, I have raised short accommodation. Two days.
My lord also directed them to produce the consent award. It is in respect of Karnataka and Niravar Nigam. They say I have given a consent, but they are not getting rules. I request any sort of.
63 at the request of counsel for the respondent released on 13th March.
Page 16, 64 to 69. Page 17, 69. Page 18, 70 to 73.
Serial number 72, my lords. Happy for respondent number 1. Lords, this matter was substantially heard by your lordships. Lord, matter pertaining to grant in aid, my lords, to assistant teacher. My lords, somehow it is listed in B group. The lordship's permission, my lords, if I can make mention at 2:30, my lords.
Further hearing alla ididu.
This matter wherein the lordship has directed granting
40 years and all those things. Further hearing ittalla.
ಹೌದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತಾನೆ ಇತ್ತು.
Further hearing ಕೆಳಗೆ ಬಂದಿಲ್ಲ ಇದು. 72 released on 20th for further hearing at 2:30 p.m.
Please.
Page 19, 74 to 80.
Serial number.
My lord, serial number 80. There is urgency in the matter, your lordship, because the interim order is modified by the trial court that was challenged before this honorable court, and the respondent number 3 has filed a complaint before the consumer court, your lordship, and that is the order is that was posted for orders on 21/2, your lordship, and if the order is passed, definitely he will he will withdraw 50 lakhs with interest, your lordship. It may kindly be taken at 2:30, your lordship.
ಎಲ್ಲಿ 2:30 ನು ರೀಚ್
Your
ಆಗಿದೆ.
lordship, if the orders, because she is, the plaintiff is entitled for.
80 released on 20th at 2:30 p.m.
Please.
Page 20, 81 to 84.
Serial number 84, my lords. My lords have 2:30 ಅಂತ ಹೇಳಿದ್ರು. 2:30 ಬಂದಿಲ್ಲ.
ಎಲ್ಲರೂ 2:30
ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಡೆಮೋಲಿಷನ್ ಮ್ಯಾಟರ್, my lord.
ಡೆಮಾಲಿಷನ್
Please. 78 and 84.
ಎರಡು ಕನೆಕ್ಟೆಡ್.
Connected.
78 connect to 84 released on 20th at 2:30 p.m.
Interim order kindly.
Interim order. ಮತ್ತೆ interim order ಇದ್ರೆ ಏನು ಅರ್ಜೆನ್ಸಿ ನಿಮ್ಗೆ? What is the urgency?
Interim order ಇದ್ರೂ ಅಲ್ಲಿ.
Then no urgency. 84 released on 13th, interim order earlier granted is extended.
21, page 21, 85 to 90. Page 22, 91 to 96. Page 23, 97 to 102.
Serial number 100, ma'am.
What
accommodation may kind I am appearing for petitioner, ma'am. 2 weeks time.
100 at the request of counsel for the petitioner 13th March.
Please.
Lord, there is interim order.
Page,
Interim order may kindly fix.
ಅವ್ರಿಗೆ ಬೇಡ ಅಂತ ಬಿಟ್ಟು. Interim order next, please.
page 24, 103 to 107.
Serial number 30, 30. Issue wakalat, my lord. In week time will be granted. Wakalat.
Inform ಮಾಡಿದ್ದೀರಾ petition?
Shankar Devar,
Yes.
ಏನ್ category orders?
Yes.
30 at the request of counsel for respondent number 4 released on 13th March.
One submission. Serial number 64, my lord. This, my lord, I made a submission on the last occasion that my allotment of site has been cancelled, and the lordship have directed to list it.
Yes. So,
1, Lakshman T. Mantagani.
I am for the petitioner. But the petitioner is in possession and malad waiver of the land, property being 44 wherein her name is also shown in the record of rights. That is annexure A and B are the property extracts. Here the respondent number 4 and 5, without having any right over the property in question, they made a representation to the panchayat taluk panchayat officer. Page 14 here this is the page 14. They represent ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಗೊಳ್ಳಿ ಗ್ರಾಮದ ಶ್ರೀ ದಿಲಾವರ್ ಸಾಬ್ ತಂದೆ ಬಾಳಸಾಬ್ ಸುಲ್ತಾನ್ ಬಾಯಿ ಹಾಗೂ ಇತರು ಆಸ್ತಿ ನಂಬರ್ 44 ಬೇಕಾಯ್ದೆಸಿರಿ ಶ್ರೀ ಮುಕ್ತುಮ್ ಸಾಬ್ ತೋರ್ಗಲ್ ಹಾಗೂ ಇವರ ಮಗಳಾದ ಫಾತಿಮಾ ತಂದೆ ಮುಕ್ತುಮ್ ತೋರ್ಗಲ್ ಅಂತ ದಾಖಲು ಮಾಡಿಕೊಂಡಿದ್ದನ್ನು ರದ್ದುಪಡಿಸಲು ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಕ್ರಮ ಕೈಗೊಂಡು ಮನವಿದಾರರಿಗೆ ಹಿಂಬರ ನೀಡಲು ಕಾರ್ಯಾಲಯಕ್ಕೆ ವರದಿ ಸಲ್ಲಿಸಿದೆ. Here on the representation of the Taluka Panchayat made a correspondence with the Gram Panchayat to take action on that. But here the Gram Panchayat has issued an endorsement, that is NSRD, stating that this is in respect of the title of the property in question. You have to approach the civil court. Here, your lordship kindly they have sook the himpara kodala helidare antande. Subsequently, your lordship kindly see these persons, the respondent 4 and 5 made a appeal to the under section 269 to the Taluk Panchayat. Here under 269 they have not at all challenged any original order and anything. As per section 269, your lordship kindly take they have to challenge the any original order passed by the Gram Panchayat. Here ಪ್ರಾರ್ಥನೆ ಲಾಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 19 ನಲ್ಲಿ ಎದುರುಗಾರರು ಯಾವತ್ತು ತಕರಾರುಗಳನ್ನು ತಳ್ಳಿ ಹಾಕಿ ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಸಂಗೊಳ್ಳಿ ಗ್ರಾಮದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಆಸ್ತಿ ನಂಬರ್ 44ಕ್ಕೆ 18/8/85 ಸಭೆ 5ರಲ್ಲಿ ಠರಾವ್ 4 ಮೂಲಕ ಸಂಗೊಳ್ಳಿ ಗ್ರಾಮದ ಆಸ್ತಿ ನಂಬರ್ 44 ಪಾಸ್ ಮಾಡಿದ್ದನ್ನು ರದ್ದುಪಡಿಸಿ ಮೊದಲಿನಂತೆ ಹೆಸರುಗಳನ್ನು ದಾಖಲುಪಡಿಸಲು ನ್ಯಾಯ ಮತ್ತು ಸಮ್ಮತಿ ಒಪ್ಪಿಗೆ ದೃಷ್ಟಿಯಿಂದ ಆದೇಶ ಮಾಡಲು ಇರುತ್ತದೆ. Here, after lapse of 38 years, the resolution was passed in the year 1985 for implementation that without challenging any original order. For implementation, they approached the Taluk Panchayat, wherein Taluk Panchayat proceeded to pass an order, that is annexure K. Your lordship kindly take the impugned order, that is annexure K. Here they have proceeded to pass an order, Adesha, that is 37. ಮೇಲ್ಮನೆಯನ್ನು ಪುರಸ್ಕರಿಸಲು ತಕರಾರಿಗೆ ಆಸ್ತಿಗಳಿಗೆ ಮೇಲ್ಮನೆದಾರ ತಂದೆಯ ಹೆಸರನ್ನು ದಾಖಲು ಮಾಡಿ ಆದೇಶಿಸಿದೆ. ಹಿಯರ್ ಆಸ್ ಪರ್ ಪೇಜ್ ನಂಬರ್ 37 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಆಫ್ ದ ಆರ್ಡರ್. ಹಿಯರ್ 85 ರೆಸಲ್ಯೂಷನ್ ನ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಮಾಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತಾರೆ. ಮ್ಯಾಂಡಮ್ಸ್ ಲೈಕ್ ಮ್ಯಾಂಡಮಸ್ ದೇರ್ ಇಸ್ ನೋ ಪ್ರೊವಿಷನ್ ಎಟ್ ಆಲ್. ದೇ ಹ್ಯಾವ್ ಟು ಆಸ್ ಪರ್ 269. May I read 216 Panchayat Raj?
It's only an emergency.
Yes, yes. 269.
Yes.
Any person aggrieved by any original order of the Gram Panchayat under this act, unless appeal is provided elsewhere in this act, may within 30 days from the date of such order appeal to the executive officer. Here, there is no order, they have not at all changed any order. Moreover, after lapse of 38 years, they wanted to implement that Gram Panchayat resolution. Furthermore, here the Taluk Panchayat, the officer order sheet may kindly be looked into. They have not here last after the last order, page number 30. Page number 30. 22/9/2022 ಮೇಲ್ಮನಿದಾರರು ಮತ್ತು ಅವರ ಪರ ವಕೀಲರು ಹಾಜರಿರುತ್ತಾರೆ. R1 ರವರ ಪರ AC ಪಾಟೀಲ್ ವಕೀಲರು ವಕಾಲತ್ತು ಸಲ್ಲಿಸಿ ತಕರಾರು ಸಲ್ಲಿಸಲು ಸಮಯ ಕೇಳುತ್ತಾರೆ. ದಿನಾಂಕ 12/10/2020ಕ್ಕೆ ಮುಂದೂಡಲಾಗಿದೆ. Here already written argument have been filed by the petitioner. Subsequently, your lordship kindly take next page number 31. This is dated 15/10/2022. ಮೇಲ್ಮನವಿದಾರ ಮತ್ತು ಅವರ ಪರ ವಕೀಲರು ಹಾಜರಿರುತ್ತಾರೆ. R1 ಗೈರಿರುತ್ತಾರೆ, R2 ಹಾಜರಿರುತ್ತಾರೆ. ಇನ್ನು ಚೌಕಾಶಿ ಮಾಡುವ ಜರೂರು ಇರುವುದಿಲ್ಲ ಅಂತ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಕಾರಣ ಆದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆ. This after reserving this after lapse of 5 months, this annexure K to be passed. That to on that on 27/3/2023. Your Lordship kindly see the conduct of that the Taluka officer, executive officer. I have secured from the authority whether he was on the office or not. On 23/7/2023, he was not at all in the office. He was on duty. Your Lordship kindly, this is 27/3/2023.
27-3.
27/3/2023. Here, 8:30, my lord, he went for, my lord, visiting the Gram Panchayat. Thereafter, on night, my lord, 10:30, he returned. Madam, on that day, he passed in order.
May permitted to see the document, my lord, I will encourage.
Madam,
Instead of going to merits of the case, my lord,
There is no merits in the ತೋರಿಸಿ ಅವ್ರಿಗೆ. ಮಲ್ಖಾಣಿಯವರೆಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಈವನ್ ಥ್ರೂಔಟ್ ಮೇಲೆ ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಹಂಗೆ ಸ್ವಲ್ಪ
I will verify it from, I will verify it.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಅವ್ರ ರೆಪ್ಯುಟೇಷನ್ ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ ಅಂತ.
I will verify it.
appeal itself is not maintainable, first of all.
Blood, I will verify it from.
That will direct, but how is this order, how can this order be passed?
Blood,
Yes, madam. You have not challenged any order. You only asked for cancellation of the entry.
There was an application for change of name entries, my lord, which is Russian kindly there is annexure C, my lord. After passing of the award, only the name and the number and the date is not forthcoming in the appeal. That doesn't mean that it is not an appeal.
You have not challenged this endorsement. Endorsement at annexure D, you have not challenged.
269 ಅಂತ appeal ಹೋಗಿದ್ದು. Annexure E.
ಇಲ್ಲ ಅದರ
Annexure F.
Where have you challenged that endorsement?
That's what I'm saying. That specifically the order date has not been mentioned.
Not date, endorsement ಆದ್ರೂ challenge ಮಾಡಿದೀರಾ? You only asked for the name to be deleted and your name to be added.
Resolution has been challenged, my lord. Resolution has been challenged.
ಅಲ್ಲ ಮಾಡಿಲ್ಲ ರೆಸಲ್ಯೂಷನ್
ಇಲ್ಲ, annexure F, that was challenged. ವಿಷಯದಲ್ಲಿ ಇದೆ in appeal. Annexure K, my lord. Wherein in subject, my lord, it has been mentioned.
ಪ್ರೇಯರ್ ನೋಡಿ ಪ್ರೇಯರ್
It is my lord, original.
Condemnation of delay.
ಇಲ್ಲ
Please.
Where is the condemnation of delay? It is not so. Even assuming that there is a challenge of 18/8/85 resolution.
Please.
That has been made in the year
My lord, the
23.
Please, my lord. I gone through the my lord, documents on submission. My lord, in the appeal, the appeal appellant has mentioned that my lord, they have filed an application seeking for continuation of delay. Even in the written arguments also they have submitted.
Where is the order?
But in the order it was not considered. Yes, my lord. But they have submitted application seeking for kindly see, my lord, annexure E, my lord. Annexure E, page number, it was not 19, my lord. 19 in internal page number 4. ಲಿಸ್ಟ್ ಪ್ರಕಾರ ದಾಖಲೆಗಳನ್ನು ಮತ್ತು ಕಾಲ ವಿಳಂಬ ಮನ್ನಾ ಕೋರಿ ಮಧ್ಯಂತರ ಅರ್ಜಿ ನಂಬರ್ 1 ಅನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Blood, it was not properly mentioned the page.
ಪ್ರಕಾರ ದಾಖಲಾತಿಗಳು ಕಾಲ ವಿಳಂಬ
Appeal, in appeal memo, my lord.
ಸಲ್ಲಿಸಲಾಗಿದೆ.
ಸಲ್ಲಿಸಲಾಗಿದೆ. Even in the written argument submitted by the appellant also they have submitted. They have submitted ಲಿಖಿತವಾದ in the annexure H, my lord.
What is the reason for?
Blood,
Order ಅಲ್ಲಿ.
when it was not considered by the appellate court, it was not mentioned in the order, my lord. Yes, please. They have mentioned, they have filed application.
This is the
But kindly
executive
see.
officer. Executive officer will come under whose jurisdiction? Secretary ga?
ಎಸ್ ಮ್ಯಾಮ್ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಅಂಡ್ ಮಲಡ್ ಸೆಕ್ರೆಟರಿ ಸಿಇಒ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಅಂಡ್ ಮಲಡ್ ಸೆಕ್ರೆಟರಿ
ಈ ಒಂದು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನೀವು.
ಮಾಡಿ ಸೆಕ್ರೆಟರಿ
One moment, my lord, kindly see the, what is the impugned order challenged in the appeal, my lord. Annexure, ink page number 21, typed copy of annexure F.
Yes.
ಠರಾವು ಸಂಖ್ಯೆ 4 ಆಸ್ತಿ ನಂಬರ್ 44 ಬಗ್ಗೆ ಆಸ್ತಿ 44 ಮಾಲೀಕ ಮುಕ್ತುಮ್ ಸಾಬ್ ಫಕ್ರು ಸಾಬ್ ಸುಲ್ತಾನ್ ಬಾಯಿ ಇವರು ಸದರ ನಂಬಿಕೆ ಇದ್ದ ತನ್ನ ಹೆಸರನ್ನು ಕಡಿಮೆ ಮಾಡಿ ತನ್ನ ಸಂಬಂಧಿ ಮುಕ್ತುಮ್ ಸಾಬ್ ಮೊಹಮ್ಮದ್ ಸಾಬ್ ತೋರ್ಗಲ್ ಇವರ ಹೆಸರನ್ನು ದಾಖಲು ಮಾಡಲು ವರದಿ ಬರೆದ ಪ್ರಕಾರ on that basis blood mutation has been. Yes, but it's totally blood without following any due procedure of law.
Petitioner is before this court seeking for the following reliefs. Respond number 4 and 5 had filed an application to the respond number 3 Panchayat Development Officer for deletion of the names of the petitioner from the revenue records and entering the names of the respond number 4 and 5 therein. The said request came to be rejected by an endorsement dated 10/11/2020 directing the respond number 4 and 5 to approach an appropriate civil court and obtain necessary orders. Without challenging said endorsement, however, in a convoluted manner, challenging the resolution dated 18/8/1985, under which the names of the petitioners had been entered into the records. An appeal under section 269 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993 came to be filed in appeal number 203/2223. The said appeal came to be allowed by the impugned order dated 27/3/2023, directing the entry of the name of respondent number 4 and 5 in the records. It is challenging the same. The petitioner is before this court. Sri Lakshman Mankani, learned counsel for the petitioner, submits that no original order has been challenged in the appeal as filed. Furthermore, the resolution under challenge is dated 18/8/1985, as regards which, though it is stated that a condemnation of delay application has been filed, it has not been filed or not filed.
Madam, so far as my case is concerned, no application has been filed.
No such application has been filed. Be that as it may, he submits that there is no condemnation of delay which has been granted in the impugned order or any other order passed thereon. As such, without looking into these aspects, the impugned order could not be passed. Ms. Archana Magdum, learned counsel, appearing for respond number 4 and 5, submit that it is by virtue of the resolution dated 18/8/1985 that the names of the petitioners were entered into, and as such, the resolution having been challenged, the resolution is the original order. Sri Lakshman Mankani has also produced a memo along with the document obtained under the RTI Act, indicating that on the date of the order, that is 27/3/2023, respondent number 2 was on a field visit from 8:30 a.m. and returned back at 10:20 p.m. And therefore, respondent number 2 not being in the office could not have passed the said order on the said date, impugned order on the said date. Sri V. Shivraj Remat, learned counsel for respond number 2 and 3, submit that in the appeal memo there is a mention made of an application for condemnation for delay. On inquiry as to whether the delay has been condoned, he is unable to point out any particular order in relation thereto. He also supports the case of learned counsel for respond number 4 and 5 by stating that it is the resolution dated 18/8/1985 which is being challenged in an appeal under section 269. Heard so and so, peruse papers. Section 269 is reproduced hereunder for easy reference. Subsection 1 of section 269 requires that any person aggrieved by any original order of the Gram Panchayat under the Act, unless appeal is provided elsewhere in the Act, may within 30 days from the date of such order appeal to the executive officer. Though it is contended that the resolution dated 18/8/1985 is the original order, I am unable to accede to the said submission inasmuch as a resolution cannot be said to be an original order passed by the panchayat. And therefore, he is not amenable for an appeal under section 269 of the Act of 1993. As regards having come to such a finding, and there would be no requirement to go into the aspect of whether there is a condemnation of limitation application filed, condemnation delay application filed, and whether the same is allowed or not. But on the face of it, on the face of the impugned order, it is clear that no such application has been considered by the second respondent, even if so filed. And as such, without consideration of such an application, the impugned order could also not have been filed. This aspect is being referred to for the further reason that as per the document produced by Sri Lakshman Mandgani under the RTA Act, respondent number 2 is stated to be on a field visit from 8:30 a.m. to 10:20 p.m. Thus, all these factors, if taken together, would indicate that all is not well in the office of respondent number 2, and an order has been passed in the manner as done without regard for the rule of law. In that view of the matter, respondent number 1 is directed to cause an inquiry into the manner in which the order has been passed, more particularly as regards respondent number 2 being on a field visit for the entire day, could not have passed the said order on that day, and therefore the date of the order does not appear to be correct. Of course, it is for the first respondent to cause an independent inquiry and ascertain the veracity of the allegations made against respondent number 2 and thereafter take any action. In view of my finding above that an appeal under section 269 is not maintainable, challenge a resolution passed by the panchayat, and such resolution is not an original order. The appeal itself not having been maintainable, I pass the following order. Writ petition is allowed. A certiorari is issued. The order dated so and so, passed by respondent number 2 at Annexure K is quashed. Liberty is however reserved to respondent number 4 and 5 to approach appropriate civil court, obtain necessary orders, and thereafter if successful, seek for change in the name of change in the entries.
Copy may be directed to Milada.
Memo ಕೊಡಿ.
Yes.
2, Arun Nilopan.
Lords, petitioners have challenged the order passed by respondent number 2, my lordship. My lordship, respondent number 3, Tahsildar has passed an order.
Breakfast agilla.
Wise.
No, my lordship, not it.
Yes, really.
My lordship, respondent number 3, Tahsildar, had passed an order, my lordship, that is impugned order at Annexure C at page number 3, my lord, page number 21, my lordship. Respondent number 4, Tahsildar. He passed an order for forfeiture.
Order of 1987, 97, 21 and 23. And AG accepts notice.
There is a delay of 24 years in challenging the order, original order.
That came to be
That
condoned
came to be
by
dismissed
us.
and that has been confirmed by the Deputy
No,
Commissioner.
lordship. That came to be condoned. Delay came to be condoned, and again on the same cause, the appeal came to be dismissed, my lordship.
Condone है कि same cause?
Yes, my lordship. Order annexure page number 19 may kindly be perused, my lordship. In the first para, the delay is condoned. I may permitted to read out, my lordship.
ವಿಳಂಬವನ್ನು ಮನ್ನಾ ಮಾಡಿ
Ha, sir.
ಸ್ವೀಕರಿಸಿ.
Yes, ma'am.
That's only your prayer. Oh, ಜರುಗಿಸಲಾಗಿತ್ತು. Okay.
And on the next page, on the same ground, it is rejected.
What is your reason for delay?
Yeah, without issuing notice, the annexure C came to be passed, my lordship. Without notice to even my father and even the petitioners and respondent number 6. Entire order, if my court permits me to read out, I may be permitted to read out, my lordship. There is no recital regarding the notice issued to my father, my lordship. He was very much alive and his name is reflecting in the record of right
Name
as
was
the owner.
deleted. He's not a
And-
party.
And
He's not a party. Annexure C.
Annexure C, it is the suo motu proceedings conducted by the Tashildar.
no,
Yes,
up
but-
by application of the villagers, my lordship.
Treating
Village
somebody's
or-
name,
Yes.
notice kodad badu.
As per section 58, notice is.
Allowing something and inserting somebody's name, it is fine. But if you're deleting somebody's name, he has to be given notice.
May I take it, Lordship, at page 22 of the order? Annexure C.
Yes.
ಉಪ ತಹಶೀಲ್ದಾರ್ ಗರಗ್ ಇವರು ನಂಬರ್
ಓದ್ತಾ ಇದ್ದೀರಾ?
ಪೇಜ್ ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ
Page number 22, my lordship.
ಉಪ ತಹಸೀಲ್ದಾರ್.
ಎಸ್ ವರದಿಯಲ್ಲಿ ಜಮೀನನ್ನು ಮಾಜಿ ಭೂ ಮಾಲೀಕರು ಶ್ರೀ ಗಂಗಾಧರ್ ರಾಚಯ್ಯ ಸ್ವಾಮಿ ಕರಿಮಣಿ ಇವರು ಕೊಟ್ಟೂರು ಗ್ರಾಮದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಅವರು ಸ್ವಾಮಿ ದೀಕ್ಷೆ ಪಡೆದು ಊರು ತಿರುಗಾಡುತ್ತಿದ್ದಾರೆ. ಪ್ರಸ್ತುತ ಜಮೀನು ಅವರು ವಹಿವಾಟ ಮಾಡುತ್ತಿರುವುದಿಲ್ಲ ಅಂತ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಹಾಗೂ ಜಮೀನಿನ ರೈತರು ಸಹ ಜಮೀನು ಕಬ್ಜಾ ಹೊಂದಿಲ್ಲ. ಅದನ್ನು ಸರ್ಕಾರಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ರೈತರು ತಕರಾರು ಇಲ್ಲವೆಂದು ವರದಿ ನೀಡಿದ್ದಾರೆ ಮತ್ತು ಈ ಬಗ್ಗೆ ರೈತರು ಹೇಳಿಕೆಗಳನ್ನು ಪಡೆದುಕೊಂಡು ಪ್ರಕರಣಕ್ಕೆ ಲಗತ್ತಿಸಲಾಗಿದೆ.
Tenant statement is recorded, not the
Thereafter,
owner, my lordship.
ಸ್ವಾಮಿ ದೀಕ್ಷೆ ತಗೊಂಡು ಇವಾಗ ಬಂದ್ಬಿಟ್ರು.
Sons are there, my
Notice
lordship.
ಕೊಡಬೇಕು.
Family members are there.
ನೋಟಿಸ್ ಕೊಡಬೇಕು.
No notice is issued to them.
My lord, that would have, even though notice have been not served, that would have approached the higher authority by filing an appeal well within time. That is
It
after
was
lapse
not
of
within the
24
knowledge.
years. 24 years that appeal is filed. 97 order na 23 ದಲ್ಲಿ 21 ದಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ಅವರು.
RTC ಎಂಟ್ರಿ ಯಾವಾಗ ಆಯ್ತು?
It is existing till 1994, my lordship. I have,
87 is the order.
ಹೌದು.
yes, my lordship. At page number 39 and 41 are typed copies, my lordship.
Lord, at page 33.
39 it shows, my lordship.
96, 99, 98, 99 ಇಂದ ಸಾರ್ವಜನಿಕರ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಿದೆ. ಕಾಲಮ್ ನಂಬರ್ 2 ದಲ್ಲಿ.
Page number 39, it shows, my lordship, my name. Gangadhar Swami Karimani Rachaya Swami. It continues till 1993-94.
Yes.
97 ಇಂದ ಸರ್ಕಾರದ್ದನೇ ಇದೆ. Up to filing of an appeal.
My name is there, my lordship.
Your name was there till 93-94. You have challenged it
21.
in 21.
My lordship, even if the notice is issued to family members, they would have come to know, my lordship. No notice is as such.
No, in the RTCs, your name has got changed. What document have you produced to show that you have been cultivating, you have paid the taxes, that you have exercised ownership right over the property from 94?
After death of father, my lordship, these petitioners started cultivating, my lordship.
ಏನ್ produce ಮಾಡಿದ್ದೀರಾ document?
Only record of rights I have produced, my lordship.
Record of rights is only till 93-94.
No, my lordship, without notice, such an order came to be filed, my
It
lordship.
also come within time. You can't come after 20 years.
Even if we consider that 94, such a notice.
21 ನೀವು appeal ಹಾಕಿರೋದು.
True, my lordship, these
By that time, rights have been created in respect of other people.
rustic villagers, my lordship, they won't be knowing.
Thick villagers ಏನಿಲ್ಲ. How can you say that?
Annexure C itself speaks, the deputy Tashildar has collect.
Notice for respond number 1 to 5. Notice to respond number 6 is dispensed with in lieu of the order proposed to be passed. The petitioner claims that the land in block number 5 and 6 measuring 2 acres 13 guntas of Kottur village, Dharwad Taluk, belong to the father of petition number 1 and 2 and father of respond number 6. The name of the father of the petitioners was entered into in the revenue records and found mentioned till the year 93-94. Subsequently, on an application made by respond number 6, that the father of the petitioner is no longer carrying out agriculture activities, he has taken Diksha and had renounced the worldly possessions. Same was considered and the report having been secured, the entry of the name of father of respond number 6 was made in respect of the above property vide ME number 2527. It is challenging the same that the petitioners filed an appeal under
136-2.
section 58(2).
136.
136-2.
Filed an appeal in RTS stroke CR stroke 78 stroke 2021 before respond number 3, Assistant Commissioner, which came to be dismissed by order date 17/11/2021. Challenging the same, a revision petition was filed under subsection 3 of 136 in RP number 43 of 2021, which came to be dismissed by the Deputy Commissioner on 8/2/2022. It is challenging both these orders that the petitioner is before this court. The submission of learned counsel for the petitioner is that the entry made in the name of the father of respondent number 6 and subsequently in the name of respondent number 6 from the year subsequent to the year 1994 is without any notice to the father of the petitioner or the petitioners, and as such the said order is required to be set aside. A perusal of the RTCs which have been produced by the petitioners themselves indicate that the name of the father of the petitioner was in existence in the RTCs till the year 94-95, and thereafter the name of
ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅಂತ.
thereafter
Order came to be
Column
passed in
6.
97.
Sarkara has been inserted and an endorsement made that the land will be used for public purposes. Thus, the land has not been transferred in the name of respondent number 6, but has been reserved for
No,
the public purposes.
respondent number 6 is my own brother, my lordship. He's son of the petitioner, brothers,
Not the brother.
brothers, my lordship. He's brother of the petitioners, my lordship.
Yes. Brother,
Brothers of the petitioner,
he is the son of the brother of your
the
father.
petitioner. No, no, my lordship.
ಇಲ್ಲಿ ಹೇಳಿರೋದು ಹಂಗೆ ಹೇಳಿದ್ದೀರಾ?
He is Tirthaya Karimani, my lordship. I have, page number 45 may kindly be perused. I have filed succession certificate, Varsa certificate, my lordship. He is
So
the
why
son
you
of,
made them respond number 6?
please, my lordship.
Why you made him respond number 6?
He was not readily available to file, while at the time of filing the writ petitions, he has read as respondent number 6, my lordship.
Para 4 ಅಲ್ಲಿ ಬೇರೆ ಏನೋ ಹೇಳಿದ್ದೀರಾ? ಹೊಡೆದಾಕಿ ಹಾಗಾದ್ರೆ ಇಲ್ಲಿ ರಾಂಗ್ ಇದೆ. The name of the petitioner's father was entered into in respect of block number 5 and 6, measuring 2 acres 13 guntas of Kottur village, Dharwad taluk. Petitioners and respond number 6.
Please, my lord, are the sons of the original owner, my lordship.
The father of the petitioner is stated to have expired on 17/8/1998, leaving it behind the petitioners and respond
Number
6
6 as his legal.
legal heirs. Earlier, an entry had been made in the name of Takkanagowda, son of Mallanagowda, in the cultivators column from the year 73-74 to 74-75. And his name had been entered into in the record of rights as per ME number 2527. Irrespective of which, it is claimed that the father of the petitioner and respondent number 6 will continue to cultivate the property. In the year 1997, respondent number 4 passed an order stating that no person had filed form number 7 claiming occupancy rights, and there was unauthorized construction which had been put up in the said property, and as such an inquiry having been conducted, it being found that there was no owner who was available, the name of the father of the petitioner and respondent number 6 was deleted, and in the patta at column number 6, the name of this government was entered into, and in column number 9, an endorsement was made that the property is reserved for public purposes.
One submission.
It is challenging the same that the petitioners filed an appeal under subsection 2 of section 136 of the Land Revenue Act in the year 1921, which came to be numbered as RTS/CR/78/2021, which came to be dismissed. A challenge to the same in a revision petition in RP 43 of 2021 also came to be dismissed by Deputy Commissioner on 8/2/2022. It is challenging these orders that the petitioner is before this court.
Let's,
In the present matter,
one submission. In this, the Deputy Commissioner has recorded the statement of tenant. Why will he have any objection to forfeit it, my lordship, when he is not at all filed any form number 7?
there is a delay.
And the petitioners and family members were available. Nobody's statement is recorded. Deputy Commissioner has recorded the statement of somebody else who is no way concerned.
From 97
My lordship,
till
it is
21,
right of their
when it has been reserved for public purposes.
property right, my lordship. Only because of the delay,
The
valuable right cannot.
cause of a delay is 6 years.
True, my lordship. If notice is served and it is came to the knowledge of petitioners, at least family members, they would have come and filed, my
Learned
lordship.
learned counsel for the petitioner and having perused the documents, it is clearly seen that it is in the year 97 that the entry of the name of the government with the endorsement that the property is reserved for public purposes was made in the RTCs. The appeal under subsection 2 of section 136 was filed in the year 2021 after a lapse of nearly 24 years, by which time the property had already been put to use for public purposes. On inquiry with the learned counsel for the petitioner, if there are any documents which are available as regards the petitioners and or respond number 6,
My lordship,
having cultivated the land and or paid the taxes, she submits that no such documents have been produced, only the RTCs have been produced.
My lordship, may I seek pass, or at least I'll search and I'll seek instruction from my senior and make submissions. I apologize for that.
ನೀವೇನಾದ್ರು ಇದ್ರೆ ತಗೊಂಡ್ ಬನ್ನಿ ಆಮೇಲೆ recall ಮಾಡಿ. When there is no document which has been placed on record by the petitioner that they have exercised ownership rights from 1997 to 2021, and there is no reasonable cause for delay which has been established by them in RP number the proceedings under subsection 2 of section 136, I have the considered opinion that after a lapse of nearly 24 years, the delay has rightly been refused to be condoned by the Assistant Commissioner and confirmed, which order has been confirmed by Deputy Commissioner. No grounds being made out, the petition stands dismissed.
My lordship, one opportunity, my lordship. Kindly pass.
You can mention.
Please, my lordship.
If there is a document, we will allow the petition.
No, my lordship. By recording the statement of somebody else who is no way concerned,
that you have paid taxes
my
for last
property
24
rights,
years.
my lordship. That is the only property which is available to them. Please, my lordship, I understand.
Show us a document.
Yes, my lordship.
Otherwise, no.
Please, my lordship.
3, Praveen Pattar.
Not labor matter.
Hmm?
The petitioner is the driver to the respond number 2 company manner.
No interim relief.
For R1, my lord, NW KSRTC, Prashant Osmani.
And AG accepts notice for respond number 1. Shri Prashant Osmani accepts notice for respond number 2 to 4. Counsel for the petitioner furnished 2 sets of the petition along with annexures on the aforesaid counsel released on 18th March.
Please.
Prashant Osmani and total.
4, Srinivas Nadmani.
Last time directed the government to file affidavit of this one number 6 regarding deforest of land.
Yes, 3,225 acres have been de-reserved.
Lord, I will ascertain and make submission. My colleague appeared in the early. ಯಾಕಂದ್ರೆ ಅವರು ಇವತ್ತು ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದ್ದಾರೆ.
ಯಾಕೆ?
ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್.
ಇನ್ನ ಬೆಂಗಳೂರಲ್ಲೇ ಇದ್ದಾರೆ. ಆಗೋಯ್ತು ನಿನ್ನೆ.
By Monday, by Monday. I myself secure the records and make.
Seeks for a week's time to make his submission as regard the order date 10/2/2025. Relist on 24th.
Please.
5, Girish Dharwad.
Petitioner, my lord. Filing the memo, my lord, stating that the letter issued by the KSAPs, my lord,
My lord, Lordship has directed to produce them the bank accounts.
Yes.
Again, a letter of the Karnataka State AIDS Prevention Society they have provided. It is the check which was there, which I have produced along with annexures, respondent objection statement. They are of different entity, Star Security and Labor Garden Services.
Kind permission, my lord.
Yes,
Lord's kind, please, my lord.
Our Kodi.
Yes, I have taken received.
And my lord, one more, my lord, just only the party has given, my lord. One of the check dated, my lord, 2007, my lord, 972043, my lord.
First,
In that letter, my lord, the bottom third para, my lords, below the column line, my lords. In that regard.
What were you to produce? What are you producing?
Sorry, my lords. Seeking apology, my lord. The amount has been deducted from the KSFs, my lord, from the account of the petitioner, my lord. In this regard, my lord, the bottom line, my lord, in this regard, I am bringing to your office note that Recovery Officer ASA Corporation Bangalore, while letter dated so and so, has requested.
You were asked to that doesn't answer the question.
Sorry, my lords.
You are required to produce the checks and make a statement as regard the checks at page 18.
Please.
At annexure R3.
Please, ma'am.
Have they been issued from your account or not?
Yes, please, ma'am. Only one check amount has been.
Yav check. Which check has been issued from your either
page number 18, my lords, in that.
No, the annexure.
Ellide check number ellide.
This letter, my lord, this check number is just only has given, my lords, kindly next week. Senior is also out of station, my lord. 1,34,414 rupees check, my lord.
This is recovery officer letter ಮಾಡಿದಿರೋದಪ್ಪ.
But in that, my lord, check number is also mentioned, my lord. Check number 972043 dated 5/1/2007, 2000 for the amount of rupees 1,34,414.
Check number. But there was a garnishee order passed and that.
Lord, annexure R4, that is of different entity. I have produced annexure R4, the same check number. Annexure R4, page 18, Lordship kindly peruse. Adರಲ್ಲಿ check number is the same check number, that is of different entity. Same check number and date of Star Security Service and Labor Garden. Iವ್ರದಲ್ಲ.
But this is by the Karnataka State AIDS Prevention Society.
They have only given letter to them that they have deducted, but ನಮಗೆ ಅದರ deposit ಆಗಿಲ್ಲ.
ಇವ್ರು ನಿಮ್ಗೆ ರಿಕವರಿ ಆಫೀಸರ್ ESI corporation.
Yes, he has given a letter, but ಇಲ್ಲಿ annexure R3, the R4, check number, Lordship kindly see, check number 972043 of dated 5/1/2007. That is of Star Security Service and Labor Garden. ಇವ್ರದ್ದು ಬರೀ Star Security.
It is not. ಈ ಲೆಟರ್ ನೋಡಿದ್ರ?
Yes, madam. ಅದರಲ್ಲಿ ಇಲ್ಲ ನೋಡ್ಲಿಲ್ಲ, but
ಈ ಲೆಟರ್ ನೋಡಿ.
Letter ಅಲ್ಲಿ they are only mentioning the letters.
No, this is by saying that Karnataka State AIDS Prevention Society has withheld the amount.
Withheld ನಮಗೆ
as per your request and has made payment as per this check for 134,414.
ಅಲ್ಲ, ಬಟ್ ಅಲ್ಲಿ ಹಾಗೆ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ ಅವ್ರು ಬೇರೆ ಎಂಟಿಟಿಗೆ ಬರೀತಿದ್ದಾರೆ ಮೇಲೆ. ಸ್ಟಾರ್ ಸೆಕ್ಯೂರಿಟಿ ಅಂಡ್ ಲೇಬರ್ ಗಾರ್ಡನ್, ಅದು ಧಾರವಾಡದ್ದು.
ಇದು ನಿಮ್ಮ ರೆಸೀಟ್ ಮಿಸ್ಟರ್ ಕರ್ಣ್.
ಎಸ್ ಮೇಡಮ್, ಬಟ್ ಅಲ್ಲಿ ಎಂಟಿಟಿ ನೇಮ್, ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ, ಎಂಟಿಟಿ ನೇಮ್ ಸ್ಟಾರ್ ಸೆಕ್ಯೂರಿಟಿ ಲೇಬರ್ ಗಾರ್ಡನ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ಅಂತ. ದಟ್ ಈಸ್ ದಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇನ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನಮ್ದಲ್ಲ ಇದು ಇವ್ರದ್ದು ಅಂತ. that was his stand.
Is there any other entity by name Star Security Services Labor Garden Contractor?
Yes, that is the dispute before the labor
court.
No,
ಇದಾರ ಯಾರು ಬಂದಿದಾರ? Anybody has come forward?
ಲೇಬರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದು ಆರ್ಡರ್ ಆಗಿರೋದು, ಅದು ESI ಕೋರ್ಟ್ ಅಲ್ಲಿ. Lordship kindly see paragraph 15 of the judgment, my lord, page number 49, and relevant line is page number 51. Last 3 lines, may I read, my lord?
Yes.
by so and so dated 14/8/2000 so and so, by mentioning the different ESI code number. Therefore, all these inconsistent plays and facts taken by the respondent corporation creates a doubt about its case that the applicant firm is registered under the ESI Act and liable to pay ESI contribution. When the applicant establishes has strongly denied its registration under ESI Act, exhibit A9 letter written by KSIC so and so and recovery officer so and so, withholding an amount of 134 in respect of firm having ESI account so and so. All these, they have all been negativated, my lord, and ultimately the trial court has held that they are not liable to pay because this is not the entity. Even based on this letter, we have also taken contention that adu avrdu anta, but the trial court held that it is not correct.
So finally, what did they hold?
In between, my lord, if case Aid Prevention Society was there, I
Kindly
think
page
they
number
should have
21, my lord.
clarified this one.
Running page number 50, my lords.
You consider it and pass an order.
Now,
mandamus they are asking for. You pass a reason order that these are the reasons why it cannot be given.
Yes, I court held that they are not liable to pay. We are not recovered. That is our stand. Now they want refund of the money.
I think you'll have to pass an order.
Yes, ma'am.
We cannot say that you have to owe or you don't
Yes,
owe
ma'am. Yes,
in a writ of mandamus.
Based on this document, we will pass that.
We cannot decide your dispute.
Yes, ma'am. Yes,
If they had produced it, we could have given you a positive direction.
yes, ma'am.
Since they have not produced, we can't give you a positive direction as what they have sought for.
Based on this document, we will pass.
Only
Yes.
consider.
Please.
The petitioner is before this court seeking for the following reliefs. The claim of the petitioner is that certain amounts have been deposited by the petitioner and or on behalf of the petitioner with the respondent ESI corporation when the petitioner were not liable to make payment of any such amounts. And it is in that background that the aforesaid relief has been sought for. There being no particular application, I consider representation F15. Prayer alakal vallappa.
My lords.
The petitioner having submitted a representation on 25/1/2024 and a further representation on 21/3/2024, not having yielded any positive response, the petitioner is before this court seeking for the aforesaid relief. Whenever any application and or representation is submitted to an authority under the state, it is required for such authority to either accept or reject the request, stroke representation. Of course, if rejected by passing reasonable, by giving reasons. In that, neither having been done, I pass the following order. Writ petition is partly allowed. A mandamus is issued directing the respondent to consider the representation.
This is second round of. That's one submission.
25/1/24 at Annexure F and 21/3/24 at Annexure G. In terms of the documents which are available with the respondents and that produced by the petitioner.
That's one submission.
Within a period of 30 days from the date of receipt of a copy of this order.
This is second round, my lords. Earlier they have filed the writ petition that has been dismissed, my lord. Now they have never urged the grounds before the first.
We can't give you a positive direction. That's what we told your senior unless you produce.
My lord, but
they're not producing anything.
But my lord, page number 21, my lords, at the judgment of the ESI court, my lord, that they are clear, my lords.
If they are clear, go execute. You are before that on mandamus.
Please.
For mandamus, you are only given a representation. Positive direction kelidira.
Please.
I think ಏನು document produce madilla.
The letter issued by they have KSEPs has been withheld the amount on the direction of the respondent.
Produce ಮಾಡಿ ಅವ್ರ document consider ಮಾಡಿ. ನಿಮ್ last time ಹೇಳಿದೀವಿ produce ಮಾಡಿ ಅಂತ ಮಾಡಿಲ್ಲ. You are referring to a order, letter which has been relied upon by that court, and that's a completely different issue. ನೀವು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ಏನೂ ಇಲ್ಲ. You place it on record if you want. Within a period of 30 days from the date of receipt of a copy of this order. It's made clear that this court has not expressed any opinion on the eligibility of refund or otherwise of the fee. If the petitioner wishes to rely upon any further documents,
Yes,
petitioner is at liberty to furnish the same within 15 days from the date of this order.
please.
Six, Shivraj Badoli.
Please.
Yes.
Lord, here the.
As for respond number 3, my lords, waiting further instructions, my lord, in this matter. Lords, kindly have it on Monday, my lords.
Ian, further instructions apart.
Petitioner is the owner of the plot number 6442, my lord. And in the year 1998, my lord, 6443 is also allotted to me, my lord. Till today, they have not
Only
executed.
to consider the representation.
My lords, I've been instructed, I'm appearing on behalf of Sri Chetan.
You consider it and pass an order, then we'll have those reasons.
Kindly pass over, my lords. He's held up in another court, my lords. I have no instructions.
Yeah, Chetan Gedi.
My lords, kindly pass over. It's a
Don't get so perturbed. It's
no.
only a mandamus being issued.
No, my lords, kindly pass over, my lords. I'll inform my lord, my colleague, my lords.
No representation and onto you.
No, sorry, my lords.
Don't make this. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the representation which had been submitted by the petitioner to execute a sale deed in favor of the petitioner, vide letter dated 12/12/2011 at Annexure J and subsequent letter dated 28/2/23 at Annexure K, has not been considered by the respondents, and a sale deed has not been executed in favor of the petitioner. Whenever requests are submitted by a citizen to an authority, the same is required to be considered, necessary orders passed, either accepting or rejecting. Of course, when the request is rejected, reasons have to be given. Neither having been done, I pass the following order. Writ petition is partly allowed. A mandamus is issued directing the respondents to consider the representation of the petitioner dated 2/1/2024, 2/1/2004, 31/3/2008, and 6/1/2009. ಎಷ್ಟೊಂದು ಲೆಟರ್ ಇದೆಯಲ್ಲಪ್ಪ.
You have sent continuously, but my lord, there is
12/12/2011 and 28/2/23 from Annexure E to K, and pass necessary orders within a period of 30 days from the date of receipt of a copy of this order. Why are you keeping it pending for such a long time?
Continuous change of my lords, officers.
In continuous. If you say is not eligible, give reasons and say that.
Please, my
sort of eligibility, my lords. I have been allotted. I have paid the lords.
That is for them.
Please.
This is a mandamus. We can't decide those things.
Yes.
We can only say you are not passing, so you should impose fine on you.
I'll see to it that, my lords, it is necessary orders are passed, my lords.
You have 30 days and 30 days, or contempt of that.
Please, my lords.
Seven, Shivraj.
Cell number 7 is, my lords, the petition, where, my lords, the petitioner before your lordships is, my lords, the city municipal council, and, my lords, execution proceedings was initiated by the, my lords, respondent, alleging, my lords, that the order of permanent injunction was not, is being, my lords, tried to, my lords, being disobeyed. The lordships, my lords, on the previous occasion, my learned senior friend said, my lords, she will furnish certain documents along with photographs. I have also secured instructions, my lords, if your lordships permit, may I place, my lords, a few. This, my lords, as per my instructions, my lords.
Why was this attachment ordered?
Attachment order, my lords, is that, my lords, on the ground that we are, my lords, there was a decree of permanent injunction. The attachment order is passed, saying that, my lords, we are trying to, my lords, disobey the order of permanent injunction, which in fact, my lords, as per my instructions, is not the case. And there is no finding, my lords, by the executing court that indeed there is a violation of the order of permanent injunction. The photographs, my lords, if I may, that I've produced today would make it clear that, my lords, there is no violation of any kind.
So according to you, there's no road in the property?
There is no road in the property. If I may invite a lordship's attention.
Let us see the photo.
Please, my lords. The first photograph. This is how it is, my lords, since, my lords, the suit has been filed. There is no widening of road that has been taken place, my lords. The road, if I may point out the property of the respondent, my lords.
Channabasappa Javali.
Javali. The property, this property, my lords, on the left hand side, this building belongs to the respondent.
Page?
Page number 3, my lords. There is already a road passage which is there, my lords, from the date he filed the suit. Till date, my lords, it is as it is. We have not attempted to widen that road. The construction work was, my lords, carried out at the end of this road. On the southern side, my lords. No.
Where is the construction?
I mean, there's no construction which can be seen, my lord. Only road is laid, my lords, here. This portion, my lords, which is almost, my lords, 100. That can be seen, my lords, in page number 1, it can be seen, my lords.
Please, Your Lordship, kindly
What
come
are the
to
photographs you have produced?
page number 75. This is the road, my lord. Now they are using it. This is not a road. This is my property, my lord.
That we have not constructed any road on that.
If it is your property, your
Let him fence it. Let him fence
Because,
it.
my lord, if the public will thrown the stones, if I covered that, therefore, my lord, for safer side, my lord, I have constructed the building. Your Lordship, kindly see the decree, the injunction. It is in the map, my lord, it is my property.
Where is your sale deed?
Yes, my lord. Your Lordship, kindly come to page number 75, my lord. In the earlier round of litigation, this honorable court made an observation, my lord. Page number 75. Para number 13 is the decree passed in the year 1986. OS 192 of 1986.
Where is your sale deed, madam?
Sale deed, my lord. No, this is in the partition, my lord. I have got the property.
Where is the decree?
That is exhibit P4, approved plan.
What is the length and width of the property allotted to you? We will appoint a ADLR to measure this one to find out what is the width available to you.
Already the finding regarding the plan, my lord, they stated that, my lord, there is no road in that, my lord. That is exhibit
They
P4.
said they are not forming a road.
We are also not disputing the
They are
title.
also saying they are not forming any road. Ali kacha road ಇದೆ.
ಹೌದು.
ಅಲ್ಲ ಕಚ್ಚಾ ರೋಡ್ ಅದು ನನ್ನ ಜಾಗ.
ನಿಮ್ ಜಾಗ ಅನ್ನೋದಕ್ಕೆ
Exhibit P4, my lord, that is the approved plan by the municipality.
ತೋರಿಸ್ತೀರಾ ನಮ್ಗೆ?
ಅದು records call for ಆಗ್ಬೇಕು.
ಮತ್ತೆ how do we make out?
Because, my lord, in respect of para number 21, your lordship kindly see that already there is a finding. Page number 11, my lord. Internal page number 11, running page number 38. In the decree, my lord, there is a finding. This is an approved plan after 10 line, my lord. The municipality would have marked the same in this plan itself. Otherwise, it would not have at least approved this plan. But this is an approved plan. This plan.
Yeah, page number ಏನು?
Page number, running page number 38, internal page number 11, my lord.
Internal page 11.
Yes, my lord.
Yes.
There's a correction by hand, my lords. But anta, that line.
But this is an approved plan. This plan does not disclose any public way as such. Exhibit D1 is the notice given under section 112 of the Karnataka Municipalities Act 1964 as per Schedule 9 of Javali Mahantappa of Chitwadgi on 23/2/1976 with a plan. This Javali Mahantappa is none other than the father of the plaintiff in this suit. This notice is in respect of transfer of khata from name of Javali Mahantappa to Javali Channabasappa, that is the plaintiff. The sketch, rather plan, which is exhibited at D1 along with this notice in this suit tallies in all particulars with Exhibit P4 plan. Even in this plan also there is no mention regarding the existence of any public way in plot number 5, that is the plain schedule property. That is why probably the defendant municipality has not specifically pleaded in its written statement to the effect that this public way referred to by it runs in a passes through the plain schedule property itself. Then, my lord, your lordship, kindly come to para number 21, my lord.
Madam,
Page number 20.
what is the injunction order passed is restraining them from interfering with your possession or forming a road. For them to form a road, if general public are using the property, then you have to file a suit against them. ಅವ್ರು ಏನಾದ್ರು ಫಾರ್ಮ್ ಮಾಡ್ತಾ ಇದ್ರೆ there is a violation of this order. ನೀವೇ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ಅಲ್ಲ, ನಮ್ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಹಾಕದೇ ಇದ್ರೆ ನಮ್ಮ ಮನೆಗೆ ಬರ್ತಾರೆ, ಅವರು ಅಲ್ಲೇ ಓಡಾಡ್ತಾರೆ.
ಯಾರು?
ಫಾರ್ ಸೆಕ್ಯೂರಿಟಿ, ಮೈ ಲಾರ್ಡ್.
ಯಾರು ಬರ್ತಾರೆ?
ಬಿಕಾಸ್ ದ ಮುನ್ಸಿಪಾಲಿಟಿ is itself.
ಅವ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, no, municipality is supporting the public. Whenever I have given several complaints, public are using my site, but they are not protecting me. Now acquisition ಮಾಡ್ಕೊಳ್ಳಲ್ಲ, ನಿಮಗೆ ಒಂದು ಪೈಸಾನು ಕೊಡಲ್ಲ.
Give us your title document, the partition deed, and this one, we'll permit you to file and we'll direct them to assist you in constructing the compound if the measurement is so and so. ನೀವು ಈ ಬೇಸಿಸ್ ಮೇಲೆ ಇಂಜಂಕ್ಷನ್ ಇದೆ, ಜನರಲ್ ಪಬ್ಲಿಕ್ ಆರ್ ಯೂಸಿಂಗ್ ಅಂತ ಅವ್ರ ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಕ್ಕೆ ಹೆಂಗಾಗತ್ತೆ ಇದು?
Your lordship, kindly see, I have made several representation.
Madam,
I will produce the document to show that, my lord, the municipality
on the basis of your contention, we have to allow the petition. As simple as that. Because they are not doing it, they are supporting somebody, andre somebody else is doing it. I take action against them.
Suit is filed against the municipality, my lord. Suit is filed against the municipality.
Interfering with your possession.
Yes, my lord, they are interfering in my possession. Your lordship, kindly, I will produce the document to secure the records to show that. Otherwise, my lord, if they are not in process of law, my lord, there is a finding in para number 21. Your lordship, kindly see page number 22 in para number 12 in execution petition order, my lord. Page number 20, I may be permitted to read from page number 20, my lord. It is pertinent to note that judgment letter has issued for number 3 in favor of decree holder. Para number 20, page number 21.
21.
Yes, my lord. It is pertinent to note that judgment letter has issued for number 3 is in favor of decree holder in respect of property, which is at exhibit PA. The boundaries shown in the said document disclose that there is a small road towards south of the property. This document is generated in the year 2019. There is no other document available on record to show that there is road in existence towards south of the property of the decree holder. The judgment letter, relying on the boundaries shown in the said document, cannot claim that there is already exists a road when a court has given a finding that there exists no road. The contention arise by the judgment letter that is going to construct or widen the road as per the order of the deputy commissioner is unsustainable. Such claims by the judgment letter are insufficient to hold that the judgment letter has got no respect towards the decree passed by this court. It is pertinent.
All this is of no consequence when you yourself are submitting that you have put up the compound wall leaving the road.
My lord,
you have done it on your own.
No,
you can't say contempt.
When I have started constructed to edge of my boundaries, the municipality is objected for that. Because my house is there,
Where is the objection?
I will secure records, my Lord, your Lordship, kindly have it next. I will secure the records regarding
Stay
that.
this order till then. Learned counsel for the respondent seeks for and is granted a week's time to place on record the document under which the petitioner and respondent has secured title rights on the property bearing number
49F.
bearing assessment number 49-F out of survey number 257-B/B, the measurements thereof, the plan sanction which has been issued, and details as regards the interference alleged against the petitioner in interfering with the possession of the respondent. Until then, the order dated 28th August 2024 in execution petition number 10 of 2019, he stayed. Relist on 24th.
Please, oblige.
But if they are able to produce documents indicating the length, you will stand there and get the compound wall done.
As per
You will stand there and get it
please,
done.
Lords, please, please. Oblige.
You ಅಂದ್ರೆ not you. ನಾನು ನಿಮ್ಮನ್ನ ಕಳಿಸ್ಬೇಕಾಗುತ್ತೆ.
Oblige.
Notes. Before the RA court notes, compromise petition is filed notes. Same is not considered.
Compromise petition filed and not considered.
And joint memo is also filed notes. Same is rejected. On the ground that compromise petition is pending. Already 6 months have passed notes.
My lord, yesterday I have filed the wakalat, my lord. My lord, only grievance of the trial court is that the appellant 1 and 2, 2 is the sister and appellant number 1 is the brother. The terms of the compromise are thus, my lord. The suit for specific performance was filed, suit was decreed. There were 2 properties. In respect of one property, they are ready to execute the sale deed in my favor. And another property, the appellant number 1 is retaining, my lord. That compromise, the trial court is rejecting.
Nimden, you agreed to the compromise.
My lord, I am agreed, my lord. The trial court says the sister who is relinquishing her share in respect of one property can't be accepted.
He's not getting anything.
She is not getting anything. She was also present. She has been inquired before the court.
She has also signed notes.
She has also signed the compromise. Affidavits were filed.
Where is the order sheet?
My lord, ink page number 32, last order, my lord. Even we filed a joint memo referring the matter to Lok Adalat. That memo has been rejected.
Referring to the Lok Adalat is rejected. Compromise is not rejected.
Compromise ಮೇಲೆ hearing ಅಂತ ಹೋಗ್ತಾ ಇದೆ.
Hearing, they'll hear. Because this is in furtherance of the orders passed by this court saying that once it is settled, it cannot be referred to Lok Adalat. Settled ಆಗಿ Lok Adalat ರೆಫರ್ ಮಾಡ್ಕೊಡ್ದು ಅಂತ ಎಷ್ಟೋ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದಾವೆ ಹೈಕೋರ್ಟ್ದು.
ಇದಾವೆ, but
Furtherance of that.
my lord, compromise
17-8 it is
they are
filed
not
notes.
ready to accept.
Compromise petition.
The court will consider it on that day. Your application, your memo to refer the matter to Lok Adalat is rejected.
Please.
Rightly so.
As it was not considered, joint memo was filed notes.
On
not
17/8/24 compromise was filed. When it was not considered,
17/8/2024
thereafter we filed the joint memo. At least refer the matter to Lok Adalat, we will do something.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದು?
Page number 27 notes.
38-24.
38/24.
9-9, you are absent.
Yes, ma'am.
25-4, respondent absent. 22-10, you filed a memo for reference to local adalat
Yes, my lord.
instead of making a submission on compromise petition.
My lord, trial court was ready to accept, but only regarding that issue, it is not ready to accept the compromise.
So the trial court will pass orders.
Please.
The petitioner is before this court. Is mandamus,
Please.
not chairing that memo.
No, no.
No, my lords.
Memo on
Not challenged.
petitioner is before this court seeking for the following relief. The grievance of the petitioner and the respondent is that a compromise petition which had been filed on 30/8/2024 is yet to be considered by the first appellate court. And even a memo filed to refer the matter to local adalat has been rejected. A perusal of the order sheet indicates that a compromise petition was indeed filed on 30/8/2024. When the matter was taken up on 9/9/24, both the appellant and respondents were absent. On 25/9/24, the appellant was present, but respondent was absent. On 22/10/24, when a request for referring to the local adalat was made, the first appellate court rejected the same on the ground that a compromise having been already entered into, the question of referring the matter to a permanent local adalat would not arise. Insofar as rejection of the joint memo is concerned, I do not find any fault therewith. Thereafter, the matter has been adjourned to 9/12/24 for hearing on the compromise petition. Amele enayitu?
We made the submission. Trial court said in respect of appellant number 2, which he is want to give up her share to her brother, can't be accepted.
When on
Orally.
9/12/24, both the councils submit that submissions were made to accept the compromise. Since all of them were agreeable to the terms of the compromise, all the parties having signed, executed the compromise petition, being present before the court, the same is required to be accepted. Amele enayitu? 9/12 inda?
The court insisted us to convince regarding that term can be put up in compromise.
The learned counsel for respondent submits that the trial court, however, called upon the petitioners to make good the submission that respondent number 2 sister, petition number
Two. Petition number 2, my lords.
petition number 2 sister has given up her right in the property in favor of petition number 1 brother. And it is for such submission that the matter is now posted on
Next.
on blank Tirukondeli.
Please.
When a compromise has been entered into between the parties and the parties have agreed to the terms of the compromise, so long as the terms are lawful, it would be for the court to accept the said terms. Even if a person were giving up any right voluntarily, no roving inquiry is required to be made as regards whether such relinquishment is valid, is required to be made or not. When the parties have voluntarily and categorically expressed that they have executed the compromise petition of their own free will and volition, it would be for the court to accept a compromise petition so filed. In that view of the matter, I am the considered opinion that a compromise having been filed way back on 30/8/2024 could not have been kept pending for such a long time. And the trial court is directed to consider the said compromise petition, pass necessary orders, either accepting or rejecting the same at the earliest.
Next date is on 10/3/25.
10/3/20.
Oblige.
Shri, notice agilva. Shri Santosh Raut submits that he would be appearing for respondent.
So
he is directed to print his name as such.
9, Santosh Raut.
This is regarding seeking mandamus to the respondent authorities regarding put up.
Insofar as issuance of NOC to the establishment of a liquor shop, it was put in the general body meeting, my lord, out of 40 members, my lord, 7 members has been consented. Whereas these petitioners are the, my lord, unsuccessful members. Lord, once again, they have submitted application.
The resolution?
Last
A
occasion,
resolution,
my
my
lord, has
lord,
directed to
today, my
produce
lord,
this.
they are on the way, my lord. Kindly tomorrow or day after tomorrow.
Today they are on?
A resolution, my lord.
ಅಲ್ಲ ರೆಸಲ್ಯೂಷನ್ ಕಾಪಿಯಲ್ಲಿ
ಅಲ್ಲ ಅವ್ರು ಇವತ್ತು ತರ್ತಾ ಇದ್ದಾರೆ.
ತರ್ತಾ ಇದ್ದಾರೆ. ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಬರುತ್ತಾ?
ಪ್ಲೀಸ್ ಇಲ್ಲ ಆದರೆ ಡೇಟ್ ಟುಮಾರೋ
ಸಾಯಂಕಾಲ ತರ್ತಾರೆ.
ಬಂದ್ರು ಮತ್ತೆ
Let counsel for respond number 2, 5 and 6 submit that the permission to put up a liquor shop has been approved by the panchayat
Yes, my lord.
in its meeting with a majority of 14:7.
Please, out of 14 to 7 members.
Out of 14:7 ಅಂದ್ರೆ half ಆಯ್ತಲ್ಲ.
ಇವರು 6 members ಇದ್ದಾರೆ ನಾವು.
ಅಂದ್ರೆ 8 members of
8 members.
8:6 with the panchayat having 14 members.
Please.
He seeks for and is granted 2 days time to place on record the said resolution. Released on 20th at 2:30 PM.
Okay.
10 Anandarpalli.
Lordship.
Yes.
Lordship, plaintiff has filed the suit for the declaration and the permanent injunction. And plaintiff have further he wants to the reopen for the leading evidence.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಹಾಕಿದ್ ನೀವು?
For the A number, the evidence was both side closed, Lordship. The plaintiff wanted to reopen the leading evidence and mark the sum of the document which are necessary for the.
You want the plaintiff's evidence to be led?
Yes, Lordship. Plaintiff wants to sum of the evidence.
The stage of final argument in a suit of the year 2013.
Lordship, I number 13, 14 and 15 straight away the honorable trial court has rejected.
Yes, rightly so.
Lordship, please, plaintiff wants to sum of the evidence which they are very important to that property. Lordship, trial court without giving any reasonable opportunity for the plaintiff.
You've been brought on record. So you were brought on record on 12/11. And then immediately you filed the application. Issue notice to the respondents returnable by 28th April. The further proceedings in OS number 429 of 2013 pending on the file of the principal civil judge in JMFC Kushtagi are stayed till the next date of hearing. This is as per the, so on a perusal of the order sheet, it is seen that the legal heirs of plaintiff, deceased plaintiff number 1 were brought on record only on 12/11/2024 and immediately thereafter on 16/11/24 they had filed the applications for recall of the stage to permit them to lead evidence. Process fee and copies to be furnished by end of day 20th February. Acknowledgement of service on the counsel appearing for the respective respondents before the trial court to be filed on or before 27th February. Failing either of which, the interim order will stand automatically vacated. ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಕರೆಕ್ಟಾಗಿ ಹೇಳಿ, ನೀವು ಬೇಗ ಹೇಳಿದ್ರೆ ಬೇಗ ಹೋಗುತ್ತೆ. ಎಷ್ಟು ದಿನ ಆಯ್ತು ಶುರು ಮಾಡಿ ಪ್ರಾಕ್ಟೀಸ್? ಎಷ್ಟು ದಿನ ಪ್ರಾಕ್ಟೀಸ್ ಶುರು ಮಾಡಿ?
15 days. 15 days.
15 days, sir.
11.
Lord, the land in question is within the city limits of Ballari municipality, municipal corporation, which measures around 4 acres. My predecessor in title, my lord, that is my erstwhile owner, applied for a land conversion in the year 2000.
And AGA
ಅಲ್ಲ ಆಗಿದೆ, ನೋಟಿಸ್ ಆಗಿದೆ.
ಲಕ್ಷ್ಮೀಕಾಂತ್ ರೆಡ್ಡಿ ಅಲ್ಲಿ
ಇಲ್ಲೇ ಇದ್ರು.
ಪಾಸು ಪ್ಲೀಸ್.
12. Ashwin, buddy.
My lord, in this writ petition, the petitioner has challenged the impugned notice at annexure E to be found wide, page number 14, whereby the respondent number 2, that is the deputy commissioner, has directed me to remove the encroachment on the road in respect of revision survey number 71 of Savgaon village, Taluka district, Belgaum, Your Honor, within 7 days from the date of the receipt of the notice. Failing which, Your Honor, the respondent number 2 has direct consequences would be met with in the event of failure to remove the encroachment, my lord.
Yes.
My lord, the petitioner has purchased the land bearing arrest number 73/4B of Sound.
You reply to them.
Yes, my lord.
You reply to them.
My lord, he has directly he has said for the removing of the encroachment, Your Honor. And moreover, my lord, the
Don't reply properly, or if you don't remove it, it will be removed. Third option ಇದೆ. Reply ಇದ್ರೆ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ.
Earlier also similar notice came to be issued by the respondent number 3 wide annexure C, my lord.
What happened to that?
That is not acted upon.
Not
Not acted
upon.
because that notice has
Is there
been
any order
superseded.
passed on that?
No. He has not submitted any reply till today.
You have succeeded.
No, my lord,
that
concede,
time
I
when
fairly
no order
concede,
being
yes.
passed. You reply. It's a show cause notice.
My lord, and this notice which is being impugned notice at annexure E does not meet the requirement of form number 47. No description of the land, no boundaries. And moreover, it
You
does
are
not
entitled
specify.
to take all those contention in your reply.
Yes, my lord.
Petitioner is before this court.
Lord, both the matters same.
The following reliefs. What is essentially challenged is the show cause notice issued by respondent number 2, deputy commissioner. The petitioner would always be at liberty to reply to the said notice by giving out his justification and or reasons enclosing the necessary documents on which the petitioner relies upon. Needless to say, once such a reply is issued, it is for the deputy commissioner to pass reasoned orders on the same and thereafter take necessary action, reserving liberty to the petitioner to reply to the said show cause notice, which shall be so replied. ಇದು ಯಾವ ಡೇಟ್ ಇದು? 2012.
So this is 26/12
December.
2024, December, which was received by me on 3rd February. E, annexure E.
26/12/2020.
How many days? 7. The time granted in the impugned show cause notice dated
26/12.
26/12/2024 is extended by a further period of 7 days from today. Needless to say, if reply is not issued by the petitioner on or before 25th February, respondent number 2 would be entitled to proceed on the said notice.
Please.
I1 allowed. Connect.
Next same, my lord.
ಏನಿದು?
Same. ಅಲ್ಲೇ ತಹಶೀಲ್ದಾರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು earlier.
Connected, my lord.
The same notice now which is impugned is issued by the deputy commissioner. In that case, Tashildar has issued with regarding to the illegal encroachment. Same notice.
Annexure C is nothing in
But
this.
that has not
petition.
been acted upon.
That is the verbatim reproduction of
Not
annexure.
acted on this.
No.
And AGA accepts notice for respondent. And AGA submits that the impugned notice at annexure C issued by Tahsildar has not been acted upon. In fact, a notice by the deputy commissioner has been issued, which has been impugned in WP number 147297 of 2020, which petition has been disposed of.
Yes.
In that view of the matter, placing on record the submission of the learned AGA that annexure C is not been acted upon and will not be acted
Yes,
upon.
yes.
The petition stands disposed.
13. Geetanjali.
Lordship's permission. Serial number 11 as immediately it is passed over, my lord, they came.
Yes, madam. Where are you?
As a formal party, now the endorsement is passed by the deputy commissioner, which they are claiming.
Formal party.
Please, your lordship. I appear for the Urban Development Authority.
Direction quash the
Prayer is
order by
against
respondent number 2.
Please, your lordship. Deputy
Deputy
commissioner.
commissioner. Yes, yes.
My lord, the land in question is 4 acres, my lord. In the year 2003, my erstwhile owner applied for a conversion of a land use from agriculture to residential. Though, my lord, it is applied for a 4 acres, my lord, only 3.75 was converted and 0.25 cents was reserved for a road which is adjacent to National Highway number 63. Again, in the year 2013, my lord, after 10 years, I purchased the property, and year 2015, I applied for a conversion of a land from residential to commercial. Again, my lord, only 3.75 was converted and 0.25 was reserved for a road, my lords.
What was agriculture to?
Originally, in the year 2003, my lords, it was converted from agriculture to residential. That is at page number 8.
Now residential to commercial.
Commercial. After my lord, the 10 years, I applied for residential to commercial. Again, my lord, only 3.75 acres was converted. Meanwhile, my lord, this is adjoining a national highway number 63. Bypass was constructed, and this has ceased to be a national highway. So I have given an application. The road is submitted to PWD. I have given an application to saying that now, as my lord, there is no prospects of road widening. So convert the entire 4 acres, my lord, which has come to be rejected. Now, my lord, initially reserving 0.25 itself is without the.
Formal and
Annexure F में kindly. Annexure F, page 34.
That is impugned order.
Yes.
My lord, operative portion. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಿಮಗೆ ತಿಳಿಸುವುದೇನೆಂದರೆ ಈಗಾಗಲೇ ನಿಮ್ಮ ಜಮೀನನ್ನು ಬಫರ್ಗಾಗಿ ಎಂದು ಕಾಯ್ದಿರಿಸಿದ ಆದೇಶ ಹೊರಡಿಸಿದ್ದು ಅಂತ ಜಮೀನನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕೆ ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಕಾರಣ ಕೇವಲ 3.7 ಎಕರೆ ಜಮೀನಿಗೆ ಮಾತ್ರ ಭೂ ಪರಿವರ್ತನೆ ಬದಲಾವಣೆ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ನಿಮ್ಮ ಬೇಡಿಕೆಯನ್ನು ನಿಮ್ಮನ್ನು ಪರಿಗಣಿಸಲಾಗುವುದು ಎಂದು ವಿಷಯ.
Why cannot it be done?
Lord, since if it comes under the town planning authority, buffer zone, they have to give a report that whether it comes under industrial area or it is classified under the residential. Then only on the basis of the report only, my lord.
CDP, ಎಲ್ಲಿ the property?
A CDP ಇಲ್ಲ ಅದು.
Ballari.
My lord, we have examined the CDP. CDP ಅಲ್ಲಿ road widening ಇಲ್ಲ ಏನು ಇಲ್ಲ. Now as it has.
Road widening ಅಲ್ಲ. What is the zoning? Zoning ಏನಿದೆ CDP ಅಲ್ಲಿ?
Zoning, my lord, he sent me.
Zoning residential ಅಂತಿದ್ರೆ ಬರಲ್ಲ.
But the reason which has been assigned is, my lord, it is reserved for a buffer.
Buffer zone.
That is at the page number 8, my lord, they have said it. That is for a road wide.
So 3.75 ಕೊಟ್ಟಾಗ ಮಾಡ್ತೀವಿ ಅಂತ ಹೆಂಗ್ ಹೇಳಕ್ಕಾಗತ್ತೆ ನೀವು?
ಅದನ್ನ ಅವರು zoning ಗೆ ಹೇಳೇ ಇಲ್ಲ, ರಿಸರ್ವ್ ಮಾಡಿದ್ರು.
Considered and conversion order has been issued prior to that.
That
now
is
he is seeking for the entire extent.
Now you are again saying 3.75 ಕೊಟ್ಟರೆ
ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ರೆ ಅಂದ್ರೆ ನಾವು ಪರಿಗಣಿಸ್ತೇವೆ ಅಂತ ಹೇಳಿದ್ದೇವೆ.
ಅರ್ಜಿ ಸಲ್ಲಿಸಿದೀವಿ, ಅದನ್ನೇ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಈಗ.
ಇಬ್ರು ಸರಿಯಾಗಿ ಹೇಳ್ತಾರೆ. You had applied for 4 acres. 3.75 acres has been converted from agriculture to residential.
That is in 2003.
Now, if you want residential to be changed to commercial, it is not conversion, it is change of land use.
Yes.
That will have to go to the development authority.
That is also done.
Adu separate. Only for 0.25 you will have to go for conversion.
Yes, my lords.
So ನೀವು 4 acres ಹಾಕಿದ್ರೆ ತಪ್ಪಾಗಿದೆ ಅಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲಿ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ನಾನು. That is at page number 32 E. 32 E, my lords.
Yes.
ಇಲ್ಲಿ ಒಂದನೇದು ಉಲ್ಲೇಖಿತ ಅಧಿಕೃತ ಜ್ಞಾಪನಾ ಪತ್ರ ಸೊ ಅಂಡ್ ಸೊ 31/3/2015 ರಲ್ಲಿ ಬಳ್ಳಾರಿ ತಾಲೂಕು ಕೊಳಗಲ್ಲು ಗ್ರಾಮದ ಸೊ ಅಂಡ್ ಸೊ ಹಾಗೂ 0.25 ಎಕರೆ ವಿಸ್ತೀರ್ಣ 4 ಎಕರೆ ಪೈಕಿ 0.25 ಎಕರೆ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ರಸ್ತೆಗಾಗಿ ಉಳಿಸಿ 3.75 ಎಕರೆಗೆ ಜಮೀನಿಗೆ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ನೀಡಲಾಗಿತ್ತು. ಸದರಿ ಆದೇಶ ನೀಡುವಾಗ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ 0.25 ಎಕರೆ ಪ್ರದೇಶದಲ್ಲಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಹಾದು ಹೋಗುತ್ತದೆ ಎಂದು ಅಧಿಸೂಚಿಸಿದ್ದರಿಂದ 0.25 ಎಕರೆ ಜಮೀನನ್ನು ತಮ್ಮ ಆದೇಶದ ರಸ್ತೆಗಾಗಿ ಕಾಯ್ದಿರಿಸಿ ಆದೇಶ ಮಂಡಿಸಲಾಗಿತ್ತು. ಆದರೆ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಪ್ರಾಧಿಕಾರವು ನಗರ ಪ್ರದೇಶದಲ್ಲಿ ಬರುವ ರಸ್ತೆಗಳನ್ನು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿಗೆ ಅಭಿವೃದ್ಧಿಪಡಿಸಲಾಗುವುದೆಂದು ಮತ್ತು ಅವುಗಳನ್ನು ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯಲ್ಲಿ ಮುಂದುವರಿಸಲು ಪತ್ರ ಸೊ ಅಂಡ್ ಸೊ ಇಲಾಖೆ ಬಳ್ಳಾರಿಯವರಿಗೆ ಬರೆದಿರುವ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಈಗಾಗಲೇ ಭೂ ಪರಿವರ್ತನೆ ಕೋರಿ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯ ಜೊತೆಗೆ ಲಗತ್ತಿಸಿದ ನಕಾಶೆಯಲ್ಲಿ ಭೂ ಪರಿವರ್ತನೆ ಕೋರಿರುವ ಪ್ರದೇಶಕ್ಕೆ ಬಳ್ಳಾರಿ ಹೊಸಪೇಟೆ ರಾಜ್ಯ ಹೆದ್ದಾರಿ ರೋಡ್ ನಿಂದ ರಸ್ತೆ ಇರುವುದನ್ನು ತೋರಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಹಾದು ಹೋಗುವುದು ಎಂಬ ಉದ್ದೇಶಕ್ಕಾಗಿ ರಸ್ತೆಗಾಗಿ ಕಾಯ್ದಿರಿಸಿದ 0.25 ಎಕರೆ ಜಮೀನನ್ನು ರಸ್ತೆ ಎಂದು ಕೈಬಿಟ್ಟು ಪೂರ್ಣ ವಿಸ್ತೀರ್ಣ ಅಂದರೆ 4 ಎಕರೆಗೆ ಭೂ ಪರಿವರ್ತನೆಗೆ ಆದೇಶ ಮಾಡಿ ಪರಿಷ್ಕೃತ ಆದೇಶ ನೀಡಬೇಕೆಂದು ಕೋರಿರುತ್ತೇನೆ.
ಅದೇ ಆಗಲ್ಲ, ಇಸ್ ಆಲ್ರೆಡಿ ಕನ್ವರ್ಟೆಡ್, ಮತ್ತೆ ಭೂ ಪರಿವರ್ತನೆ ಬರಲ್ಲ.
ಅಲ್ಲ, ನಾ 0.25 ಅಷ್ಟೇ ಕೇಳಿದೆ.
ಅಂದ್ರೆ 4 ಎಕರೆ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ಮಾಡಿ
ಅದೇ ಪರಿಷ್ಕೃತ ಅಂದ್ರೆ ಪರಿಷ್ಕೃತ ಮಾಡಿ
ಮಾಡಕ್ಕಾಗಲ್ಲ ಅದು.
ಅದನ್ನ
you have to make a separate application for 0.25.
My lord, I'll make a separate application for 0.25, let them consider.
The petitioner is before this court seeking for the following reliefs. The land measuring 4 acres in survey number 792/B/10 was owned by one M.R. Uday Kumar, son of Ramchandra Naidu, who had applied for conversion of the said land from agriculture to residential purposes in the year 2003. While order date 28/2003, an extent of 3.75 acres, 3 acres 75 cents, was converted from agriculture to non-agriculture residential purposes. However, 0.25 cents, 25 cents was reserved for widening of the national highway. The petitioner, having purchased the said property on 25/2009,
2013.
The said Uday Kumar sold the property to one Chandra Asa on 25/2009, and Chandra Asa had in turn sold the same to the petitioners on 19/8/2013.
Yes, my lords. 2013, my lords.
79 AB ಶುರು ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ನಾನು ನಾನ್ ಅಗ್ರಿಕಲ್ಚರ್ ಖರೀದಿ ಮಾಡಿದ್ದು ನಾನು.
3.75, 0.25?
ಇಲ್ಲ, ಎಂಟೈರ್ ಖರೀದಿ ಮಾಡಿದ್ದೇನೆ. ಅದನ್ನ those two numbers have been given. ಎರಡರ ಎಂಟೈರ್ ಖರೀದಿ ಮಾಡಿದ್ದೇನೆ.
25 cents ಬಚಾವಾಗಿದೆ ಅಷ್ಟೇ.
ಇಲ್ಲ.
Anything more? To the petitioner. The petitioner had applied on 31/3/2015 for conversion of the said land from residential to commercial purposes. Which was also granted, and 3 acres 75 cents, which had earlier been converted for residential purposes. Yengappa idu? How can you convert from residential to commercial?
My lord, earlier, my lord, agriculture to residential was converted. Now I want to use it for commercial.
This is a land coming under CDP.
My lords.
Development plan ಅಲ್ಲಿ ಇದೆ ತಾನೆ?
ಹೌದು.
But the development plan ಇದ್ದಾಗ there can't be a conversion.
But formally ನಾವು ಅಪ್ಲೈ ಮಾಡ್ಲೇಬೇಕಂತ ಹೇಳಿ, ಇಲ್ಲಂದ್ರೆ ಅದರ
It has to be only a change of land use, Mr. Bandi.
My lord, that's what I submitted, my lords. Change of land use ಗೆ ಕೊಟ್ಟಿರೋದು.
Annexure C ಏನಪ್ಪಾ? It's a OM. By Deputy Commissioner.
By Deputy Commissioner.
Deputy Commissioner could not have issued this.
They have converted it to residential to commercial.
Residential to commercial ಮಾಡಕ್ ಬರಲ್ಲ. Once it is under a development plan. ಹಿಂಗೆಲ್ಲ.
So far as earlier conversion, I had to seek clarification and make submission. But I will.
Earlier conversion is fine. The second conversion could not
That is
happen.
not.
Yes.
For commercial purposes. Thereafter, once again, the extent of 0.25 cents had not been converted, and in that background that the petitioner gave a representation stroke application on 6/11/2024 at Annexure E, stating that the highway having already been formed, the 25 cents were not required for the purpose of widening of the highway, and as such, the 25 cents could also be converted to commercial purposes. The said request came to be rejected by the endorsement dated 10/12/2024 at Annexure F on the ground that the same can be considered only if an application could be made for 3.75 acres, which had already been converted for residential purposes. And if an application is filed in relation thereto, the same would be considered. Having heard the learned counsels and having gone through the papers, there seems to be a lapse on part of the authorities concerned. Once an agricultural land had been converted to non-agriculture purposes, and the said land came under the development plan, the deputy commissioner stroke revenue authorities would become functus officio and could not exercise any revenue jurisdiction on the said land, and it is for the development authority to take action in relation thereto. The land having been converted for residential purposes and coming under the development plan, any particular change in the character of the said land is required to be done by the development authority by exercising powers under section 14 of the Karnataka Town and Country Planning Act for change of land use. No conversion can be granted by the deputy commissioner after the land comes within the purview, as regards land which comes within the development plan. In that view of the matter, the respondent number 1 is directed to look into this issue and issue appropriate directions to all the deputy commissioners not to exercise any jurisdiction as regards land which comes under the development authority's jurisdiction by virtue of it being included in a development plan. In the present matter, the land to an extent of 3 acres 75 guntas having been converted from agriculture to residential purposes.
75 cents.
This 75 cents having come converted for residential purpose and same coming within the purview of the development plan, the petitioner would be at liberty to make such application as is necessary in terms of section 14 of the Karnataka KTCP Act for change of land use, which should have to be considered by the concerned authority in accordance with law. Insofar as the remaining 25 cents are concerned, it is for the petitioner to make necessary application for conversion of that land from agriculture to non-agriculture purposes, which shall be considered by the deputy commissioner in terms of section 95, 95(5) and could you land revenue, Sriram, land revenue act. ಎಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಏನೋ ಡಿಲೀಟ್ ಮಾಡಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ? 1 to 4
and 7.
and 7, 5 and 6,
Lord, 5 and 6.
SDMC.
Alla,
Urban
urban
Development
V.
Authority.
Sharanabasava for R5
P. Sharanabasava for 5,
and municipal HDMC Gurudev Gachinmat R6.
Gurudev Gachinmat for respond number 6.
My lord, some miscreants are trying to encroach upon that land, my lord.
Interim order in no further encroachment.
It's at page 19, my lord.
Encroachment against whom?
That the position, it is in my possession, my lord. I'm writing representations, giving requisitions to so many authorities. Nobody is ready to
Police
opt
na
to it.
party madilla.
Yes, my
Police
lord.
na party madbekagiತ್ತು.
Madbekagiತ್ತು, my lord. I bow down.
Make them, then we'll direct it.
My lord, if interim order is granted, that at least status quo is maintained till the disposal.
Again, if you have made a complaint to the police and they have not considered it, then we can direct the police to give you.
I'll make a party, my lord.
Otherwise, these
Yes.
people cannot do that.
My lord, if there is at least one order that status quo should be maintained, I can take it to the authorities and give a police complaint.
Madam, you are asking, still you are at a very, to declare lawful owner. You want a declaration of lawful ownership from this court?
Mandamus,
Mandamus
my-
declaring ownership. Mandamus directing fourth respondent to declare you as lawful owner.
my lord, nobody has owed up to it, my lord. That's saying we have acquired. If anybody owes up to it, we can challenge it, my lord. But we have written, even the secretary, principal secretaries have written representations. But that is not, no response is given to it, my lord.
What are the facts?
Facts are, my lord. Annexure A, section 10(1) notification was issued. Thereafter, a layout was made for the remaining land, not the vacant land, the remaining land, and 6,000, what was acquired, 6,800 was made a road. Thereafter, we applied for exemption. Annexure B, my lord, is the order of exemption, where they say exemption is given to 6,819 meters, square meters. But this is not recorded anywhere, my lord. We've continuously been giving representation. Recently, we have given one representation to revise the layout and make a 30 feet road, my lord. What has happened is the other layouts are 30 feet. Suddenly, when it comes to my land, they've made it 100 feet for no good reason, which ends in dead end. It does not connect anywhere also, my lord. This exemption is not considered, and ULC was repealed thereafter, so no appropriate authority to approach, my lord. We have written letters, given representations to DC and HDMC. Each one is saying it does not come under our jurisdiction.
Madam, the way that you have drafted it and the way you are going about it will not yield any
I apologize, my lord.
swan to your client. Please get some proper advice and do proper job out of this. This
Please,
is
my
not, you give representation Allah. You will have to do it in accordance with law.
Yes, my lord.
Hinge 26 ಜನಕ್ಕೆ letter ಬರೆದ್ರೆ ಏನಾಗಲ್ಲ. Under the ULC, what is the procedure? We can't guide you. You
Please,
will
my
have to
lord.
get that. So note, 2 sets, relist on 13th.
Please, my lord.
14, Srivatsa Hegde.
Lord, yes, Mr. Hegde.
Third respondent denies grant of building permission, citing the reservation of my plot as a road in the master plan. Covered by my lord's judgment, neither acquired, the layout has been approved by the second respondent, development charges have been taken.
Entire land comes within the,
No, I am owner of one particular plot, my lord, that's all.
only one portion of it is marked.
Yes.
There is a sketch.
Now, the master plan is not made available to me, my lord, but the endorsement says,
Master plan is available for everybody, Mr. Hegde. ನಿಮ್ಗೆ ಸ್ಪೆಷಲ್ ಆಗಿ ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ. ಬೇರೆ
now the
Layout
annexure
plan.
A1,
even illi, where is the highway?
Nim survey number. ಇಲ್ಲಿದ್ರೆ
No, this is a Kamijast Patrika prepared by the Tehsildar, my lord, of the entire survey number 371/4.
Yes, where is the highway coming now?
My lord.
Where is the highway? Where is the sketch of your property and highway road reservation elli there?
Mine is plot number 16, my lord. The endorsement at A1 says, my lord, that page number 11, issued by second respondent. 371 ಬೀರ ವಿನ್ಯಾಸ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆಗೊಂಡ ಗೋಕಾಕ್ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ರಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಲಾದ 12 ಮೀಟರ್ ಅಗಲದ ಪ್ರಸ್ತಾವಿತ ರಸ್ತೆಯು ತಮ್ಮ ನಿವೇಶನದ ಅಂದರೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 16ರಲ್ಲಿ ಹಾಯ್ದು ಹೋಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಮುಂದುವರೆದು ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆಗೊಂಡ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಪ್ರಸ್ತಾಪಿಸಿರುವ ರಸ್ತೆಗಳನ್ನು ಯಥಾಸ್ಥಿತಿಯಲ್ಲಿ ಕಾಯ್ದಿರಿಸುವುದು ಅವಶ್ಯವಿರುವುದರಿಂದ ಈ ಹಿಂದೆ ಸಲ್ಲಿಸಿರುವ ತಮ್ಮ ಕಟ್ಟಡ ಪರವಾನಗಿ ಕುರಿತು ತಾಂತ್ರಿಕ ಅಭಿಪ್ರಾಯ ನೀಡುವ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ.
Master plan. You can get a plan sanction for the balance of the land, not for the entire land.
Now, my lord, the thing is, there is no proposal to acquire this land.
Under
Yes.
the KTCP Act, when it is reserved for a road, they can't deny you the plan. But if the entire road is demarcated for the plan, for the road, then they can deny but they will have to acquire.
Yes, my lord.
So ಇವಾಗ ಎಂಟೈರ್ ಪಾರ್ಟ್ ಅಂತ ಅದಕ್ಕೆ
Only part.
ಎಷ್ಟು ಪಾರ್ಟ್?
ಎಷ್ಟು ಪಾರ್ಟ್ ಅನ್ನೋದು my lord, it's not coming forth.
If it is only part, you can apply for the balance. With the full FIR, we'll direct them to issue.
No, because I am only owner of plot number 16, I made an application, my lord, and the endorsement is restricted only to my. Yes.
Where is that road going?
Yeah.
If it is on 16, what is the plot measurement?
One gunta, my lord.
1 gunta, 1034, 1029.
1089 square feet, yes.
Correct again. If the entire property is shown as a road, then we'll have to direct them to acquire.
If they propose to acquire, my lord, I am not asking for any direction to acquire, but then they simply say, ಯಥಾಸ್ಥಿತಿಯಲ್ಲಿ ಕಾಯ್ದಿರಿಸುವುದು ಅವಶ್ಯವಿರುವುದರಿಂದ.
Then if you put up construction, you won't be eligible for compensation later when they acquire.
Yeah, but the layout has been approved by the very same authority, my lord.
So what if it is under CDP?
Now, as far as the building bylaws goes,
then you will have to challenge the CDP.
Now, my lord, third respondent.
Notice or R1. Point number 1. 2 arrow.
2, I have no idea. 3, Srinand Pachapure appears, my lord,
Member
and I have
Secretary,
already.
Town Planning Authority, Gokak.
members.
Srinand Pachapure for respond number 3. Yarri, Town Planning Authority, Gokak. Gokak
CMC ನೀವು ಅದಿರ ಅಂದ್ರೆ ಅದಕ್ಕೆ
R3 only, my lord.
R2 arrow.
R2 ಯಾರು ಅಂತ.
Issue notice to respond number 2, returnable by 13th March. Counsel for the petitioner is also permitted to take out hand summons on respond number 2 as will serve on the standing counsel for respond number 2, if any.
15 P.N. Osmane.
ADB passed award taking into account the Kharab land of petitioners and along with other lands, my lord. From award is balled in the year 2022 till date payment is being not made, my lord, awarded amount.
ಇದಕ್ಕೆಲ್ಲ ಇಲ್ಲಿ ಯಾಕೆ ಬರ್ತೀರಾ? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕ್ಬೇಕು.
Award being passed, my lord.
ಅಲ್ಲಿ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಗತ್ತೆ. ಇಲ್ಲಿ what do we do?
General award is passed by KADB, my lord.
Yes.
Now they have issued a notice that to come and collect the amount, my lord. As per the request, I have submitted all the documents, my lord. Till date, but they are the one or the other, my lord, postponing payment, my lord.
Payment if it is so. ನೀವೇನ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಹೋಗಿಲ್ಲ?
No enhancement, my lord. Only general
apportionment issue ಇಲ್ಲ.
ಇಲ್ಲ, no issues.
Right. KID.
State. SLO.
ಅಲ್ಲ state only.
SLO is giving the money, not KIDB. Mr. ಅತ್ತಿ ಅದಕ್ಕೆ ಹಿಂದೆ ಹೋಗಿ ಕೂತ್ಬಿಟ್ರು. ಕಾಣಿಸ್ಕೊಂಡು ಅದೇ ಬೇಡ ಅಂತ. ಯಾರು ದುಡ್ಡು ಕೊಡೋದು? ಅವರಾ ನೀವ?
SLO is KIDB.
SLO
KIDB.
KIDB SLO.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? Why are these petitions required to come before this court?
My lord has rightly directed them to file an execution petition.
Yes. ನಿಮ್ಗೇನು ರೈಟ್ ಡೈರೆಕ್ಷನ್? ನಿಮ್ಗೇನು ಡೈರೆಕ್ಷನ್ ಲೆಫ್ಟ್? And AG accepts notice for respond number 1. Shri P.N. Athi is directed to accept notice for respond number 2 to 4. The submission of the counsel for the petitioner is that a general award has already been passed. However, despite several requests, the compensation amount has not been released in favor of the petitioner land loser. In that view of the matter, respondent number 1 to 4 are directed to file their respective affidavits indicating as to why compensation amounts have not been released to the petitioner and who is responsible.
On
Had been
30th.
issued on 31/2024. Respond number 1 to also place on respond number 1 alla.
ಅಲ್ಲ, 2 ಅಥವಾ 3.
Being of the considered opinion that the state of Karnataka, represented by the Principal Secretary, Commerce and Industries Department, is also required to be brought on record since the KDB comes under the supervisory jurisdiction of the Commerce and Industries Department. The state of Karnataka, represented by the Principal Secretary, Department of Commerce and Industries, is brought on record as respond number 5. Learned AGA is directed to accept notice for respond number 5. Respond number 5 to file an affidavit as regards amounts and the time taken for the disbursal thereof. Since in the present matter, in a final notification having passed on, issued on 4/10/2012, and award being passed on 31/3/2022 after a lapse of 10 years, compensation has not been paid till date.
This award is only in respect of Kharab land, my lord.
ಯಾವುದೇ ಆದ್ರೂ ಅಷ್ಟೇ 12 ವರ್ಷ ಏನಿದೆ. Relist on 24th.
Respond authority is Dharwad. Respond authority is Dharwad.
ಎಲ್ಲ ಹುಡುಕ್ಬೇಡಿ, ಅತ್ತಿಯವ್ರು ನಿಮ್ ಕಿವಿಯಲ್ಲಿ ಹೇಳೋದು ಬೇಡ ಅದು. He is trying, find no fault, you are trying to support your officers. But ನಿಮ್ಮ officers ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಮಿಸ್ಟರ್?
No, I am not supporting Mala. That matter can be disposed with a time bound direction.
ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ಏನು ಆಗಲ್ಲಪ್ಪ ಅದು.
No.
ಅದಕ್ಕೆ ಒಂದು ಸಿಸ್ಟಮ್ ಇದು ಮಾಡಬೇಕು, ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಹೋಗ್ಬೇಕು.
I will instruct them.
ಎಷ್ಟು ಮ್ಯಾಟರ್ ಬರ್ತಾ ಇದೆ, ವಿ ಹ್ಯಾವ್ ಸೆಂಟ್ ಎವ್ರಿಥಿಂಗ್ ಟು ಎಕ್ಸಿಕ್ಯೂಷನ್, ಬಟ್ ಹಿಂಗೆ ಬರ್ತಾನೆ ಇದಾವೆ. 10 ವರ್ಷದಿಂದ ಪೇಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ
I will ask them to make a payment.
Not only in this, what is the procedure? Why is it not being paid for land losers? New land,
Actually, they have
in the common dialogue, automatic vesting without any further ಇದು ಅದೆಲ್ಲ ಹೇಳ್ತೀರಾ, ಆಟೋಮ್ಯಾಟಿಕ್ ಪೇಮೆಂಟ್ ಯಾಕೆ ಹೇಳಲ್ಲ? Should have automatic payment then.
Yes, yes. They are entitled. They are entitled.
ನೀವು ಲ್ಯಾಂಡ್ ತಗೊಂಡು ಅದ್ರ ಮೇಲೆ ಬಿಸ್ನೆಸ್ ಬೇರೆ ಮಾಡಿ ಯಾರಿಗೂ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿ ಅವ್ರ ಹತ್ರ ದುಡ್ಡು ತಗೊಂಡು 20% ಕಮಿಷನ್ ಬೇರೆ ತಗೊಂತೀರಾ. Even a real estate agent doesn't get 20% commission. ಅವ್ರು 2%, ನೀವು 20%. ಆಮೇಲೆ ನಾಟ್ ಫಾರ್ ಪ್ರಾಫಿಟ್ ಅನ್ನೋದು.
No profit and no loss.
20% ಎಲ್ಲೋಯ್ತು? See, if you misuse the power, then sometime it is going to come and
My lord is right in that matter.
hit you.
But they, according to this.
When is
petition,
the
their-
question?
Their prayer is that there is no any other alternative
ಕೊಡಿಯವ್ರೆ.
prayer.
ದುಡ್ಡು
That's why I am
ಕೊಡಿ.
requesting this honorable court, my lord. Kindly dispose
File
of
an
the matter
affidavit,
with
let
a
us see.
time-bound direction.
File an affidavit.
16.
Let us see what is the system being used and implemented by the authority.
The person who has passed this award, he is in custody. He is in custody. That's what I'm telling.
ಏನಪ್ಪ. Affidavit act
Lord, it may be taken on 25th.
25th.
Please.
16 BV Somapur.
Typed copy of sale deed with some.
Yes, I have produced the typed copy and also written statement and translated copy. I also given a copy of that to the other side.
When did you file the typed copy?
ನಿನ್ನೆ ಹಾಕಿದ್ರಿ.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Yesterday you have filed that.
ಬಂದಿಲ್ಲ. ಪಾಸು ಕೊಡಿ, ಅದೇನು ಕಾಪಿ ಇದೆ ಕೊಡಿ.
Principal Secretary Department.
This is RSA.
In the written statement also, we have taken that contention that in the year 1978 itself, partition has been taken place between the fathers. Written statement. In para number 10 of the written statement, detail ಇದನ್ನ ತಗೊಂಡಿದೆ. 1978 ದೊಳಗೆ ಇದು ಅದು.
This, then partition deed has already been considered in para 14, 15, 16, 17.
Yes. Because the document was not produced before the trial court, my lord.
Yes, and you sought to produce it before
Yes.
this court.
Yes.
And this court has imposed costs on you
Yes, because of that
for having abused the process of court by trying to mislead by saying that it is being stamped as on the date of the execution of the document when it was found that the stamping was done subsequently.
Stamp duty has been paid subsequently. Stamp duty has been paid
ಅವತ್ತು
subsequently.
argument ಬೇರೆ ಇದೆ ಇಲ್ಲಿ.
But only
ಇವತ್ತು ಬೇರೆ ಇದೆ.
ಇಲ್ಲ ಅವತ್ತನೇ stamp duty has been.
Then what is the ground for review that you want? What is the ground for review that you are agitating?
That is because of that document is material document in this case to show that there was an earlier partition between the parties. And also on the basis of that document, names of the parties have been mutated in the records. And after their death, the death of the fathers, their sons have been, again they have partitioned in the properties. ಮೂರ್ನಾಲ್ಕು ಸಲ ಮತ್ತೆ mutation ಆಗಿದೆ. They have not challenged the mutations also. That is the case because of that Uma Pandey case in their lordships have observed. It is a question of law. That is
This honorable court was pleased to dismiss the RSA. There is no question of law. That is, the trial court and first court, they have dismissed they have held that no document has been produced to show that that is the case.
What is the ground? This has been considered already. The production of this document cannot be done until we have already given a finding. Review again ground is there. Right or wrong, that's different.
In that case, in the RSA, this honorable court has held that there was no ground, there is no question of law in because of that the document which I have produced at later stage at this before this honorable court, it amounts to that question of law. In the Amma Pandey case, in para 20 of the Amma Pandey case, my lord, the lordships have observed.
I don't find any ground for review, Mr. Somapur.
In our view, the following substantial questions of law arise in the second appeal within the meaning of section 100 of the decision. Second one, sir. What is the true nature of Uma Pandey judgments? I have produced that Uma Pandey.
Uma Pandey.
Please.
Para?
Para 20, my lord. Para 20. The following substantial questions of law arise in the second appeal within the meaning of section 100 of the code of for its decision. Otherwise, second one, what is the true nature of exhibit A? Can it be termed as partition deed or a document recognizing a fact of partition already effected between the parties in relation to the suit land? It is the question of law.
Your contention is it's a partition deed. Where's the dispute about it?
Because that document was not taken into consideration.
There is no dispute between you. New over partition and Theodatu. Mr. K.L. Patil saying it's not a partition, it's a recordal partition. Our recordal partition, no new recordal partition or partition and Theodatu. That's the dispute.
Yes.
You are claiming it's partition. He says that it cannot be relied upon. It's not been produced at all. It was never produced before the original court or the first.
In the original court, we have not produced that document.
Only in the second appeal, you seek to produce the fact.
We have produced that document before this honorable court in the second appeal. That is the case. That is in that case.
Then you turn every second appeal into. That will go beyond.
Because in that case, we have taken the contention in the written statement and also we have let the evidence in that respect. That on 23/11/1978 itself, the partition was taken place.
You have observed already.
But no document,
any evidence.
because the lower court and first appellate court have held that no document has been produced in that respect.
And you can't produce it in a second appeal.
Therefore, that document was traced out later on.
Yes.
And we have produced that document before this honorable court.
The petitioner is before this court seeking for the following.
That is this
relief. Shri B.V. Somapur, learned counsel,
and
for the petitioner who had appeared for the appellants in RSA number 100424 of 2019, submit that the order passed therein on 18th April 2022 is required to be reviewed. His submission is that even an aspect as regards whether a document termed as a partition deed is a document recognizing the factum of partition already effected between the parties in relation to the said in relation to the suit land is a question of law as held by the Honorable Apex Court in Civil Appeal number 3657 of 2018, Uma Pandey and others versus Munna Pandey and others. And as such, he submits that since a partition deed had been produced before this court by filing an application under Rule 27 of Order 41 of the Code of Civil Procedure, this court ought to have taken the said document on record and examined the said document in a second appeal. Yes, Mr. Patil, what is your submission?
No, that has been considered. The document itself has been
The
considered by
KL
this
Patil
honorable court.
learned counsel appearing for the respondents would submit that the aspect of whether the partition deed could be produced in evidence, as evidence in a second appeal, has been considered by this court in
And its,
detail
and its validity regarding registration.
in para 12 to 17 thereof. And as such, there is no ground for review which has been made out. Heard so and so peruse papers.
I am
The
also,
condition of Sri B.V. Somapur, learned counsel for the review petitioner, is that though the petitioner had not produced,
I am also relying on the another decision of the apex court. Para 125.
129.5.
125, sir.
125. Sri B.V. Somapur also relies upon the decision of the Honorable Apex Court in 2029 SEC 1, Vinita Sharma versus Rakesh Sharma and others, more particularly para 125 thereof, which is reproduced hereunder for easy reference. Placing reliance on the same, he submits that the interpretation of the document as to whether it's a family settlement or otherwise is also a question of law. Heard so and so. Submission of Sri B.V. Somapur essentially is as regards the appreciation of a document, namely a partition deed, which was sought to be produced before this court in a second appeal. The Court of Original Jurisdiction, as also the First Appellate Court, having come to a conclusion that there was no document which has been produced by the defendants therein, who are the appellants in RSA number 100424 of 2019, had rejected their contention. It is after a judgment was passed by the original court, confirmed by the First Appellate Court, that during the course of hearing of the second appeal in the year 2022, that for the first time that the appellant sought to produce a document titled as a partition deed. Insofar as the production of the said document is concerned, the same has been dealt with extensively in para 12 to 18 of the said order, and a cost of rupees 3,000 has also been imposed on the petitioners. The judgment in Uma Pandey's case, which has been relied upon by Mr. Somapur while arguing the present review petition, in my considered opinion, would not be applicable to the present facts and circumstances, inasmuch as that was a case where Exhibit A termed partition deed had been produced before the original court, and the interpretation thereof was considered by the original court as also by the First Appellate Court. That was not a case where for the first time a document was produced in a second appeal.
Second appeal, since it was not traced out at the time of
Allegedly on the ground that it was not traced out earlier. Insofar as the decision in Vinita Sharma's case, that also the reference made to para 125 is as regards the interpretation of a document styled as a family settlement or a family arrangement. Even in that case, the said document had been produced in the court of original jurisdiction and not in a second appeal. Having come to a conclusion that in the second appeal, it is only a question of law which could be agitated and no fresh evidence could be laid in a second appeal on the alleged ground that the document was not available, this court, also taking into account that the document was stamped just before production before this court and the contention was raised that the document had been adequately stamped at the time of the execution, had imposed cost of rupees 3,000.
And not registered. It was stamped but not registered.
It was not, it was stamped.
Not stamping a 3,000. Not registered is a fact that nobody has done anything. Had imposed a cost of rupees 3,000. In that view of the matter, this aspect of consideration of the partition deed, having been all production of partition deed, having been already dealt with in detail, there is no error apparent on the face of the record which has been brought out by the counsel for the petitioner seeking for requiring review of the said order. The review petition stands.
The document is executed in the year 1978 itself, but a stamp duty has been paid later on.
That we have already observed. Again, ಮತ್ತೆ ಇನ್ನೊಂದು ಸತಿ ಕಾಸ್ಟ್ ಏನಕ್ಕೆ?
ಅದ್ರಾಗ ಇದು
ಎರಡು ಸತಿ ಕಾಸ್ಟ್ ಬೇಡ ಅಂತ ಸುಮ್ಮನೆ ಇದೀವಿ.
PL party.
Respondent 4%. Yes. Respondent number 4.
4 to 7.
So 7. Yes, please.
The brief facts is that, my lord, this dispute concerned to regrant of the village office in abolition.
Pertains to?
Regrant of the land.
Regrant. Yes.
Service inam.
Yes, please.
What has happened is that, my lord, in the year 1972, there was a regrant order made by the Tahsildar on the application filed by the parties. And that was challenged subsequently. And in the year 1987, my lord.
What is this service? Valikar andre ಏನು? What kind of service is that?
Valikar.
ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ?
Valikar ಅಂದ್ರೆ village ನಲ್ಲಿ ಪಾಟೀಲ್ ಕೆಳಗೆ as peons they were working.
Okay.
They were called as Valikars.
Sanadi service Valikar ಅಂತ ಹೇಳಿದಿರಾ?
Sanadi and Valikar ಅವರು.
ಏನ್ ಅರ್ಥ ಅಂದ್ರೆ?
ಸೇತ್ ಸಂಧಿ. ಸೇತ್ ಸಂಧಿನೂ ಅಂತಾರೆ ಅವ್ರಿಗೆ.
ಈ ವರ್ಡ್ ನಮ್ಗೆ ಅಷ್ಟು ಫೆಮಿಲಿಯರ್ ಇಲ್ಲ, ಅದಕ್ಕೆ ಇಲ್ಲಿ ಮೀನಿಂಗ್ ಏನು?
It is there in this Bombay Karnataka area. ಸೇತ್ ಸಂಧಿ.
ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು? What is their role?
ವಿಲೇಜ್ ನಲ್ಲಿ ಈ ಮೊದಲ ವಿಲೇಜ್ ಆಫೀಸಸ್ ವೇರ್ ವಿತ್ ಪಾಟೀಲ್ಸ್. ಅವ್ರ ರೆವೆನ್ಯೂ ಇದರ ರೆವೆನ್ಯೂ ಅಂಡ್ powers of police powers are also there. They used to be assistant to them, class 4 assistants. They used to move around this village, bring the information, give them, they used to write, and all this. Because of that service, they were granted with some of the properties.
Yes.
Like inam to the patils, like inam to the village office, which were Valikars and others.
Yes.
In this case, my lord, if your lordship is pleased to peruse without taking much time of this court, because only what I request your lordship is to peruse one judgment of the district court. Second, third round of litigation. Because I restrict my claim. What happened is earlier it was granted, it was challenged, and then it was challenged before this honorable court also in the writ petition. In the writ, because that was challenged before the deputy commissioner earlier. Thereafter, in the writ petition in the year 1995, this honorable court come to the conclusion that appeal does not lie to the deputy commissioner, appeal lies to the district judge. So the matter was sent to district judge then. And district judge again dealt with that. Initially rejected the appeal, and thereafter review was filed. Review was also rejected. Then they approached this honorable court. This honorable court, by condoning the delay, again sent it back to the deputy commissioner to consider that. Thereafter, in the review petition, the deputy commissioner, the district judge dealt with it and held that the order passed by the Tahsildar for regrant was against the dead persons, which was not brought to the notice of the Tahsildar, nobody else. And that's why the order was set aside and sent the matter back to the Tahsildar for consideration. And that order also challenged before this honorable court, and this honorable court held that the order passed by the district judge where in review petition is correct and the only Tahsildar has to deal with it. Thereafter, Tahsildar considered my application and passed order in my favor.
Yes.
And that order has been challenged, instead of challenging that order with the respondents herein before the district judge, they challenged it before the assistant commissioner in 136 proceedings. Land Revenue Act 136, RTS proceedings. The assistant commissioner set aside the order of the Tahsildar of regrant. Thereafter, this present petitioners, writ petitioners approached the deputy commissioner. Deputy commissioner confirmed the order of the assistant commissioner. And being agreed by, I am before this honorable court. Only short point to be considered is the order passed by the Tahsildar of regrant, impugned order passed by the Tahsildar for regrant, whether appeal lies to assistant commissioner and deputy commissioner in their 136 proceedings, or they ought to approach the district court as held earlier also. Only on that point, if this order is set aside and they are referred to district judge for filing appeal.
Is to the extent of land though?
Extent of land is nearly
Total 35 acres.
35 acres.
Out of which
35.
4 acres, 22 guntas.
ಇಲ್ಲ 35 acres.
ಅದ್ರೊಳಗೆ ಇಷ್ಟೇ ಇದೆ.
ಇವಾಗ ನಿಮ್ಮಿಬ್ಬರದು ಜಗಳ ಇರೋದು 4 acres 22.
ಇಲ್ಲ ಇಲ್ಲ 30 acres 23 gunters.
Total 35.
And the legal heirs are went on adding.
35 acres.
35 acres.
You already have now around 30 people.
Yes.
How?
20, around 40 people.
If only my request is,
ಒಬ್ಬೊಬ್ಬರಿಗೆ ಬಂದ್ರೆ 1000 square feet, 2000, 3000 square feet ಬರುತ್ತೆ.
Not here. If the court permit minutes, may I minutes pass on
Third
minutes?
generation is already here,
How?
fourth generation ಬರುತ್ತೆ. Why
But
don't
sir,
you
just-
sort it out?
Minutes have no objection for remand minutes. However, minutes for a moment, minutes, amicable minutes. We allowed to pass on the synopsis minutes.
Synopsis ಆಮೇಲೆ ನೋಡೋಣ.
ಇಲ್ಲ ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲ.
ಇಲ್ಲ, I will.
Is there a possibility of it being referred to mediation and being sorted out?
What senior says, minutes.
ನೀವೇನ್ ಹೇಳ್ತೀರಿ?
I can put a word to my parties minutes.
See, there already is 40 people here.
I can put a word to my parties minutes. Yeah.
For 4 acres, how much will you
ಇಲ್ಲ 4 acres ಇಲ್ಲ 30 acres 35 acres out gunta.
35 acres. 35 acres.
35
Total
acres.
35 acres.
ಇವಾಗ
ಇಲ್ಲ, I can minutes
ಅರ್ಧ
we will
ಎಕರೆ
put a word.
ಬರುತ್ತೆ. If all of you have to share, maybe some will get half acre, somebody will get 2 acres.
Minutes, what happens minutes, there can be only 2 partitions minutes, because the propositors is 1 minute, subject to whatever minutes offer they give minutes, I can put my word to my parties, I can convince them.
None of you are going to be able to use it.
How?
And
Even
sell-
minutes now, minutes, 1 month ago minutes, even a criminal complaints are also filed between the parties. It would be better minutes. ಇವ್ರು ಅವ್ರ ಮೇಲೆ ಆಗಿದ್ದಾರೆ, ಅವ್ರು ಇವ್ರ ಮೇಲೆ ಆಗಿದೆ, and admittedly they belong to.
ಪಕ್ಕದ ಕೋರ್ಟ್ಗೆ ಹೋಗೋದು ಬೇಡ.
I can minutes put a word minutes to my party.
Total 2ಗೂ ಬೇಡ, ಸಾರಿ 3ಗೂ ಬೇಡ, 6ಗೂ ಬೇಡ,
8ಗೂ ಬೇಡ.
8ಗೂ ಬೇಡ. 8 ಆದ್ರೆ ರಿವಿಷನ್ ಬೇಲು.
I will.
Bound to happen like this if
How?
they keep fighting.
In 1973 in the litigation ಆಗ್ತಾ ಇದೆ, I can minutes we can.
KL Patil ಅವರು
Put a
ಇಲ್ಲಿ ಬಂದ್ರು,
bill.
ಅಲ್ಲಿ ಹೋದ್ರು, ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ, ಇಲ್ಲಿಂದ ಇನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹತ್ತಿಲ್ಲ.
ಇಲ್ಲ.
That is also bound to happen.
ಹೈಕೋರ್ಟ್ದಲ್ಲಿ 4th round of litigation here itself.
ಇಲ್ಲೇ
ಇಲ್ಲೇ
ಇನ್ನ ಒಂದ್ 2 ಸತಿ ಅಲ್ಲಿ ಹೋಗಿ ಬಂದ್ರೆ,
ಇವಾಗ ಮತ್ತೆ ರಿಮಾಂಡ್ ಮಿಲೋಡ್ಸ್.
if we can settle this,
I will.
not as strictly that this is a partition, that is a partition. If everybody gets something, everybody can be happy and go on.
How?
Otherwise, by the time it gets settled, people will get only 10,000 square feet, 5,000 square feet.
Already there are, as per my calculation, there are 84 shareholders now.
80. ನಾವು 40ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ.
ಹಿಡ್ಕೊಂಡ್ರೆ
40ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ನೀವು 84 ಆಲ್ರೆಡಿ ಹೋಗ್ಬಿಟ್ರೆ
ನಮ್ ಕಡೆ ಅವರು ಒಂದಿಷ್ಟು ಇದ್ದಾರೆ.
20,000 square feet ಹೊಡೆದೋಯ್ತು. ಸಾರಿ 15,000 square feet ಹೊಡೆದೋಯ್ತು. It doesn't make sense. Nobody will get any benefit out of this. And adinna meets and bounds ಮಾಡಿ road gate ಮಾಡಿದ್ರೆ ಹೋಯ್ತು ಅದನ್ನು.
ಅದು
ಏನೂ ಸಿಗಲ್ಲ. Nobody will benefit from this.
and at the end of the day, it is an inam land given by the government. It is not.
ಯಾವುದಿದ್ರೇನು some benefit to the people who are living. Unless you want to keep it as a bank for the next third generation from now and give them 5 rupees. That's your choice.
We can put a cut.
This doesn't look like.
Again remand again. Bad.
It doesn't make any sense. Remand ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು 4 ವರ್ಷ. ಅಷ್ಟರಲ್ಲಿ ಇಲ್ಲಿ ಆಲ್ರೆಡಿ ಇದ್ದಾರೆ 62, 74.
ಸಿಕ್ಸ್ಟಿ-ಟೂ 72 ಆಗಿದೆ. 2015 ರಿಟ್ ಪಿಟಿಷನ್
50, huh?
69 plus 10. Not in their interest. Let them get something during their lifetime. ಇಲ್ಲೂ ಇದ್ದಾರೆ, ನಿಮ್ಮ ಪಾರ್ಟಿಗಳು ಇದ್ದಾರೆ.
I will minutes.
After having heard the matter for some time, I have the considered opinion that this is a fit case for amicable resolution of the matter.
Mediation.
And as such, the said proposal was put up across to both the councils by this court, who have expressed that they will discuss with their respective clients and make their submission as to whether the matter could be referred to, whether the matter could be settled by themselves or the matter could be referred to mediation. Released on 24th.
Yes. ಒಂದ್ ದಿವಸದಾಗ ಆಗೋದು ಇಷ್ಟೆಲ್ಲ ಬಿಡದಾಡ್ತಿರೋದು ಮಾತಾಡೋಣ.
ಯಾರು ಮೀಡಿಯೇಟರ್ ಅಂತಾನೆ ಹೇಳಿ ನೀವೇ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಒಳ್ಳೇದು. ಇಲ್ಲ ಮೀಡಿಯೇಟರ್ ಅಂತ ಹೇಳಿದ್ರು ಯಾರು ಹೇಳಿ.
ಬಾಡಿಕಾಯಿ ಮೇ ಬಿ ಬೆಟರ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಸಮ್ ಇನಾಮ್ ಅಂಡ್ ರಿಗ್ರಾಂಟ್.
ಯಾರು
ಬಾಡಿಕಾಯಿ
ರವಿ ಬಾಳಿಕೆ ಹಿಂದೆನೇ ಇದ್ದಾರೆ.
ಮೀಡಿಯೇಷನ್ ಇನಾಮ್
35 acres, there are already 84 claimants.
35
let it go further more. ಯಾರಿಗೂ ಏನೂ ಸಿಗಲ್ಲ.
Hopefully, my lords, if they are members of the same family, same community, same family. Family then segregate ಮಾಡ್ಬೋದು. Division.
Some ego issue has happened sometime. Monday ನೋಡಿ.
Monday before mediation.
ಅಲ್ಲ ಇವಾಗಲೇ ರೆಫರ್ ಮಾಡೋಣ ಮೀಡಿಯೇಷನ್ಗೆ.
ಮಂಡೇ ಇಲ್ಲಿ ಹೇಳಿ and then can
ಕೇಳಿ ಹೇಳ್ತೀರಾ ಇಲ್ಲ
ಮಾಡ್ಬಿಡ್ಬೋದು.
ರೆಫರ್ ಮಾಡಿ.
Please.
18 Shekhar Gowda, Nagmuri.
Filed an IA, my lords, for recalling the order dated 7/12/22.
7/12.
Yes.
Office objection have remained comply ಮಾಡಿದೀರಾ?
Yes, my lords.
ಎಲ್ಲಿದೆಯಪ್ಪ ರಿಪೋರ್ಟ್? When did you comply? ಅದಾದ್ಮೇಲೂ ಬಂದಿಲ್ವಲ್ರಿ ನೀವು? Has not been complied.
2 days time.
Pending consideration of IA 1 of 2023, the counsel for the petitioner is permitted to comply with the office objection. Released on
Monday, my lords.
20th, sorry, 24th.
Please publish.
18 Sunil Desai, PR.
With your lordship's kind leave, my lords, I beg to appear for respondent number 2 to 7, my lords.
2 to 7. The state has chosen not to be represented.
Please, my lords. My lords, we have placed on record 2 judgments, which my lords.
Who is appearing for the petitioner, Mr. Desai?
Sunil Desai.
My lords, I just want to bring to the notice of this court one small fact, my lords.
Yes.
My lords, this is an order passed under 34B3 of the Karnataka Industrial Area Development Act. That is a resumption of plot lands.
Yes.
Admittedly, my lords, a B2 notice has not been given to him. And on the very said procedural flaw, there have been earlier judgments of this honorable court remanding the matter for fresh consideration. We have
Yes.
placed 2 such orders for the consideration of this court in similarly placed cases by coordinate bench. Lords, may please set aside the impugned order herein and remand the matter back for fresh consideration in a time-bound period, my lords. We'll do it in accordance with law.
B1 notification, notice has to be issued.
B2 notice has to be given.
B2 na?
B2.
KD Act.
My lords, I'll read B1, my lords.
Yes.
Where the board is of the opinion that an allotee of any premises or part thereof or residential tenement in an industrial area or industrial estate has violated any of the terms or conditions of allotment or holds it without any authority, it may, without prejudice to section 25, give notice to such allotee and banks or financial institution in whose favor the board has permitted the mortgage or lease.
B1
B1 ಕೊಟ್ಟಿದ್ದೇವೆ, B2 ಕೊಟ್ಟಿಲ್ಲ.
You straight went to B3.
We have gone straight to B3. And similar, this was unfortunately, my lords, it was due to a perceived misconception amongst the board officials where they thought that it is not required as such. That is why a batch of such orders have been issued.
2020 ಯಾಕೆ ಹಂಗ್ ಮಾಡಿದ್ರು? Third, petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that though the petitioner has been issued notice under subsection 1 of section 34B, the reply thereto having been furnished, necessary notice under subsection 2 of section 34B has not been issued, but order has been passed under subsection 3 of section 34B. This court has in numerous matters held that without issuance of show cause notice under subsection 2 of section 34B, orders cannot be passed by the executive officer under section 34B, subsection 3 of 34B. In that view of the matter, I pass the following order. Writ petitions allowed, certiorari is issued, so and so. At annexure
M.
M alla.
One.
M
and N ante ಹೇಳ್ತಾರೆ.
M will continue.
Yes.
Mr. Patil?
Please, my lords.
M page number N.
101 is the M.
M is 101, my lords. 103 is M. Only M has to go, my lords.
M will continue.
Yes, my lord. That is the notice pursuant to which
N will have to go.
It may be observed, my lords, that
The certiorari is issued. The order dated 17/12/2020 at annexure N issued by respondent number 6 is quashed. It is made clear that the notice at annexure M shall continue to be valid. It is for the respondents to pass necessary orders in pursuance of subsection 3 of section 34B and proceed therewith.
My lords, after issuing the 2 notice, my lords.
After issuing.
After issuing.
After issuing the necessary notice, show cause notice under subsection 2 of section 34B. Petition is partly allowed.
Deeply obliged.
for R1 I accept notice. Allah, we have already accepted, but it has been shown. In the year 2021 only, we have intimated them.
Direct print the name of the AG as that appearing for respondent number 1.
Please.
Partly allowed quashed resumption. You give a reply to the show cause notice and then go ahead.
Obliged. Deeply obliged.
KL Patil?
Allowed.
ಆಮೇಲೆ explain ಮಾಡ್ತಾರೆ. Yes.
The petitioners are before this honorable court challenging the order at annexure J and L, my lords. Lords, petitioners and another one have granted with an occupancy rate of the properties to the extent of 9 acres and 6 acres. Accordingly, for number 2 came to be issued as per annexure A and B, my lords, at page number 19 and 21. Then, my lords, someone has filed an, to that extent, my lords, as per annexure C, my lords, merger was conducted, wherein it is held that the petitioners were
In possession.
in possession of the property and they are cultivating the land, my lords. After that, my lords, the deputy commissioner, as per annexure D, wrote a letter to Tahsildar at page number 25, my lords, stating that the grant was there. ದಾಖಲೆ ಪರಿ ಸಿರಿಗೇರಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 201ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬುನಾಯ ಮಂಡಳಿಯಿಂದ ಯಾವುದೇ ಆದೇಶ ಮಾಡದೇ ಇದ್ದಾಗೂ ಕೊಟ್ಟೂರಿನ ನಮೂನೆ 2 ಪಟ್ಟಗಳನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿ ಆಧರಿಸಿ MR ನಂಬರ್ 149, 147ರಲ್ಲಿ ಮಾಡಿರುವ ಹಕ್ಕು ಬದಲಾವಣೆ ಕಾನೂನು ಬಾಹಿರ ಆದೇಶಗಳು. ಆದ್ದರಿಂದ ಈ ಆದೇಶಗಳನ್ನು ರದ್ದುಗೊಳಿಸಲು ಪ್ರತ್ಯೇಕ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಕೊಟ್ಟ ಆದೇಶಗಳನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿದ ನೌಕರರ ವಿರುದ್ಧ ಈ ರೀತಿ ಆದೇಶ ಪಡೆದ ಹಕ್ಕು ಮತ್ತು ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಸೇರಿದಂತೆ ಕ್ರಮ ಜರುಗಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. Then, my lords, as the deputy commissioner initiated a proceedings under section 136 as per annexure E, my lords, without issuing a notice to these petitioners, my lords, wherein he held that, my lords, the mutation entries were illegal and he cancelled those mutation entries. Being agreed by this order, my lords, the petitioner were approached as per annexure before this honorable court. This honorable court, after hearing the matter, remanded back the matter, my lords, by setting aside the order passed by the deputy commissioner and hold an inquiry after giving an opportunity. Then, my lords, during that proceedings, my lords, one of the grantee, my lords, died. That was brought before the deputy commissioner as per annexure G, my lords, wherein along with the death certificate, one Malaya, the respond number 2. And the petitioners were submitted the written arguments stating that, my lords, we are cultivating the land. And accordingly, after holding the inquiry, the occupancy right was granted by the tribunal, my lords. Then again, my lords, as per annexure J, my lords, the deputy commissioner has passed the order holding that these are frivolous entries under section 136 without cancelling the form number 7. The grant of occupancy right, my lords, and wherein he held that, my lords, these are frivolous entries and those entries was cancelled, my lords. Being that, my lords, the petitioners are before this honorable court. And, my lords, in page number 50, my lords, para 4.
Form number 7.
With the annexure A and B, my lords, page number 19 and 21. Form number 2 issued by the Tahsildar Sirgu.
Form 7 ಅಲ್ಲಿ.
Well, form 7 ಅಲ್ಲ, inam abolition act. Inam
Form 1 ಅಲ್ಲಿ.
Form not available.
Not available.
Not available.
Orders on form 1 not available.
Not available.
Form 2 ಮಾತ್ರ ಬಂದ್ಬಿಡ್ತು.
Who ಇದೆ? Only the
ಬಂತು.
inam. And, my lords, as per in page number 50, para 4 of the order passed.
Form 2 was issued when?
My lords, in the year 1986, my lords.
ಆವಾಗ ಕಂಪ್ಯೂಟರ್ ಪ್ರಿಂಟ್ಔಟ್ ಎಲ್ಲ ಚೆನ್ನಾಗಿತ್ತು. ಒಳ್ಳೆ ಲೇಸರ್ ಪ್ರಿಂಟರ್ ಎಲ್ಲ.
ಲೇಸರ್ ಪ್ರಿಂಟರ್
ಅಲ್ಲ, ಕನ್ಕಾಕ್ಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್, ಮೈ ಲಾರ್ಡ್.
ಬಹಳ ಚೆನ್ನಾಗಿದೆ ಅಲ್ಲ ಪ್ರಿಂಟು.
ಪ್ರಿಂಟ್ ಅಂಡ್, my lords,
ಏನ್ ಮಾಡ್ತೀರಾ? ಎನ್ಕ್ವೈರಿ ಆರ್ಡರ್ ಮಾಡೋದಾ? ಸ್ಟೇಟ್ಗೆ ಎನ್ಕ್ವೈರಿ ಆರ್ಡರ್ ಮಾಡೋದಾ?
And that
on the face of it, it is a fabricated document.
Page 25, I may kindly be seen.
25.
Page 25, annexure D. The deputy commissioner himself says that form number 2 are created.
On the face of it appears to be created. ಇಷ್ಟು ನೀಟಾಗಿ ಬರೋ ಚಾನ್ಸೇ ಇಲ್ಲ. ಏನ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ?
Take instructions.
Relist tomorrow for further hearing. Relist on 20th at 2:30 for further hearing.
The interim order still.
Interim order earlier granted is extended till next week.
21, SK Kayakmat.
Please, my lords. The present respondent number 2, my lords, in the year 2012.
What is the status of the representation?
What is the
Status of the
status?
representation?
Lord, they have mandamus to mutate the name. With regarding to implementation of order avoid annexure B, my lord, page 13, 11. Page 11.
So in 12 order ಏನಾಗಿದೆ?
ಅಲ್ಲ ಅದು
To allot the land, my lords.
13 ವರ್ಷದ ಏನಾಗಿದೆ? ಸುಮ್ಮನೆ ಮ್ಯಾಂಡಮಸ್ ಕೊಟ್ಬಿಟ್ರೆ
ಅಲ್ಲ, my colleague appeared. By tomorrow I will secure an information. Tomorrow or day after tomorrow.
ಇನ್ನು ಅವ್ರು ಮತ್ತೆ
ಅಲ್ಲ ಬೇಡ, by 2:30 I will pass over. Kindly pass over. At least I will get secure instructions and make submissions.
22, Mrutyunjay Hallikeri.
ಎಸ್ ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
This is an affidavit of Chief Secretary. Broadly, this affidavit covers the clause which has been inserted by the KBGNL. It was inserted from the year 1996. In the 8th meeting of the KBGNL, board meeting of the KBGNL. And we also, in this affidavit, we stated, the state never intended to delegate the power of eminent domain neither to the KBGNL nor to the contractor. This is an affidavit she has stated. This is the first submission. And also it is categorically stated, the clause should not be used without the consent of the landowner.
Who are there to use that clause also?
The reason why we have, yes, I make a submission, this affidavit cover that aspect. Why we included that clause, after the implementation of the Bachawat first award, the Upper Krishna project, the state has experienced some difficulties in respect of the land acquisition matters, where some lands, part of the lands which is not covered under the acquisition proceedings, smaller extent of the land. In those cases, to encourage the work, progress in the work, prevent the delay, that extent with the consent of the owners were permitted as a crop loss. These are the provisions used for the crop loss, and future acquisition will be done.
What has happened in this situation?
In this case, yes.
Mr. Egede is claiming full right under that agreement. His losses are being cost
this
to
clause,
him.
yes,
Men and machinery are idle. All those things.
We are not, the Chief Secretary has not supported that clause. In the present case, consent has not been taken. We have categorically stated. But in this stretch, on facts, out of 22 landowners, 21 landowners has given a consent for this crop loss. Except the petitioner, written consent we have not taken. However, the facts, it indicated that we have deposited the amount in their account.
Yes.
And the petitioner wife was very much present at the time of the execution of the work also.
Yes. So you wanted her to.
Now, that is why the inquiry is ordered against the officers also for misusing this clause. That cover the affidavit, that aspect is also covered under this affidavit. This is a project intended to irrigate 1,12,000 acres of the area under the total, and filling up of the 79 tanks. this land, my lord, this, especially this contract matter cover. ಅಲ್ಲ ನಮ್ ತಪ್ಪಾಗಿದೆ.
Consent and
ಅಲ್ಲ,
do it.
ಅಲ್ಲ ನಮ್ ತಪ್ಪಾಗಿದೆ. We should not, KBJ,
ಬಿಟ್ರಲ್ಲ,
it means
ಅವ್ರು
as a state agency I am making, my lord.
ರವಿ ಅವ್ನು ಕರ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ.
We
Ravi, yesterday also we saw some other matters where your SLO is again,
Not applying their mind.
the way that your KBJNL, KNNL will probably in one of the matters be recommending that your company should be closed. You are given rise to more litigation than what was there with the state. It was supposed to be to make it seamless. Your officers have become even more. The whole purpose is lost. And now you are doing these kind of things also. You are becoming bigger than the state.
That's a very unfortunate thing.
No, not you are becoming, you are making a contractor bigger than the state. That's why Mr. Hegde in loud voice can proclaim himself to be more than the state and say that his rights are being affected. Yes, Mr. Alikeri, what do you say?
Now, my lords, I filed an amendment application for quashing of the final notification also, along with my other prayers. In my prayer, my lord, I have made two prayers. One is, my lord, to declare that the entering in my land as illegal, number one. Number two, my lords, without there being, my lord, any survey, joint measurements, my lord, they have carried out the work. And that too, my lord, when they had come to my land, my lords, they had demarcated in a different way. Thereafter, my lord, in order to save somebody's property, my lords, I produced the photographs. In order to, my lord, protect somebody's property, my lords, what was told me, my lord, it was all completely diverted. And in between my land, my lord, it was taken. And then, my lord, I asked them for the map, etc., my lords, nothing was given to me. So, my lords, the final notification is made. Final notification is made after I approach this honorable court, and this honorable court grants an interim order not to precipitate with the matter. That's number one. Number two, my lord, their final notification is also not in consonance with the map, which they call a JMC. It is also not in accordance with that. I can demonstrate that, my lords. So, my lord, this entire proceeding has to be.
Now, what do you want? You want compensation or you want to
Now-
challenge that?
Now, my lord, in simple terms, I want that what they had shown me earlier, that the way they would go, because, my lord, they have reached this part of my land and this part of my land. They had told me that only a corner of my land, my lord, they would go. If they go to that extent, my lord, I would, my lord, stand back. In order to save the other property, they are going in between my land now. And that to just example, my lords. It was supposed to come like this, my lords. Now they are coming like this and going touching here in order to save this property. That they have to address.
There is the sketch of how you are planning of the entire thing.
You should check.
May I request your lordship, my lord?
Where is your property?
Now, my lord, in that 69/1 is my property, my lord.
69/1.
One is my property.
Stage 1, stage 2, bleeder 1, bleeder 2,
No,
bleeder.
that map will not serve the purpose. This is for entire project. It will not serve the purpose.
I request, my lords, we have filed it along with the statement, my lords, R12.
You are the petitioner property. Straight ಆಗಿ ಇದೆಲ್ಲ ಏನು ಚೇಂಜ್ ಇಲ್ಲ.
That your lordship may kindly take my objections, my lord, on 3/12/2024, filed on 3/12/2024 for a minute.
3/12.
3/12/2024, my lords. Objection to IA for vacating of, for impleading also I produced the photographs. Page 6 may kindly be taken.
Yes. Yes.
Page 7, my lord, would, I have written the survey numbers also. Now, your lordship, may 69/1 is my survey number. Now, my lord, 69.5, your lordship, 69/5, your lordship may kindly see.
Yes.
My lord, I have put a dot there, my lords. Ulidiruva pipeline Kamagari antide. I have shown a straight line, my lords. There, my lord, it comes here, my lords. I have shown in a circle, square, my lords. So what they have done is, they have done a work up to here, and they have done work up to here, my lords. Now the impression was given to me, my lords, that they would go in a straight line like this. Now the contractor, my lords, colludes with the owner of the 69/6, and he deviates it in this way.
Where is your sketch, Mr. Pregade?
R12, my lord, with kind permission. R12, in our statement of objection, R6 statement of objection.
When did you file it?
Page 50. Yeah, okay. Pass on.
When did you file it?
3-2.
3-2. Index ಮೇಲೆ ಏನು ಬರಿಬೇಡಿ. Index ಮೇಲೆ ಏನು ಬರೆದಿಲ್ಲ.
Correct.
Page
50. Hey, pass on, my lord, sir. It's the sketch, my lord, for it's for 4 kilometers straight, my lord, including this land of the petitioner. There is no deviation at all.
This is as per the plan.
Oh,
But as per these photographs on site, it doesn't seem to be that.
Exactly, it is. In fact, exactly, it's like this, my lord. No deviation at all.
Come to page 7 of the vacate stay application. Objection to the vacate stay application.
Therefore, my lord, I understand. May I answer it like this, my lord? We have answered it in our statement, my lord, stating that it's actually not so. They say it has been changed. Actually, it has not been changed.
So your drain or your this one will go in the 69/6 or will come to 69/1. Please be very careful before you answer. We will be appointing a ADLR to inspect and make a report.
Please.
We will be appointing a third party.
My lord, I had already appointed, my lord. They have submitted a report, my lord.
We are not concerned with your this one.
My lord had appointed earlier. ADLR had appointed report.
That is only with respect to, my lord.
Whether it is in their land. ಅಷ್ಟೇ. Alignment ಏನು ಮಾಡಿಲ್ಲ.
69.1 is survey number belongs to the petitioner. The intended acquisition of land is to the extent of 12 guttas. But we are only utilizing to the extent of 2 guttas of land. Stretch ಆಗಿರೋ ಎರಡೇ ಗುಂಟೆ ಹೋಗ್ತದೆ. That is a report from the ADLR which is already submitted. Escalation ಆಗ್ತಿರ್ತಕ್ಕಂಥದ್ದು ಭೂಮಿಯಲ್ಲಿ 2.5 ಗುಂಟಾಸ್ ಅಷ್ಟೇ.
Then during lunch time, all of you sort out this thing. If you
When
sort out, yes.
On best we can do it to solve the problem, because in the larger interest, madam, the
Interest, yes, but that doesn't mean.
please,
right,
but no, no,
offshore
with the rider, my lord, with the rider, with the consent of the petitioner, please. Or tomorrow,
Tomorrow.
tomorrow.
The request of all the councils released tomorrow at 2:30 p.m. Tomorrow na today na?
Today with kind permission, my lord, or else next week, my lord, please.
Again, pass over madam.
Next Monday.
Pass over, your pass over.
ನಿಮ್ ಕೆಲ್ಸ
Next Monday.
ಪಾಸ್ ಓವರ್ tomorrow ಅಂತ ಹೇಳ್ಬೇಕು.
22 needs to be.
ಏನು?
Next week, any day.
20th. ಆಗೋ ನೀನು. For me, okay. ತಮಗೆ.
No, no, my client.
Tomorrow.
My lord, my client is here, my lords,
Then,
and if they want a discussion, then let them give some time, my lords, and take it.
ಜನಾದ್ರೆ ಎಲ್ಲರೂ ಹೋಗ್ಬಿಡ್ತಾರೆ.
ಅದೊಂದು, please.
ಓಡೋಗ್ಬಿಡ್ತಾರೆ.
That photograph, my lord, asked us, my lord, it's a view, aerial view, that has not been implemented. ಅದು ತೋರಿಸಿದ photograph, aerial view of about 10 kilometers, that has not been.
ನೋಡಿ.
Please.
Pass over.
The interim order may kindly, oh, sorry, it's passed over.
Submission.
Yes, madam.
With due permission, my lordship. Serial number 2. Morning it was disposed of, my lordship. My lordship had asked me to make submissions if there are any instructions. My lordship, since the date of order of forfeiture and it is reserved for the purpose of burial ground, but till today it is not utilized for that purpose.
You used it for and new ತೋರಿಸ್ಬೇಕು.
No, my lordship.
Produce some documents, payment of taxes, etc. You produce.
No, my lordship. Since government
107.
submitted that.
107. There was some urgency in that matter, my lord. Just an acquisition is being started.
One permission.
You produce some documents and then make mention, not a oral
No,
submission.
I may be permitted to produce the document to show that it is not yet implemented. It is
We are-
not used for the proper.
Please understand, we have told you 5 times in the morning, now the second time. You produce a document indicating your use and your exercise of ownership right, not them not having done anything.
Some dhaba is being run over there.
Who
my
don't
lordship.
produce it, then the order stands.
I understand, my lordship, but it
Well,
was
that's all, that's
reserved for a public purpose.
Serial number 19, your lordship.
Huh.
Your lords, you have allowed it partly, your lordship.
Yes,
My lords, I
we have
request-
quashed the resumption order. Show cause notice, you will reply.
My lords, I request, maybe heard, my senior want to argue on that.
That is what it will be. Sure, they can always issue that notice. You'll have to reply.
I request on 24th, your lordship. That day it may be.
If you want your senior, ask him to come now. Yes, next.
Serial number 101.
24, my lord. Serial number 24. We kindly post on 21st, my lord. Friday, my lord. I have told, I intimated Betur Mat. Yes, some matter is
24th
before.
released on 21st.
Much.
Serial number 101, Lordship, for the petitioner. My request tomorrow, day after tomorrow, in preliminary hearing, Lordship.
Urgency ಏನಪ್ಪ?
Urgency and impleading application.
ಏನಿಲ್ಲ ಅಂದ್ರೆ ಬೇಡ.
Serial number 51, my lord. Non-compliance, this court has granted sufficient opportunity, but referring advocate is not submitted one page document. Next week, my lord, any date, my lord.
ಮಾರ್ಚ್ ಎಲ್ಲ ಮಾರ್ಚ್
Shivarudra.
Shivrudra, sir. Shivrudra, sir.
Mic on ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀನಿ sir.
ಈಗ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಿಮಗೆ?
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್.
ನರೇಶ್ ಕುಲಕರ್ಣಿ. ವಿನಯ್, ಇದು ಕಲಬುರ್ಗಿ ಅವ್ರದ್ದು ಇದು ತಾನೆ, ವಿ ಕನ್ಸೋಲೆ ತಾನೆ? ಓಪನ್ ಮಾಡಿದ್ದೀನಿ ಈಗ, ಓಪನ್ ಸೆಷನ್ ಮಾಡಿದ್ದೀನಿ. ಹ್ಮ್ 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 ಮಾಡ್ತೇನೆ. ಓಕೆ ಓಕೆ ಓಕೆ. ಫೋನ್ ಚೇಂಜ್ ಮಾಡ್ತೀನಿ ಏನಲ್ಲ. 2 hours late ಅಂತ ಲೈನ್ಸ್ ಕರೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ಹಾ ರಮೇಶ್, ಎಲ್ಲಿ ಇದರಲ್ಲಿ ನಾ ಫಸ್ಟ್ ಬೆಂಗಳೂರಲ್ಲ, ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ. ನೀವು ಇದಕ್ಕೆ ಲಾಗಿನ್ ಆಗಿ, ನೀವು ಇದಕ್ಕೆ ವಿ ಕನ್ಸೋಲಿಗೆ ಲಾಗಿನ್ ಆಗಿ. ಗುಲ್ಬರ್ಗಾನು ವಿ ಕನ್ಸೋಲೆ. ಹ್ಮ್ ನಿಮ್ಮ ಮ್ಯಾಟರ್ 330.
330.
ಅದಿಷ್ಟಲ್ಲಿ 330.
ಅದೇ ಗೊತ್ತು ಸಾಹೇಬ್ರು ಫೋಟೋಲ್ 2 ನಲ್ಲಿ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು.
ಇಷ್ಟೆಲ್ಲ ಬಂದಿದ್ದಾರಾ?
ಇಲ್ಲ ಇಲ್ಲ ಲಾಗಿನ್ ಇಲ್ಲಿ ಇನ್ನೊಂದು ಪಾರ್ಟ್ನರ್ ಮಾತಾಡಿದೆ ಒಂದು 10-15 ನಿಮಿಷ.
ನಂಬರ್ 2 ನಾ ಕರಿತೀನಿ.
ಈ 82 ಪ್ರಿಲಿಮಿನರಿ ಬಿ ಗ್ರೂಪ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಪ್ರಿಲಿಮಿನರಿ ಹಾಕಬಹುದಲ್ಲ?
ಅರ್ಜೆನ್ಸಿ ಕೇಳ್ತಾರೆ.
ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ ಇವರೇ ಹೇರ್ ಮಾಡ್ಯಾರ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಲಿ ಅಂತ.
ಅದೇ ಸ್ಟೇಜಲ್ಲಿ ಬರ್ತಾರೆ.
ನಾ ಹೇಳಿದೆ ಇಲ್ಲ ಹಂಗ ತಪ್ಪ
ಸೆಕೆಂಡ್ ಇನ್ ಕಮಾಂಡ್ ಹೋ ಅಂದ್ರೆ
ತಪ್ಪು
ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಡಿಲೀಟ್ ದಿ ನೇಮ್. ಯಾರ ಹೆಸರು ನೋಡ್ತೀವಿ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ವಾ? ಸರ್ ಒಂದು ನಿಮಿಷ. ಅದು ಇವತ್ತು ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನಾ ಪ್ರೈಸ್ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ, ಆರ್ಡರ್ ಆಗಿದ್ರೆ ಅದು ರೌಂಡ್ ಅಪ್ ಮಾಡಿ ಅಂತ. ಅಲ್ಲ 56 ಹೇಳ್ಬಿಡಿ, ಅವಾಗ ಮೆನ್ಷನ್ ಮಾಡ್ರಂತೆ.
ಎರಡು ತರಿಸ್ಬೇಕು ಬುಕ್ಸು.
ಅವ್ರು ನಮ್ಮ ಸರ್ ಬುಕ್ಸ್ ತರಿಸ್ಬೇಕಾ? ಸೈಟೇಷನ್ ಇದು. ಸೈಟೇಷನ್ ತಾನೇ ಎರಡು.
ಎರಡು ಬುಕ್ಸ್ ಅಂದ್ರೆ SCC ಇದು ಫಿಸಿಕಲ್ ಯಾಕಂದ್ರೆ ತುಂಬಾ ದಪ್ಪ ಇದೆ ಅದಕ್ಕೆ.
ಇದು ಇವೆರಡು ತೆಗೆದಿಡಿ ಕೊಡ್ಬೇಕು. ಅಮಿಕಸ್ ಕುರಿ ಅದು ಯಾವುದೋ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಆದಿತ್ಯ ಸೋಂದಿ ಅವರು
ಬೆಂಗಳೂರದವ್ರನ್ನ ಎಷ್ಟು
ಬೆಂಗಳೂರು 3:30ಗೆ ಈಗ ಒಂದು ಕಲಬುರ್ಗಿ ಇದೆ ಅದು ಮುಗಿಸ್ತೀನಿ.
ಐತಿ ಮೆನ್ಷನಿಂಗ್ ಐತಿ ಶ್ರೀರಾಮ್ ಹೇಳ್ಬಿಡಿ ಏನ್ ಬೇಕು ಅಲ್ಲ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ಮೆನ್ಷನಿಂಗ್ ಹೇಳ್ಕೊಟ್ಬಿಡು. Serial number 45 is another connected matter.
With respondent number 1. Trial court has thereby preliminary tomorrow day. Hold matter.
Hearing 20th.
Please.
Second matter. Some discussion.
Mic off.
22nd matter, some discussion took place. But it appears some spot inspection also necessary very much.
Okay.
So kindly have it on Monday, ma'am.
Yes, what are problem
22.
can be solved?
After arguing for some time, both the councils all the council seek for a week's time to visit the spot, ascertain the actual situation and make their submission. We list on 24th at 2:30.
To amicably solve the problem.
Affidavit will be taken.
Amicably is always better.
We need lordship's intervention so that.
24th. But henceforth, please, your contractors cannot be doing this.
Yes, ma'am, we take care of that.
First of all, you cannot do it. Then your
I don't know.
contractors.
Well, we'll take this seriously.
State cannot permit.
Affidavit will be taken on the record.
The affidavit, an affidavit of the chief secretary has been filed, which reads as under. After arguing for some time, both the councils seek for a short accommodation to inspect the property. Relist on 24th at 2:30 p.m. for further hearing.
Interim order.
Order earlier granted is extended next.
2:30. Matter pertains to Kalburgi bench. 1. Naresh Kulkarni.
The one matter.
Lord, one submission in this.
One. Yes.
Memo.
17-2 same ಇಲ್ಲ ಬೇರೆನಾ ಇದು? Same. ಅದೇನು?
Yes.
So ಏನಂತೆ?
I have not gone through. It is instructed by the council appearing from Bangalore to make submission.
ಈ ಕುರಿತು ಮಾಹಿತಿಯನ್ನು ಅಭಿವೃದ್ಧಿ ಮತ್ತು ಸರ್ಕಾರದ
They have stated that steps would be taken and it will be communicated to them.
They have asked you to take time.
Yes, no, yes.
ಎಷ್ಟು ಟೈಮ್ ಅಂತಾನು ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ ಅದನ್ನ ಹೇಳಿಲ್ಲ ಅವರು. But the steps will be taken and it will be implemented as.
ಈಗ ಕರೆಕ್ಟ್ ಆಗಿ ಟೈಮ್ ಹೇಳಿದ್ರೆ ಆ ಟೈಮ್ ಕೊಡ್ತೀವಿ. ಮತ್ತೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಡ.
Lord,
So the sites which are available has to be mentioned
Yes, my lord.
for allotment. ಆಮೇಲೆ ಅದು ಮಾಡ್ಬೋದು. There are two portions.
ಹೌದು.
ಎರಡೂನು ಮಾಡಿಲ್ಲ. And AG has filed a memo enclosing a letter dated 15/2/2025 addressed by the Principal Secretary, Urban Development Department to the Government Advocate. The same reads as under. The said letter does not indicate firstly ಇಲ್ಲ ಇನ್ನೊಂದು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ.
Yes.
ಅದರಲ್ಲಿ ಸೈಟ್ಸ್ ಇದಾವೆ. ಮಿಸ್ಟರ್ ಕುಲಕರ್ಣಿ, a memo has been filed by the counsel for respond number. The said memo does not indicate the time period. And AGA submitted that given 4 weeks' time, endeavor would be made to report compliance. His submission is taken on record. A memo has also been filed by respond number 3 indicating the available sites. It appears to have been served on the counsel for the petitioner also. However, neither the counsel for the petitioner nor respond number 3 are present through video conferencing. Relist on 25th March.
Dharwad bench matter, 230 matters, 108, Pooja Saudatti.
Yes, madam.
I have received the statement of objections today, my lord. And in this case, with regard to the admissions of 50 students intake.
Mali. Mr. Ramchandra Mali.
Ramchandra Mali.
I'm submitting before this honorable court regarding the last date of the admission, which is required with a penalty fee of rupees 2,000 at the end
What
of
happened to
50.
that letter which your principal has signed?
My lord, in the statement of objections, the Landlord Council has stated it is in the page number R5, annexure R5, giving it with regard to the principal who has received the letter from the university.
Yes.
That is in the page number 7, paragraph 11, your lordship. That is not forthcoming in the statement of objections, whereas the page number, the annexure R5 states about the UCC MS, that is the Tanika Samiti Sadasyaru, all 3 people who have visited the institutions.
Your intake had been reduced to 50 in the year 2021 at para 9, because your score was 38.65 as per the LIC report indicated in para 8.
Yes, my lord.
So if it was reduced to 50 in 2021 and continues to be 50.
My lord, with respect to this.
Until you
the
achieve a
petitioner-
minimum of 45 marks.
My lord, the Learned Council has stated in his statement of objections with regard to the portal has been blocked with regard to the payment of the fees, wherein the payment of fees, the institution already paid more than 2 lakh rupees for the continuation of the affiliation, my lord. It is in my petition copy at page number.
And will not get you affiliation, madam. Your compliance will get you.
At page
So
number 17, my lord. This has been approved and this has been taken by the institution. My petition copy at page number 17, my lords. At the last paragraph. ಮುಂದುವರೆದು ಸದರಿ ಮಹಾವಿದ್ಯಾಲಯಕ್ಕೆ NCTU ಸನ್ 2016-17ಕ್ಕೆ 2 ಯೂನಿಟ್ಗೆ 100 ವಿದ್ಯಾರ್ಥಿಗಳು ಮಾನ್ಯತೆ ಕೊಟ್ಟಿರುತ್ತದೆ. ಅದೇ ರೀತಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರದಿಂದಲೂ 2 ಯೂನಿಟ್ಗೆ 100 ವಿದ್ಯಾರ್ಥಿಗಳು ಅನುಮತಿ ಇದೆ ಎಂಬುದನ್ನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರವಹಿಸುತ್ತೇನೆ. ಈ ದಿಶೆಯಲ್ಲಿ ಮಹಾವಿದ್ಯಾಲಯವು ಈಗಾಗಲೇ 2 ಯೂನಿಟ್ಗೆ 100 ವಿದ್ಯಾರ್ಥಿಗಳು ಸಂಬಂಧಿಸಿದಂತೆ ಶುಲ್ಕವನ್ನು ಕವಿವಿಗೆ ಪಾವತಿಸಲಾಗಿದೆ. ಮುಂದುವರೆದು ಸನ್ 2023-24 ಸಾಲಿಗೆ ಕವಿವಿಗೆ 2,89,256 rupees ಸಂಯೋಜನಾ ಶುಲ್ಕವನ್ನು ಹಾಗೂ 2024-25 ಸಾಲಿಗೆ ಕವಿವಿಗೆ 1,95,995 ರೂಪಾಯಿಗಳನ್ನು ಹಾಗೂ 2025-26 ಸಾಲಿಗೆ ಕವಿವಿಗೆ 1,76,535 ರೂಪಾಯಿಗಳನ್ನು ಯೂನಿಟ್ಗೆ ಭರಿಸಿದ್ದೇವೆ. So this much of the amount has been already paid, and whereas they are saying that it is been blocked, the portal has been blocked. If it is the portal has been blocked, how can the petitioner can pay the fees, requisite amount of fee, my lord?
Madam, the question is that they have reduced your intake to 50.
Intake of 50, my lord. Every year there will be
From
renewal
100,
of,
they have reduced it to 50 because you
because
did
of the
not
parameters which they have
meet the
stated.
parameters.
But
And
my
that
lord,
has been
in their
accepted by your
own,
principal.
yes, my lord, in their own
Now
statement
you
of
can't be
objections,
permitted to go for 100 until you meet the parameters and get 45 marks.
in the page number 23, my lord, of his statement of objections, which is being produced in the court,
Yes.
page number 23, there is a paragraph given. 2020-21ನೇ ಸಾಲಿಗೆ ವಿದ್ಯಾರ್ಥಿ ಸಂಖ್ಯೆಯನ್ನು ಹೆಚ್ಚಿಸುವ ಬಗ್ಗೆ, ಹೊಸ ಕಾಂಬಿನೇಷನ್ಗಳನ್ನು ನೀಡುವ ಬಗ್ಗೆ ಮತ್ತು ಹೊಸ ಕೋರ್ಸ್ಗಳನ್ನು ಪ್ರಾರಂಭಿಸುವ ಬಗ್ಗೆ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳು ನಿಯಮಾನುಸಾರ ಮತ್ತು ಅಭಿಪ್ರಾಯಗಳೊಂದಿಗೆ ಕೂಡಲೇ ಸರ್ಕಾರಕ್ಕೆ ಸ್ಪಷ್ಟವಾದ ಶಿಫಾರಸುಗಳನ್ನು ಕಳಿಸುವುದು. ಹಾಗೆ ಶಿಫಾರಸು ಮಾಡುವಾಗ ಒಂದು ಬಾರಿಯ ಕ್ರಮವಾಗಿ ಅಫಿಲಿಯೇಷನ್ ಸ್ಕೋರ್ಗಳಲ್ಲಿ 5% ರಿಯಾಯಿತಿ ನೀಡುವುದು. In this case, there is 38 point odd numbers has been given by the institution, my lord, by the university. Whereas there is no such 5% of riayati has not been given in this regard.
Even riayati in 1.5% kotre, it will be, it won't reach 45.
Only for this particular year, my lords, they have a decreased number of admission intake, only for the 50 students, only for this year, that is 24 and 25. And they have approved for the 25 and 26, whereas the already institution has been giving the course for since 2016 and 17 from the NCTE, and NCTE
Where
has
is
also
that
given.
order reducing the intake?
Pardon?
Where is the order reducing the intake?
My lord, intake is not reduced. For 25, my lord, 24, 25, the approved intake, my lord, for the previous year was 50 only. They applied for, my lord, renewal of 50 intake, and my lord sought approval of additional intake of 50.
So from 100 it was reduced to 50. From 100 it was reduced to 50.
Their
must be an
application, my
order.
lord, I have produced.
Where is that order?
My lord, page number 12, annexure R1. This is an application, my lord, submitted, my lord, on the portal by the petitioners college. Page number 10, 24, 25 sali salವಾಗಿ ಇದು. Page number 12 ನಲ್ಲಿ total approved intake 50. ಆಮೇಲೆ additional intake sought 50.
It means 100 total.
One second. This approved was only 50 for the previous year, which they, my lord, sought its renewal, my lord, for 24, 25. And at the same time, they also sought, my lord, for approval of additional intake of 50 for 24, 25. Pursuant to this application, my lord, the LIC, my lord, visited the institution,
6724. Yes.
conducted, my lord, the inspection. Next, my lord, is the report of LIC, Local Inspection Committee. That has to, my lord, conduct the inspection as per the, my lord, parameters and or the, my lord, norms, my lord, issued by the state government.
Yes.
Page number 16, my lord, is the relevant portion. Assessment is done, my lord, under various credentials. Middle of the, my lord, page number 16.
Yes.
Secured weighted score of the college is 38.65. After giving, my lord, weightage,
Is student performance index 0? Zero ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ?
my lord, since what had happened, though permission, my lord, from the NCT was granted to the college from 2016-17, there was a case registered by the CBI, my lord, against the petitioner college. There was no renewal of, my lord, affiliation was granted, my lord, by the university till 22-23, my lord. In 23, my lord, renewal was granted, but by that time, my lord, already the academic year had.
See your own document. Part 3 recommendations ನೋಡಿ.
Yes. Otherly then.
Additional intake sought.
Additional intake sought 50. Not recommended increase in intake due to fees not paid for the purpose. Not recommended, next, my lord, not recommended increase in intake due to fees not paid for the purpose. And my lord, on the final, my lord, observations, remarks, page number 17 ನಲ್ಲಿ ಇದೆ of the LIC.
Page number?
17. Observations and remarks anta.
Yes.
So where it is given regarding the parameters of the institution, my lord, it is further it has been given in a different.
Your
parameter.
argument is contrary to your document.
Complete automation of library and purchase library books to meet the standard of B.Ed course. Appoint qualified faculty with social security benefits. Faculty should be well paid and maintain roster in appointment. Above observations are accepted. My lord, in the.
Is accepted.
Yes. They have been accepted, and subsequently, my lord, once again they submitted the application. Second time, my lord, LIC visited the institute, conducted, my lord, inspection, but they could not, my lord, score minimum 45 marks, which is, my lord, required.
That is not the reason that they were given here in part 3 recommendation in.
16, my lord, total weighted score
Your
is.
reason is not recommended increase in intake due to fees not paid, not because of the marks.
Final observations are, my lord, at 17, page number 17.
The final observation ಅಷ್ಟೇ.
Defined parameters, my lord, on the page number 17, your lordship could find it. There are various, my lord, parameters.
That
On
is
the
not
basis
the
of,
reason given.
they could not, my lord, secure the minimum, my
That
lord.
is not the reason given. That minimum is so and so ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. And it's not been secured ಅಂತಾನೂ ಹೇಳಿಲ್ಲ.
They-
And your argument is contrary to this document. So what do we do with your argument and the instructions received by you?
Since, my lord,
Who is the person who has instructed you?
Pardon?
Who is the person who has instructed you that it is because of marks?
My lord, I have taken the instructions, my lord, from the concerned department.
Departmental ಯಾರು officer?
Lord,
That instructions are contrary to this document.
I shall clarify, my lord, if there is some discrepancy in the document and, my lord.
The only reason why you are not recommended is because fees has not been paid. Now they have paid the fees. So you can't stop from increasing the intake.
Regarding this, my lord, I shall submit, my lord.
Every day one though.
Every day, my lord. Within 2 days, my lord, I had taken the instructions and filed, my lord, my statement.
My lord, with the permission of this one.
Now, my lord, already the last date for admission is also over.
Collect the fees. That last date was over because you took time.
And that last date would be with the penalty
Page number
fee, my lord.
23, my lord, of the government order dated
When the matter was taken up,
12/2/2021 may kindly be seen.
a notice was ordered on 7/2/2025. When the matter was taken up on 10/2/25, the counsel for respondent sought for time. On 12/2/2025, the counsel for the respondent had submitted that the petitioner had not satisfied the minimum requirements and therefore the intake was not recommended. And as such, he sought to place those documents on record. Objections were filed on 17/2/2025. Along with the said objection, the report of the local inspection committee is enclosed. A perusal of the said report indicates that that insofar as the additional intake sought for, the recommendation made by the LIC is, inverted commas, not recommended increase in intake due to fees not paid for the purpose, inverted commas close. Thus, the only reason why the additional intake was not recommended, as indicated in the LIC report, is non-payment of fees and for no other reason. The learned counsel for the petitioner, by pointing out to the letter issued by the petitioner on 7/12/2024 at Annexure F, has categorically stated that the fees was ready to be paid. However, the fees was not accepted by the respondents. In that view of the matter, I have the considered opinion that at this stage, a direction would have to be issued to respondent to collect the fees of from the petitioner for the increase in the intake and grant the additional intake, as also collect the fees, examination fees
Admission
for all
fees.
the students, admission and examination fee, or all
Without
the
penalty
students
fee, without penalty fee, my lord.
who have been admitted without penalty or interest. The respondent university shall open the portal from 10 a.m. to 5 p.m. on 19th February, when the petitioner would be entitled to make payment of the due amounts. On such payments being made, the respondent shall process the said application and the payments made and issue necessary endorsement for increase in the intake, as also issue the admission card and all ticket for the students to take up their examinations.
Lord, students have not yet been, Lord, admitted. They are
ಅದಕ್ಕೆ
seeking,
admission ಅನ್ನು ಹೇಳ್ತಾರೆ.
they are seeking permission, Lord, to admit the students.
Yes.
That is
And you
rectification of the
refuted, your
application.
arguments are contrary.
Lord, only, my Lord, due to the fact that they couldn't, my Lord, succeed in securing minimum, my Lord, criteria.
Mr. Mali, we are
I
not
understand, my Lord,
commenting
there
on-
is a, yes.
Your instructions are wrong, completely contrary to the document. That only indicates when university does this is for some other purpose.
This is a state government portal, my Lord. Normally it is uploaded on the internet profile.
Much obliged.
Prithvi KS.
So in this case, I
Request my lordship to 13 to order, my lords. My lordship has.
13-2.
please. On 32/2020, the Lordship has directed the state government to make submission insofar as entry of the petitioner's name in survey from 1969 to 1981. And also insofar as classification of Burke Arab land.
Yes.
Yes. To that effect, my lord, may I pass on the memo along with the documents? Lord, the first document is with regarding to the Mysore revision settlement. That is the, yes, my lord. That was much prior. There, my lord, I have marked insofar as 273 is concerned.
Yes.
Yes, ma'am. Thereafter, next is with regarding to the,
Really, ಎಷ್ಟು ಇವಾಗ?
please. ನಲ್ಲಿ ಇಲ್ಲೇ ಇಲ್ಲ. Till today also there is no reference. So my lord, as per the documents and the resettlement surveyment, that land is a Karab land and the entire extent of land is a Karab land.
What about your computerized RTC at B1?
That is at page 37, my lord.
Yes.
Page 37, my lord. ರಾಷ್ಟ್ರಪತಿ ಸರ್ಕಾರ ಅಂತ ಪರವಾಗಿ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಇವಾಗ 745 Karab 531 ಆಯ್ತು.
ಅಲ್ಲ ಅದರಲ್ಲಿ 2.14 has been acquired by the National Highway Authority. We have given them to for formation of road.
ಅದಕ್ಕೆ 5.
ಹೌದು.
ಅದು 2.14 ಗಣರಾಷ್ಟ್ರ.
Yes. So my lord, on this basis, my lord, my respectful submission to the honorable court that the documents which have been relied by the petitioner and the grant order on which they are claiming the right as per annexure.
The only document is the RTC at annexure B which finds their name.
How?
Even the computerized RTC doesn't find it.
There is no reference. They claim their right as per annexure A, my lord, page 20. That is the D form which has been issued. We are also disputing this also. As per the D register which has been maintained by the state, there is no such document which has been issued.
Yes, Mr. Prithvi.
My lords, in the order passed by the Assistant Commissioner, he himself says that, my lords, the grant order issued to the petition. Page, my lords, annexure, page 59, annexure E, my lords. In the order, my lords, he himself refers. Melkanda Vishay, page 59, my lords.
Yes.
ಫಸ್ಟ್ 3 ಲೈನ್ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖ ಮೂಲಕ ಬಳ್ಳಾರಿ ತಾಲೂಕು ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಭಾಷಾ ಸಾಬ್ ತಂದೆ ಇವರಿಗೆ ದಟ್ ಡಿ4 ನಂಬರ್ ಆಲ್ಸೋ ಪಟ್ಟ ನೀಡಲಾಗಿದ್ದು ಹಾಲಿ ಪಾಣೆ ಸರ್ಕಾರ ಎಂದು ಮಂಜೂರಾತ್ ಪಟ್ಟ ಪ್ರಕಾರ ಹಾಗೂ ಕೈ
This is your claim, your contention.
ಬಟ್ he himself admits that
Admit ಅಲ್ಲಪ್ಪ ನೀವು ಹೇಳಿದ್ದು ಇವಾಗ ನೀವೇನ್ ಹೇಳ್ತೀರಾ ನಾವು ಬರ್ಕೊಂತೀವಿ.
and also my lords, my submission,
he says submit so and so.
And he says, my lords, Colway in respect of 7 acre 45 gunta. My lords, in annexure C3, my lords, the report has been submitted by the, my lords, revenue inspector to the Tahsildar, and Tahsildar has forwarded to the, my lords, assistant commissioner, wherein he states that, my lords, ವಾಸ್ತವದಲ್ಲಿ ಕಾಲುವೆ ಇರುವುದಿಲ್ಲ ಎಂದು ಸ್ಥಳ ತನಿಖೆಯಲ್ಲಿ ಕಂಡು ಬರುತ್ತದೆ.
ವಾಸ್ತವದಲ್ಲಿ dried up or whatever, that's
that, my lords,
dry up ಆಗಿರಬಹುದು, but it is a ಕಾಲುವೆ reserved for B Karab, the entire length.
If the questions
lake ಗೆ ಒಂದು ಸರ್ವೆ ನಂಬರ್ ಕೊಡ್ತಾರೆ, ಸರ್ವೆ ನಂಬರ್ 11, the entire lake 250 acres will be one lake. Survey number 1, Belandur lake, that is 750 acres, one survey number, Bengaluru. That is a lake which the survey numbers are granted. But how did you get this annexure B? And all the documents, certified copy kodake chance ilvalla.
For that reason also, certified, there is no signature of the authenticated officer at annexure B. ನಾನು ಸರ್ಟಿಫೈಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ. ಡೆಪ್ಯೂಟಿ ತಹಶೀಲ್ದಾರ್ ಹ್ಯಾಸ್ ಸೈನ್ಡ್ ದೋಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಪಕ್ಕದಲ್ಲಿ ಒಂದು ಇನಿಷಿಯಲ್ ಹಾಕಿದ್ದಾರೆ. ಸೊ ವಿ ಡಿಸ್ಪ್ಯೂಟ್ ದಿಸ್ ಆಲ್ಸೋ. ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಿಚ್ ಹ್ಯಾವ್ ಬೀನ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಬೈ ದ ಪಿಟಿಷನರ್ಸ್ ಆರ್ ಫ್ಯಾಬ್ರಿಕೇಟೆಡ್ ಅಂಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
records I will also verify.
Initiate proceedings.
ಅಲ್ಲಲ್ಲ, that already steps have been taken.
That records I will verify. Lords, tomorrow, my lords, I will just.
You can verify, but if fabricated documents are produced, steps will be taken.
Party also present, my lords, I will just verify the records tomorrow itself, my lords.
Learned AGA has produced the original records of Form 11, original Form 11s.
Yes.
Relating to record of rights, tenancy and crops as maintained by the authorities. A memo has also been filed enclosing the Mysore revision settlement registry extract, as also revision survey and resettlement register of Belugolu village, Bellary Taluk. Both the documents
and Akarabandu.
both the documents relating to survey settlement would indicate that the entire extent of 7 acres, 45 guntas in survey number 273 has been classified as B Karab. The same is also reflected in the Akarban, which has been produced. The RTCs in the register in Form 11 maintained indicates that from the year 1965 to 1980, there is no mention of the name of the petitioner or any his predecessor. In fact, in type of in column number 9, column number 9, it has been indicated to be Kaluve Perumbok, and nature of possession is being shown as Sarkara. Faced with the above situation, counsel for the petitioner seeks for a day's time to obtain instruction, make his submission. Learned AGA at the next relist tomorrow at 2:30. Please.
My lords, apologies for the, my lord, as to tomorrow's date.
108 handle very odd.
Handle we don't. Sure, sure.
110, Mallikarjun Swamy.
No, in this, there was a direction to secure the records. Secure the records. Regarding to rejection of the petitioner's claim for insofar as conversion of land is concerned. Lord, the report submitted by the Buddha and
inspection ತಗೊಂಡಿದ್ದೀರಾ? Inspection ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಅಲ್ಲ just now I have received. ಅಲ್ಲ ನನಗೆ just now ಬಂದಿದೆ. ಅಲ್ಲೇ ಅದೇ ಹಳೆದೈತೆ
ಹೊಸದೈತೆ after the file.
ಅಲ್ಲ that is the record whether that is
That is after the rejection.
after rejection ಇರಬೇಕಲ್ಲ.
After the rejection, that report.
That is dated 25 ಅಂತಿದೆ. But the rejection order is of 26/9/2024, my lord. So I will just now I have received. I will go through and give the.
You know,
Please.
The AGA submit that he has secured the records, and it would be made available to the petitioner for inspection.
Yes.
I'm given a copy of the endorsement. This is a piece without any authentic.
ನೋಡ್ಲಿ ಅವ್ರಿಗೆ ಇವಾಗ ತಾನೇ ಬಂದಿದೆ.
It says that there is no report.
ಅಲ್ಲ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ಸ್ಟ್ರೇಟ್ ಅವೇ
ಇನ್ನ ನೋಡಿಲ್ಲ ಎಲ್ಲರೂ.
ಆಯ್ತಾ?
Or we'll have to send him out to see and other matters will not take.
No, in fact, to verify, I asked him, I think.
We list on 20th at 2:30 p.m.
It may be taken on, please 20th.
20th. 111, KL Patil.
IPF for petition.
Sir, last occasion I was directed to produce the approval and sanctions.
Yes. By the council and the municipal council.
No, I'm representing the deputy commissioner.
The municipal council.
Municipal council, respond number 10.
But these are the, but this is an grant is under the, for the benefit of scheduled caste and scheduled tribe. The first one is the amount has been placed before the board of the Karnataka Niravari Nigam, and the Karnataka Niravari Nigam every year reserves some fund for the purpose of allocation only for SC/ST areas for the development. So this is an other areas where the document, the page number 1, the letter dated 23/6/2021 on various different MLA constituency it has been given. Subsequently, the preliminary approval was given on 15/7/2021 at page number 3. The municipality has given a permission on 7/10/2022 at page number 5. However, there is an initial objection from the municipality. After clarification, they have given on 7/10/2022. Subsequently, the approval given by the MD Chief Engineer KBGNL at page 9. It is an
How
approved.
can you say that this is for the benefit of the members of the SC and the ST community? It's for
Residents are
everybody.
Yes,
You're restricting it to only SC and ST community.
Under there is the act, my lord, which provides for the allocation of the fund for the scheduled caste and scheduled tribes area where they're situated.
But how can you use those funds for these? This is not for the benefit of SC and ST community. How is it for the benefit?
My lord, even for the construction of the any developmental work, road or construction of the park in that area.
For those funds are to be used specifically for the benefit.
Yes, benefit
How
in
does this benefit?
For the developmental work, my lord. It is need not be restricted to individual development of the scheduled caste or scheduled tribe, my lord. For example, my lord, if there is a dominated area where this is the area, my lord, where the for the playing equipments have been installed at the area where the scheduled caste scheduled population is staying or residing.
ನೀವು ಎಜುಕೇಶನ್ ಮಾಡಿ, ಸ್ಕೂಲ್ಸ್ ಮಾಡಿ, ಕಾಲೇಜಸ್ ಮಾಡಿ, ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಏನಾದ್ರು ಜನರೇಟ್ ಮಾಡಿ, any of those things can be for the benefit. ಒಂದು ಪಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ಟು ಇಟ್ ಇಸ್ ಫಾರ್ SC ST ಬೆನಿಫಿಟ್ ಅಂದ್ರೆ ಹೆಂಗಾಗತ್ತೆ? This, when you use the funds for the particular community, it must be exclusively for that community. It can't be for anybody else. ನೀವು ಅಲ್ಲಿ ಯಾರನ್ನೂ ಸ್ಟಾಪ್ ಮಾಡಂಗಿಲ್ಲ.
ಬೇರೆ ಎಲ್ಲರಿಗೂ ಇಲ್ಲ.
ಯಾರು ಬಂದ್ರೇನು ಅವ್ರು ಒಳಗೆ ಬಿಡಬೇಕು.
ಅಲ್ಲ ಬಿಡಬೇಕು. When it is public, my lord, we can't prevent it.
ಹೇಳ್ಬಿಟ್ಟು ಹಂಗ್ ಮಾಡಂಗಿಲ್ಲ. It's not proper.
But allocation fund regularly for the development work which has been done, my lord.
Your allocation is wrong.
But under the 2013 Act, my lord, covered the entire development. I understand, my lord, the total object should be for the in-person. That should be, it should not be in the name of, I understood.
You are using CSR funds of this company for this purpose.
But admittedly in this area, my lord, they are the dominated people that I have document to show that also. But subsequently, my lord, the approval has been taken from the authority. Subsequently, my lord, even under the proceedings I have produced at page number 74, my lord, the government proceedings, the government order, which indicates that, my lord, if the amount spent is for the nearly crore rupees, the concerned chief engineer is a competent person to give the approval. I have produced the government's.
The whole genesis is bad, Mr. Ganga.
Yes, I understand, my lord, but
understand as well, Mugitalla.
For development is already they happened, my lord. In future, my lord, state will give the.
So every time states make a mistake, we'll say.
ಅಲ್ಲ ಈಗ ಈ ಎಲ್ಲ ಬೇರೆ ಕ್ಷೇತ್ರದಲ್ಲಿ ಕೈಂಡ್ಲಿ ಟೇಕ್ ಪೇಜ್ ನಂಬರ್ 1 ಮೇಡಮ್. ಈ ಬೇರೆ ಎಲ್ಲಾ ಕ್ಷೇತ್ರದಲ್ಲೂ ಡೆವಲಪ್ಮೆಂಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. That is to the extent of 25 lakhs, 75,125.
These funds will have to be made good for the SC and ST community exclusively. You will have to source some other funds to give them the benefit. Their benefit cannot be deprived by doing this. So if you undertake that, you will source separate funds of this to 10 crores.
1 crore. 1 crore.
1 crore. 100 lakhs. From some other source, which will be used exclusively for the SC and benefit and not for this.
Okay.
And we may be agreeable. Otherwise, diversion of funds cannot happen like this.
Yes, my lord, I understand. In stricto sense, we are not fully utilized for those class of the persons, my lord.
Fully alla.
Yes, regarding that, my lord, I will.
We should not be saying all those things.
Yes, yes. I will seek instruction on that. This amount will be from any other.
To that, as separate funds and not as per this scheme.
Yes, I understand, my lord, that, but the development work is already half of that has been done. With that undertaking, my lord, I will also indicate the source from where it.
Admil undertaking, iವಾಗ undertaking ತೋಳೋಣ.
ಅಲ್ಲ, instruction ತೊಗೊಂತೀನಿ. We'll seek. I can't make a submission. Have it tomorrow, my lord. I'll seek instruction and make a submission.
Yes.
Please. In fact, on the other day also.
One of the grounds you urged is on the funds being used and nobody from the SC/ST community is there. You are from the petitioner, alva?
Please,
you respondent here.
You contesting respondent.
Contesting respondent. One of the fund grounds is that we'll address.
Go through the records, my lord.
Records
now.
ನೋಡಿ, records is okay. Only issue is the genesis of the funds. ಎಲ್ಲಿಂದ ಬಂತು ಅದು under that ground may not be acceptable. We'll agree with you. That is why Mr. Gangadhar will get his instructions and sort out the funds issue. But this project is for the development of the area.
Ultimately, the plaintiff's easement rights is involved, my lord.
Easement right ಅಲ್ಲಿ ನಾಳೆ 5 ಜಾಗ ತೋರಿಸಿದಾರಲ್ಲ, ಎಲ್ಲಿಂದ ಕ್ರಾಸ್ ಮಾಡ್ಬೋದು ಅಂತ.
From 30 years back to.
Then we'll remove everything at your cost and make it into that same nala as it was.
I have also produced some records, my lord, yesterday, my lord.
Your whole suit is misconceived, except for this funds thing.
I'll go through the records, my lord, tomorrow.
Otherwise, password, my lord, seek instructions.
Password.
Deputy Commissioner.
Funds matra, you are right. Other things, everything is wrong.
Tomorrow.
Tomorrow.
Yes.
Release tomorrow at 2:30 p.m.
Please.
A memo with documents has been filed by learned Additional Advocate General. Same is taken on record at the request of counsel for respond number 1 to 8, 12 to 42, release tomorrow.
112 HR Deshpande.
For respondent.
For the petitioner, my lords, we have challenged the orders passed by the trial court at annexure E, my lords.
Yes. Suit for EP, na?
EP, my lords.
Yes.
The dispute was regarding the memo of calculations filed by both the JDR2 and decree holder.
ಮತ್ತೆ ಕರ್ನಾಟಕ ನೀರಾವರಿ ನಿಗಮನ ಎಷ್ಟು ಲಿಟಿಗೇಷನ್ ಇದೆ ರೀ ನಿಮ್ದು? ಒಂದು ಲಿಸ್ಟ್ ತರಿಸಬೇಕು ನಿಮ್ದು ಲಿಟಿಗೇಷನ್.
Genuine ಇದೆ.
ಇದು ಜೆನ್ವಿನ್ ಬೇರೆ ಎಲ್ಲ
ಅಲ್ಲ, ಪಬ್ಲಿಕ್ ಮನಿ ಲಾರ್ಡ್ಸ್ will have to as far as
Yes.
possible.
Yes, Mr. Deshpande. What is your contention? Your the execution petition was filed.
As per annexure E, my lords,
Hmm.
the gazette notification is from 41 notification 1/4/2004, my lords.
Gazette notification ಎಲ್ಲಿದೆ? Annexure E na?
Yeah, my lords. It is.
Annexure E is the.
No, annexure E is the impugned order.
Order. On the memo of calculation.
Yes, land acquisition commenced from 2/4/2005, my lord. That's
Preliminary notification
1/4/2004, my lords.
Hmm.
And the actual possession was taken as per the RTI reply given by the JDR number 2 himself as on that is also inculcated in the order itself, my lords. In the 1/4/2004, lands were acquired and the actual work was started in the month of August 2004 itself. Therefore, we took it as date of disposition from 1/8/2004 itself. And earlier, the learned presiding officer has accepted this RTI explanation and also the date of disposition. But subsequently, my lords, when there were a lot of arrears, the trial court has issued attachment warrant. And the JDR number 2 has approached this honorable court as per annexure A, wherein the liberty was given to the JDR number 2 to file the fresh memo of calculation, and also we were also permitted to file the rebutting memo of calculation. As per the impugned orders, my lords,
So your contention is the interest from 1/8/2004.
Yes, my lords. It is from the date of
9/5/2005 has not been paid.
Yes.
Only for that 1 year.
Yes.
1 year alla, it is around 8 months.
Para number 11 is very clear, my lords, of the impugned order.
Yes.
In page number 31. May I read it, my lords? Earlier, relying on the letter dated 31/12/21 produced by the DHR, my learned predecessor in office had taken the date of disposition as 1/8/2004.
Where is that letter of 31/12?
Yes, that was produced. However, I am having a copy, my lords. That is the reply given by the JDR number 2 himself.
ಇದು ಯಾವ್ದು ಸರ್ವೆ ನಂಬರ್ ನಿಮ್ದು?
Impugned order para number 11, my lords. This RTI reply issued by the JDR number 2 has been accepted by the previous presiding officer, but subsequent officer did not accept it. There are contrary views by both the officers.
What to say about this letter issued by your executive engineer?
But earlier, my lord, it was calculated based on that letter, but that, my lord, has been negated by this honorable court. Page number 15, my lord. Earlier calculation was based taking that date, my lord, as a date for.
In which order has it been negated?
At page number 15, my lord, page number 9. This is the earlier order of this honorable court.
Para number 5, my lords.
In that, my lord, page number 15, para 5, my lord, regarding the
Yes.
date of possession. The beneficiary has approached this honorable court because, my lord, interest was awarded from date of possession, taking that date as date of possession.
Earlier it was not
At
there.
page number 15, para 5, may I read, ma'am?
Yes.
Lordship gets it, para 5. In this background of above, having noticed the specific dates relating to passing of the award dated 23/4/2005 and the very claim based on the basic calculation as indicated in execution petitions so and so, a prima facie error is noticed in as much the interest component is claimed from 1/8/2004 without specific reference as to whether possession has been taken on the said date. The fact that the award was passed subsequent is clear, and there is categorical assertion that possession had not been taken earlier to the same, and interest awarded is from the date of possession cannot be in dispute. Therefore, the said calculation indicated
All matters which are which require appropriate consideration by the executing court.
Please.
Yes.
This court has not given a finding.
Not given finding, my lord. That date, my lord, which was calculated based on that date, 1/8/2004.
The most you can say it is not on 1st August, August alli anta.
Whether
1st August though.
my lord, that earlier order is not available here. I'm not sure, my lord, if it was calculated based on the same letter.
No. Impugned order
Because, my
says-
lord, that date, my lord, it's not available at all otherwise. Only, my lord, based on that letter, they are my lord, coming to conclusion that it was taken on 1/8/2004. There also it was calculated from 1/8/2004. This court has.
At the most you can say 1/8 ಇಲ್ಲ 31/8 or 15/8. Independence Day ಶುರು ಮಾಡಿದ್ವಿ ಅಂತ. ಒಳ್ಳೆ ದಿನ ಎಲ್ಲಾರನ್ನೂ ಕರೆದ್ಬಿಟ್ಟು ಒಂದು
ಅಲ್ಲ, when there's no
function
proof.
ಮಾಡಿ ಶುರು ಮಾಡಿದ್ವಿ ಅಂತ.
Yes.
But you cannot deny this letter.
Letter, my lord, I mean.
ನೋಡಿಲ್ವಾ ನೀವು?
No,
It's not part of the writ
it's
petition.
by the JD number 2 himself,
For
my
the
lords. It has been accepted earlier by the court.
execution court. The execution court has referred to that letter 31/12/2011.
But no, I didn't have a petition. I just borrowed from. I'll just go through the letter.
ತೋರಿಸಿ ಶ್ರೀರಾಮ್. ಸರ್ವೆ ನಂಬರ್ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ.
Yes.
ಇಟ್ಸ್ ನಾಟ್ ಜನರಲ್ ಅಲ್ಲ, ಸರ್ವೆ ನಂಬರ್ ಸ್ಪೆಸಿಫಿಕ್ ಕ್ವೆರಿ ಇದು.
I'll take instruction. But I understand, my lord, 8 months.
So 1/8 will make it 16/8,
Yes. And
just 15 days.
the trial court has erred, my lords, by taking the date of disposition as date of award.
Award.
Allah, when there is
Then
no
final notification. In this letter.
but
is there.
award or possession, whichever is early, when there is no, my lord, proper dates of possession is cannot be ascertained, then award is taken as the reference point.
This letter we'll have to accept unless you suspend this executive India.
I'll take instruction, but if it is
That he is
given,
not given properly.
yeah, I understand.
You cannot disown it.
My lord, tomorrow, my lord. Sir.
And despite this letter, if you have argued all these things before the trial court, before the execution court, that is mala fide.
My lord, earlier he says, my lord, that was taken reference.
We are not going to let go. ಸುಮ್ಮನೆ ಬಿಟ್ಟು ಬಿಟ್ಟಿನ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. We'll take action.
But I'll take
Spend a little more time in this matter to take that action, but we'll take it. You can't be taking a chance with the court.
Yes.
ಅಲ್ಲೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ, ಇಲ್ಲೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ, ನೋಡೋಣ. We won't permit that.
Regarding this letter, my lord, I'll take instruction which can be disposed of tomorrow, day after tomorrow.
H.R. Deshpande, learned counsel for the petitioner, has filed a memo enclosing the letter dated 31/12/2011 issued by the executive engineer KNNL, Karnataka Niravari Nigam Niyamita, respond number 2 herein. In terms of the said letter, the executive engineer has categorically stated that the notification, preliminary notification, has been issued on 1/4/2004. The works in respect of survey number 21/5 and 21/3 were commenced in the month of August 2004. In that view of the matter, faced with the above situation, counsel for respond number 2 seeks for 2 days' time to obtain instruction, make his submission. Since if that letter has indeed been issued by the executive engineer, then the submissions made by the KNNL before the execution court are completely mala fide. We list on 20th
My
at
lord,
2:30 p.m.
Till that, my lords, the EP may kindly be stayed, my lords. Otherwise, they are going to close tomorrow itself.
The further proceedings, even if it is closed, we'll reopen it, Mr. Deshpande. ಎಷ್ಟು ದುಡ್ಡು ಬರುತ್ತೋ ಅಷ್ಟು
Because
ತಗೊಳ್ಳಿ
once
ಸದ್ಯಕ್ಕೆ.
they close.
ಇದೇನ್ ನಾಳೆದ್ದಕ್ಕೆ ಒಳಗೆ ಏನು ಕ್ಲೋಸ್?
No.
The further proceedings in EP number 78 of 2006 pending on the file of the additional senior civil judge and JMFC
Athani, my lords.
He stayed till the next date of hearing. We list on 20th at 2:30 p.m. for further hearing. ಇನ್ನೊಂದಿದೆ 130.
113, L party.
This is not yet started.
One minute.
Urgency ಏನಿದೆ?
Land acquisition matter, my lord, BRTS acquired my land in the year 2012-2014. They have not paid my any compensation till today. And in spite of direction in the writ petition by this honorable court also, he passes the award stating that this is the road margin area. And thereafter, my lord, when in this writ petition also, they came out with the stand that the joint measurement done by the then land SLO is not proper. Then this court directed to the DLR to measure the land and submit the report. In that report also, it is clearly mentioned that 1 gunda and odd is acquired by my land.
What do you mean marginal land, Mr. Angadi?
Lord, it's a word that has been used with regard to the road portions forming part of the layout. Forming part of
the road margin to be left for future expansion.
Not necessarily, not all the roads internal and abutting the existing highway, my lord. They were all covered under the road portion, and any developer, my lord, will be entitled for about 55% of the plottable area. Keeping about that approximate ratio, my lord, these layout sanctions have been made by the planning authority or the successors in office, that is Hubli Dharwad Urban Development Authority. So this is also one such instance, my lord. So in fact, the DDLR who was appointed, my lord, he has not conducted any work properly, my lord. He never surveyed. And then he says the better opinion can be formulated by the Hubli Dharwad Urban Development Authority, my lord. That is his opinion.
They themselves, initially joint measurement was conducted. In the joint measurement conducted on behalf of the SLO, it came out that 1 gunta and 1 gunta 10.5 annas is acquired. Thereafter, my lord, before this court in this very writ petition, last year in 24 to 2024, they took up the dispute that the measurement is not correct. Then this court directed the DDLR to measure and submit the report. Even that report also clearly shows the DDLR has measured and submitted the report on 5/4/2024. Before that is part of this records of this writ petition, my lord. By direction of this honorable court only, DDR conducted. DDLR.
Report filed on?
5/4/2024.
Yes.
And this also they say that this is not a proper measurement.
In fact, no survey.
And what happened is that, my lord, they directed the BRT's name to be mutated in the record of rights also. HDMC directed, property belongs to HDMC. And that was challenged before the Assistant Commissioner. Assistant Commissioner set aside that mutation.
So 66K1 nalli a portion of the property.
Very small portion of this thing is acquired for them. That they are denying to give the compensation even till today. They initially notified, issued notice to me, collected the documents also from me. Bond ತಗೊಂಡ್ರು ಎಲ್ಲ ತಗೊಂಡು rate fix ಮಾಡಿ ಕೊಡ್ತೀವಿ ಅಂದಾಗ last moment they came out with the fact that this belongs to road margin area, this belongs to corporation, and corporation never said that this property belongs to them. Even they did not contest before the Assistant Commissioner when the mutation was contested. Assistant Commissioner directed to delete that name.
Plus, with regard to basically not this writ petition, my lord, the claim of the petitioner, my lord, it suffers from the doctrine of suppressio vera and surreptitio falsi, my lord. Lord, entire case rests on Annexure C, my lord, which got surveyed at the instance of the petitioner in the year, my lord, 2013. The acquisition notification was issued in the year 2012. And with regard to block number 66, my lord, the name of the owners is not at all shown in the section 15 notification of the year 2012. This particular Annexure C, my lord,
shown.
It is the...
No owner's name is shown.
Beg your pardon, my lord?
No owner's name is shown for block 66.
66 in the section 15 notification, no name of any owner is...
You not acquired it.
It is acquired. That land is mentioned.
No owner's name is shown. How is it acquired?
Lord, now, my lord, that particular portion which is acquired, it forms a portion of the road abutting these 4 sites. Lord, this...
How can you acquire a land without showing the name of the owner?
Because, my lord, for this particular acquired portion, it didn't stand in anybody's name, my lord. I'll convince, my lord, this particular Annexure C, my lord, the measurements are shown, my lord, on all the 4 sites. And if this particular area is calculated, it amounts to, my lord, 14 guntas, 8.32 annas. Whereas, my lord, the petitioner has never produced their document of title, my lord, the earlier sale deed or gift deed. That I have produced, my lord, at Annexure R6 and R5 and R6, my lord. R6, my lord, it is the first title deed for this particular site number 1. There are totally 4 sites developed in RS number 66, my lord. Page number 20, the vendors, my lord, they sold the property to the purchaser, my lord. One Ramesh Sheikh, they sold
11 guntas in 92.
Yes, my lord. 11 guntas, 15.25 annas.
Yes.
Page number, my lord,
23.
Yes, my lord. And the same property was gifted, my lord, by the purchasers, being the donors, in favor of the donee, my lord, in the year 2012. And here also, the area that is shown, my lord, that is conveyed, that is block number 66K, plot number 1, measuring 11 guntas, 15.25 annas. This is the portion which is purchased by the original purchaser, thereafterwards, which is being gifted to the donees, my lord. Now, my lord, not a square inch out of this particular portion of the land being conveyed is acquired, my lord. In fact, this particular annexure C, if it is, when it is got done at the instance of the petitioner, my lord, a survey were conducted on 23/1/2013, as it is evidenced by the contents of annexure.
Boundaries are Purva ke raste,
Yes, my lord.
Paschima ke block number 65, Uttara ke raste,
Yes, my lord.
Dakshina ke alli, Dakshina ke
Plot number
number 2.
Yes, my lord. There are 4 sites developed in this particular.
This is Uttara ke raste, alwa, Uttara tane idu,
East is size, my lord.
annexure C.
Annexure C, my lord. In annexure C, my lord, the directions.
The direction ಕೊಟ್ಟಿಲ್ಲ.
Kotlira. Not suffice it to respectfully submit, my lord, the
Page-
area if it is
page 28
calculated.
Page 28, that map is there.
My lord,
Page 28 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Page 28 of my writ petition may please be seen.
Yes, we are seeing that only, annexure C.
ಅಲ್ಲಿ ಧಾರವಾಡದಿಂದ ಹುಬ್ಬಳ್ಳಿಗೆ ರಸ್ತೆ.
ಅಲ್ಲ, ಈ ಉತ್ತರ ಯಾವುದು ಇಲ್ಲಿ? ಅಲ್ಲ, where is north? ಎಲ್ಲೂ ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲ ಸರ್, ಅದು ಅಲ್ಲಿ ರೋಡ್ ಮೇನ್ ರೋಡ್ ಹೈವೇ ಇಸ್ ಶೋನ್.
ಪಶ್ಚಿಮಕ್ಕೆ ಬ್ಲಾಕ್ ನಂಬರ್ 65ನ 10, ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ, ಪೂರ್ವಕ್ಕೆ ರಸ್ತೆ.
R4 ದಲ್ಲಿ ಆ ಉತ್ತರ ಅಂತ ತೋರಿಸ್ತಾರೆ.
Lord, in the
TDLR map.
DLR map, it can be seen along with the memo which has been produced.
ಸೊ ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ, ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ 66. Yes.
Well, let's,
And
if
even
the
the
area is,
notification, if your lordship is pleased to see, the notification which I obtained in the RTI, my name is clearly shown there.
well, let's,
This is a notification under
I produced it at annexure R1, my lord. Annexure R1, page number 8, my lord, along with my statement of objections.
this is JMC, not notification.
Yes, that is joint, when they joint measured it.
Notification ನಿಮ್ಮ ಹೆಸರು ಇತ್ತಾ?
That I have produced R1, my lord, along with my statement of objections, page number 8. In particular, page number 9, my lord, serial number 290 and 291, block number 66, then plot number 1. Names are not shown.
Who was required to show?
Madam,
Who
pardon?
was required to show the names?
That's a notification is issued by the state government.
So now we'll hold that the acquisition has not taken place. The acquisition without showing the name of the owner whose sale deed was registered in the year 1992, not having been shown in a notification of the year 2012.
Well, the reason for
is
that is
contrary to the acquisition laws. Therefore, we'll quash the acquisition in respect of 1666
well, this particular,
at serial number 290.
but for that, my respectful submission is that this particular portion that is acquired, it forms part of the road portion which totally measures 3 guntas plus, my lord. Out of that, one gunta 10 annas has been taken. That
Explanation as
doesn't,
to why that has been.
that doesn't belong to the petitioner at all, my lord.
Where is the award?
Award is not produced.
Tangdi, your road is going to get closed. Please remember that.
Beg your
You can persist with your arguments,
But here,
but we'll direct the road to be removed.
well, I will convince on the, what, even the commissioner report.
You are going to be responsible for it.
Yes, my lord.
Yes.
Well, my submissions are that if the area is calculated in terms of the map
Because
prepared,
you have excluded the road on the eastern side. The passage which was given for all the four sites.
it is got prepared by them, my lord. I am relying on that annexure C. So if the area is calculated, my lord, it comes to 14 guntas, 8.32 annas. Whereas what they have purchased is hardly 11 guntas, 15.25 annas. This is where the crux lies, my lord.
So 44 into 20.50 into
Yes, that
69 into 31.50.
Yeah, that calculation is set up at annexure
meter.
Meter, my lord. That calculation is made in the order passed by the SLAO at annexure L, my lord, which is impugned in this writ petition.
20.50 into 44.
Annexure L, my lord, that's the order passed.
69 plus 44 by 2. 20.50 plus 31.50 by 2.
On DDL.
My lord.
It's all in feet, alva?
Yes, but the detailed calculations are available at page number 59 of annexure L.
To 1469, Mr. Patil. 1469 square feet barta ide. Your calculation.
For that,
Yes,
may I
lord.
draw your
That
lordship's
is
attention
square
to my lord?
meters, my lord. My lords are correct, my lord. 1469 square meters.
That
When
SLAO has calculated it, your lordship may find it at page number 3 of DDLR report, which is filed.
So you have purchased
11 guntas, 15.25 annas. $11,979.
ಅದಕ್ಕೆ ಒಂದು ಸ್ವಲ್ಪ ತಾವು DDLR detailed report ಇದೆ ನೋಡಿ ಸರ್.
What is the calculation you are saying, Mr. Angadi? 11,979 is 11 guntas.
Yes, my lord, the entire.
You are trying to calculate it on the basis of annexure C.
Yes, my lord.
Which is giving that plot of
the total
66-1. Block number 66-1.
Which they claim to be the owner.
Now 66-1,
Yes,
if we take your measurements,
yes,
is coming to only 1469 feet.
Yeah, that when it is converted, my lord, it comes to 15,812.
Iದೇನು square meters, meter alidya, feet alidya?
Yeah, both are available, my lord, under annexure L, my lord. Detailed order has been passed.
ಅದಕ್ಕಿಂತ with the lordship's permission, my lord, all clarity is given in this DDLR report. ಇಲ್ಲಿಂದೇನು this court directed him to measure
Annexure
KJP ನು ನೋಡಿದಾರೆ ಇದನ್ನು
page
ನೋಡಿದಾರೆ.
number 52, my lord. The relevant discussions, my lord, page number 53, my lord, joint measurement, it has incorrectly been shown that 1 gunta 10.5 annas belonging to the petitioner, my lord. In fact, the ADLR induced the SLO to accept that report, my lord. That has been categorically stated in the statement of objections, my lord. Now, my lord, coming to the, there is a reference to the KJP effected under number 10 of 1987, page number 56, my lord, which speaks about the different plots developed therein. There are totally 4 industrial sites have been developed. Total area of the plots is spelled out, my lord. Then road portion, my lord, it is 5 guntas, 3.75 annas. Then total area. Then this is the first and the last map, my lord. And in fact, this map, KJP map also, they rely in their writ petition, my lord, grounds. That is at para number 18 of the grounds, they rely on the same particular KJP map, my lord. The details of that KJP map has been spelled out in para number, page number 56, my lord. Then there is a reference to the annexure C, my lord. That same map has been called out.
Is this measurement here in feet or meters?
Yes, it is in at page number 59. My lords will find both, my lord. The calculate 59.
59.
para number 2, my lord. It's part of annexure L, my lord, page number 59 of the writ petition.
Yes.
ಹದ್ಬಸ್ ನಕ್ಷೆಯ ಪ್ರಕಾರ ತಯಾರಿಸಿದ ಜಮೀನಿನ ಬಾಹುಗಳನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡಾಗ ನವಲೂರು ಗ್ರಾಮದ ಬ್ಲಾಕ್ ನಂಬರ್ 66/1 ಕ್ಷೇತ್ರ ಈ ಕೆಳಗಿನಂತೆ ಇರುತ್ತೆ. What my lords calculated is precisely the
That
same.
is what is SLO has done this.
Then my lord, it comes to 1469 square meters. Then when it is converted into square feet, my lord, it comes to 15,812.316
And guntas, it is 14.52.
Yes, my lord. It is divided by 1089 per gunta, my lord. Then finally, it comes to, my lord, 14 guntas, 8.32 annas.
Yes.
This is contrary to the contents of the sale. This itself manifests that, my lord, the petitioner has not approached this honorable court with clean hands. Now, my lord, that is why, my lord, it has been, and in fact, it is held that he is in excess of land of 2 guntas, 9.07 annas. Therefore, my lord, the property which is acquired, it doesn't belong to him at all, my lord. Even, my lord, this honorable court was pleased to appoint a court commissioner, my lord, that is the Deputy Director of Land Records, my lord. I have filed my statement of objections for the said report. On that day, my lord, the DDLR did not conduct any measurement or survey work at all, my lord. That has been for all the officials who were present at the time of inspection. My statement of objections to the spot inspection report, my lord, conducted pursuant to the orders passed by this honorable court, my lord. I have filed it on 5/6/2024, my lord. Para number 2, I have categorically stated, my lord. Para number 2 and 3. The Deputy Director of Land Records, DDLR for short, intimated this respondent be present at the site of inspection, fixing date as 19/2/2024 for the purpose of court commission measurement works. This respondent SLO had deputed 4 of its officials, my lord, including 2 civil engineers. Then para number 3. On 19/2/2024, the DDLR did not conduct any measurement or survey work with regard to the site of the petitioner, plot number 1, measuring 11 guntas, 15.25 annas in RS number so and so, and also the remaining plot number 2, 3, and 4, and also the road portion measuring 5 guntas, 3.75 annas arising out of the same land. My lord, even that Jawab based which he has prepared, my lord, on 19/2/2024, it doesn't speak about the dimensions of the internal road portion, my lord, and the road portion abutting the erstwhile NH4. And instead of meticulously carrying out the measurement work, my lord, it says he has come to a conclusion on the basis of Vahiwat, my lord. No survey work was conducted, my lord. And then, my lord, when inquired, my lord, the DDLR said that he would go to office and then take the assistance of computer system and prepare the map. All these things are placed by way of pleadings in the objection to the commissioner report, my lord.
Even as per the document that you have produced yourself.
Yes.
At annexure C.
Yes.
The extent is coming to 1469 square meters.
Annexure
C. Into 10.764 is 15,812 square feet.
Yes, ma'am.
Nim prakara, it should have been 4,000 square feet extra.
For this,
not purchased it.
No, total what has happened is 1 acre, 12 guntas was total this property purchased. Then it was converted to industrial NA, and 4 plots were laid down. And out of that is crystal clear from DDLR's
Your purchasing is 66.1.
Totally 66K was 1 acre, 12 guntas. 12 out of that, 4 divisions were made. Your lordship may please take that DDLR's report.
All this you will have to establish if you claim, if you ask for enhancement and the calculation.
Enhancement illa your lordship may please to see. ಸ್ವಲ್ಪ DDLR report ಸ್ವಲ್ಪ ನೋಡಿ sir.
Yes, my lord. In fact, I would like to remember the same, my lord.
Page 3 of DDLR report.
It will require evidence. We can't. Though of course we can, but in this writ petition we can't.
Let him pass award, 0 award. Then I will proceed. Your lordship may please to see in this award also what he has proceeded.
He'll reserve liberty to you to file application for enhancement. Then there you establish all these things.
That's your lordship may please at page 60 may please be seen, my lord. The order passed by the SLAO.
Yes. Yes.
ಉಲ್ಲೇಖವಂದ್ರೆ ಆ ಸೂಚನೆಯ 290 ಆ ಸೂಚನೆ ನವಲೂರು ಗ್ರಾಮ 66 ಕ 1 ನೇದ್ದು ಭೂ ಸ್ವಾಧೀನದಿಂದ ಬಾಧಕವಾಗಿಲ್ಲ ಭೂ ಸ್ವಾಧೀನಗೊಂಡ ಕ್ಷೇತ್ರ 1 ಗುಂಟೆ 10 ಅಣೆದ್ದು ಬ್ಲಾಕ್ ನಂಬರ್ 66 ಕದಲ್ಲಿ ಬಿಡಲಾದ ರಸ್ತೆ ಮಾರ್ಜಿನ್ ಕ್ಷೇತ್ರದಲ್ಲಿ ಬರುತ್ತದೆ ಎಂದು ಘೋಷಿಸಿದೆ. ವೇರ್ ಇಸ್ ದಟ್ ರಸ್ತೆ ಮಾರ್ಜಿನ್ ಕ್ಷೇತ್ರ? That is not, you, Assistant Commissioner's order may please be seen.
Ex facie now, either we'll have to dismiss your writ petition or allow you to go before the reference court.
If provided he passes the word. He has not passed the word at all. What he says is, he says
that is remaining is more than what your claim is.
That is why DDLR report, this honorable court directed the DDLR to get the measurement. He measured.
No measurement.
He
has measured.
No, my lord. Page number 2 onwards, my lord. I'll take my.
Where is the measurement mentioned in that report?
Page number 2 onwards, my lord. I'll start with page number 3, my lord. Of the report.
Where is the measurement in page 6?
Page number 2 todi sir. Page number 3 dalli starts ಆಗುತ್ತೆ.
And even
ನವಲೂರು ಗ್ರಾಮದ ಬ್ಲಾಕ್ ನಂಬರ್ 64 etc.
HL ಒಂದು measurement ಇಲ್ಲ.
Yes, my lord. Even same map. There are no measurements, my lord.
ಅದು ಬರೀ ಒಂದು entry. There is no measurement.
In fact, my lord, the concluding paragraph of the commissioner report, my lord, at page number 4, the last but one paragraph, my lord. ಕಾರಣ ಈ ಬಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಪ್ರಾಧಿಕಾರ ಎದುರುದಾರ ನಂಬರ್ 4 ನೇದವರು ಕಮಿಷನರ್ ಹುಬ್ಳಿ ಧಾರವಾಡ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ PB ರೋಡ್ ನವನಗರ ಹುಬ್ಳಿ ಇವರಿಂದ ನಿಖರವಾದ ವರದಿ ಪಡೆಯಬಹುದಾಗಿರುತ್ತದೆ ಎಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. This is the conclusion, my lord. No survey work was conducted, my lord. I've shown
that is the case, my lord, let there be direction to give the measurement for the DDLR.
You establish it before the reference court.
No, my lord,
this court cannot be doing all these things.
No,
to see and examine in a writ petition the measurements.
No, this court direct.
But the land which is available is in excess of your
Yes,
what you have purchased. As simple as that.
No, madam, that's not. It is not excess.
ನೀವು
Even
annexure C ಅಲ್ಲಿ ನೀವು show us after annexure C.
Yes.
69, 44, 20.50, 31.50 in meters. That is coming to 15,872 square feet. What you have purchased is 11 guntas and odd. 12 ಗುಂಟಾಸು ಇಲ್ಲ.
ಅದಕ್ಕೆ ಸೈಡ್ಗೆ ಒಂದು ರೋಡ್ ಬಿಟ್ಟಿದ್ದಿದೆ ಸರ್.
ರೋಡ್ ಬಿಟ್ಬಿಟ್ಟೆ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ, ಅದು ನೋಡಿದ್ವಿ. Annexure C ನೋಡಿ.
Annexure C ದಲ್ಲಿ 69 one side, 44 one side, 31.5 one side, 20.
Only that line. ರೋಡ್ ಆಮೇಲೆ ಇದೆ.
ಅಲ್ಲ, ಧಾರವಾಡದಿಂದ ರಸ್ತೆ ಹುಬ್ಬಳ್ಳಿಗೆ.
ಆ ರೋಡ್ ಆದ್ಮೇಲೆ ಈ ಕಡೆ ಒಂದು ಪಶ್ಚಿಮಕ್ಕೆ ಒಂದು ರೋಡ್ ಇದೆಲ್ಲ, ಈಸ್ಟರ್ನ್ ಸೈಡ್.
ಈ ಸೈಡ್ ಆ ರೋಡ್ ಬಿಟ್ಟು 31.50 plus 20.50.
50 divided by 2. That is 26. 69 plus 44 by 2 is 56.5.
Yes.
56.5 into 26 is 1469. 1469 into 10.764 is 15,872.
Yes.
You have got 11 guntas. 11 into 1089 is 11,979.
OF
11,979 ಗೂ 15,872 ಗೂ ಡಿಫರೆನ್ಸ್ ಇದೆ.
ಇದು that is ಈ ರೋಡ್ ಅದರಲ್ಲಿ ಬರುತ್ತೆ ಸರ್.
ಅದಕ್ಕೆ ಅದು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿ. The petitioner, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? Serial number 113. Petitioner is before this court seeking for the following reliefs. The contention of the petitioner is though the land of the petitioner has been acquired, though the land of the petitioner in plot number 66K1 has been acquired, compensation has not been paid.
And the permission
order passed.
My colleague.
Yes. Order passed by the SLAO dated 25/11/21 at Annexure L has held that there is no acquisition made when in fact there is acquisition made. The submission of Shri K.L. Patil, learned counsel appearing for the petitioner, is that a portion of the property belonging to petitioner in plot number 66K1 has been made use of for the BRTS project.
Yes, BRTS.
And in this regard, he relies upon the survey sketch at Annexure C to indicate that on the northern side of the property of the petitioner is situated the BRTS road, and a portion of the land of the petitioner has been utilized for the widening of the road and implementation of the BRTS project. Compensation is required to be awarded to the petitioner. It is in that background that the aforesaid prayer is sought for to quash the order passed by the SLAO dated 25/11/2021 at Annexure L. The petitioner claiming that a portion of the land has been acquired, the SLAO having held that the portion of the land has not been acquired, he is virtually an award in the negative, passed by the SLAO. Even as regards an award which is passed negating the claim of the land loser would have a right for reference, seeking both for enhancement and for establishing the title of the property which has been acquired. The same cannot be established in a writ petition of this nature. The contention of the petitioner being that a portion of the land has been acquired, the contention of the Special Land Acquisition Officer and the Karnataka Road Development Corporation Limited being that no land of the petitioner has been acquired, it would have to be established before the reference court as to whether any portion of the land has been acquired or not, and if so acquired, what is the compensation liable to be paid. Needless to say, if the acquisition is not made, there would be no requirement of compensation to be paid. These are matters which cannot be gone into by this court in a writ petition jurisdiction, hence reserving liberty to the petitioner to file appropriate reference under section 65
of Karnataka Highways Act.
Highways Act, 35 of the Karnataka Highways Act. The petition stands disposed. the limitation period, if any, stands extended by a period of 30 days from today to enable the petitioner to file such reference.
Watch out.
First Desai.
The petitioner, my lord.
Yes, Ms. Desai, whatever you decided.
This matter, on the last occasion, the Lordship has directed me to take a stand whether the property is government land or the acquisition proceedings has to be cost. Lord, my lord, as per the instructions given, my lord, it is the state property. And it is the government land. So, my lord, if the writ petition is allowed by quashing the notification, we are not.
You are not.
Yes.
You are going to return the land. In, you have to get back on that.
And seek for, my lord, allotment from the government.
ಅದು ಕೊಡಕ್ಕಾಗಲ್ಲ. ನೀವು ಅದೇ ಲ್ಯಾಂಡ್ ಮತ್ತೆ ಅಲಾಟ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ
Allah, from the government, my lord, with that liberty.
You can't do both.
No, my lord, now there is a misrepresentation that that land belongs to a private party.
Then fight it out.
That is why, my lord, this is the writ petition which I filed.
Then fight it out. Why are you asking for cancelling that allotment? You're asking for acquisition to be quashed in respect of that particular land.
Yes. Because it is acquired under a misconception that it belongs to a private party.
But you'll have to return the land.
That statement I've made, my lord, allow in the writ petition itself.
Page.
My lord, lordships may kindly see page number 8. The last 4 lines of the second paragraph. Though the petitioner has set up the resort in the entire extent of 29 acres 22 guntas, the said land measuring 138 is not utilized.
Not utilized and is kept vacant till this date is fine. Will you be returning it to the state? It's another aspect.
Lord, I may have to, my lord, I have no other choice if the
What is your
acquisition,
submission,
if
Mr.
the
Desai?
acquisition, my lord, goes.
Last time, that is why it was adjourned for your submission and for the state submission.
Lord, if the acquisition, my writ petition is allowed, the acquisition goes, then the land, my lord, vests with the state government.
Will you return it?
Yes, my lord, then I may be given liberty to approach
He
the
won't
state
give you
government.
any liberty. It is up between you and the government, and they can also object.
My lord, your lordship, sir, kindly, on factual aspects of the matter, my lord, my learned friend, my lord, who has made a submission, that's the government land, that is also incorrect. And the statement made by the state is also incorrect. On records, my lord, Lord, suppose, my lord, this 1 acre, my lord, 38 guntas. If it is a private land belong to me, Lord, I am entitled for a compensation. If it is a government land, my lord, your lordship, question. Lord, on 2 points, Lord, my learned friend has made a statement. Lord, may I request your lordships kindly take, my lord, the synopsis, my lord.
Lord, if it is going to be heard, my lord, I will argue first.
Then
let him say.
Lord, 2 minutes, Lord, I will convince.
Yes.
If I am able to show that, Lord, it is not a government land, and the statement which has been made by my learned friend, without basing on the records.
Mr. Patil,
Please.
it is immaterial whether it's government land or private land. We are quashing the notification. The land comes back to you if it is private land. If it is government land, it will go back to them.
2 aspects, your lordship. Factually, my lord, your lordship. Factually, my lord, 2 aspects, your lordship, on facts. Lord, suppose, Lord, if it is a private land, my lord, belonging to my client, he is entitled for a compensation.
If it is acquired.
Yes, acquired. Lord, on facts, on records, Lord, if I am able to show to your lordships, Lord, it is a private land belonging to my client, then, Lord, your lordships, Lord, the assertion that it is a government land, it belongs to government, that is factually incorrect. 2 aspects, Lord, I want to bring it to your lordships, kindly, on facts.
Then this will take some time, which we don't have time today. We'll adjourn it to some other day.
Any date, Lord, your lordship, can be fixed.
Due to paucity of time, the matter cannot be taken up. Relist on 13th March.
But the interim order may be extended.
Interim order earlier granted is extended till next.
Lord, next week, Lord, I wanted to argue.
The 13th.
Next week. My lord, next week, Lord, I request.
18th March.
18th March. Next week, Lord, may I meet.
It won't happen next week.
ಈಗ ಒಂದೇನೋ ನಿಮ್ಮ ಮುಂದೆ ಅಡುಗೆ ಮಾಡಿ ಮಾತಾಡ್ಕೊಂತ ಏಜ್ ಆಗಿದೆ ಅದು
ಇದು ಆಗಿಲ್ಲ.
ನಾವು
Next week,
73 ಅದಕ್ಕೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಿಮ್ಗೆ ಇನ್ನೂ ಒಂದು ಗೊತ್ತಾಗುತ್ತೆ ಇಲ್ಲಿ ಇನ್ನೆಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಬರುತ್ತೆ ಅಂತ.
ಇಲ್ಲ ಎರಡೇ ಮಾಡಿದ್ದು, ಅದೊಂದು ಮಾಡಿದ್ದೀನಿ ಇದೊಂದು ಮಾಡಿದ್ದೀನಿ, ಎರಡೇ ಮಾಡಿದ್ದು.
ಇದು ಆಗಿಲ್ಲ. ದಿಸ್ ವಿಲ್ ಟೇಕ್ ಸಮ್ ಟೈಮ್.
115 ಸಂತೋಷ್.
Interim order.
Right.
115 ಸಂತೋಷ್ ಮಲ್ಲಿಗವಾಡ್.
I appear for petition. Last occasion, lordships were directed to, please to direct the state to rework the entire notification regarding town municipal council.
Mr. Gangadhar.
Interpretation of section 42 of the Municipalities Act.
ಈ ವುಮೆನ್ ಅಲ್ಲ?
Yes.
Please. Madam, the page number 3, my lord. I have given the list, my lord, where the classification has been changed. Reservation has changed. Especially cases, in these cases, the reservation have been changed. Initially, it is reserved for the women. Since no woman candidate is available,
ರಾಯಚೂರು
please.
ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳಾ.
ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳಾ ಇತ್ತು ಅದು. These are the reservation provided under the original notification, my lord. Original notification. Dharwad ಜಿಲ್ಲೆಯಲ್ಲಿ ಅನ್ನಿಗೇರಿ, it is reserved for ST women. ದಾವಣಗೆರೆ ಜಿಲ್ಲೆ ಮಲೆಬೆನ್ನೂರು, reserved for ST women. Then Uttara Kannada, ST women. Then Jilladhikari, KR Nagar, SC women. Subsequently, these are considered, and after taking the opinion from the Advocate General Office and Law Department, it was being read as general. ಎಲ್ಲವೂ ಇವನ್ SC women ಇದ್ದದ್ದು SC ಮಾಡಿದ್ದಾರೆ, ST women ಇದ್ದದ್ದು ST ಮಾಡಿದ್ದಾರೆ. At present, no reservation, no elections is been, all the elections have been completed in respect of the town panchayat as concerned. PMC is concerned.
This is as regards Annigiri.
Annigiri, that's fall under the second one.
The elections have been completed for.
Yes, Balaganur completed, Malebenur completed, and Raichur. Completed. Except Bhatkal, my lord, it is pending litigation before this honorable court. Yes.
Bhatkal.
It is pending litigation before this honorable court.
ಅದು SC.
Bhatkal is SC woman.
That is also pending.
Near the petitioner. ಆಮೇಲೆ ಇದು KR Nagara.
That is complete. All elections completed except Bhatkal, that is pending before this honorable court litigation.
Bhatkal and Annigiri.
Annigiri.
The other three are complete.
Annigiri is other. Present is Annigiri.
ಐದೇ ಇರೋದು, ಐದರಲ್ಲಿ ಎರಡು ಪೆಂಡಿಂಗ್ ಇದೆ, Annigiri and Bhatkal. Bhatkal is the petitioner is a scheduled caste woman.
Scheduled caste woman.
ಅಲ್ಲಿ ಇರೋದು ರಿಸರ್ವೇಶನ್ ಇರೋದು scheduled caste ಇದೆ. Scheduled caste woman.
So Bhatkal writ petition is pending in the principal.
Yes, no, here I have filed.
ಇಲ್ಲ.
Yes. Uttara Kannada district, Karwar.
ಅದ್ ನಂಬರ್ ಏನು?
I shall give it to you. I was ಇದು ಈಗ ಇವಾಗ ಕೊಟ್ರು. ಇಲ್ಲ ಅಲ್ಲ ಇದನ್ನ ಇವಾಗ ಕೊಟ್ರು ನನಗೆ. I will give the number. I have the number.
ಮ್ಯಾಟರ್ ಇದೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. Yes. Related matter ಇದೆ ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
ಇಲ್ಲ I will give the number. Both of them tag together.
Connect with WP so and so and relist on Monday.
Yes. I shall give the number.
The AG has filed a memo enclosing the letter of the Principal Secretary, Urban Development Department, dated 10/2/2025. The same is taken on record. Connect with WP so and so, relist on Monday. You can explore the possibility that is SC woman, this is ST. So if these two are interchanged,
yes,
subject to that writ petition, we don't know the facts.
Yes.
I will go to the writ petition.
Verify ಮಾಡಿ.
Please.
If adadre, this will get solved.
I will.
Please.
Yes, the representation will be proper. In fact, ನೀವು ಮಾಡಿರೋದು correct ಅಲ್ಲ, but ಆಗಿದೆ. ಇದಾದ್ರೂ ಮಾಡಿದ್ರೆ at least that reservation will be maintained.
But
because I have not been represented, my lord, since many years. No rotation is provided to me. I'm the candidate.
But
not
in,
claiming and,
I encode
no
with the,
reservation, not even not.
If we go by Bombay judgment, we'll have to keep it vacant.
But even otherwise also, your lordship may kindly see the rotation pattern not under 42. What the Supreme Court says, my lord, all categories has to be, my lord, given representation.
That they've done.
Yes, no.
in the context, my lord.
That
See,
now we can't consider that.
the
aspect when the
state has
elections have
been considered. I encode with the officer why you have done that. The state has considered the main reservation, my lord, is SC and ST. The subdivision and sub classification as horizontal reservation. So that has been compromised because of the situation, my lord, not because of. So if they change the entire, for example, my lord, if ST change into SC, my lord, that will raise the representation of another caste. But here, what the government has done, only change the horizontal reservation. They have not changed the major reservation of SC or ST, but they only changed because of the non-availability of the candidate.
Is the same
Oh, yes, only my because in some cases, I give the example. Some cases it is reserved for ST. However, the ST woman has been got elected.
Either nodi, don't examine my head.
I will examine.
Otherwise,
please. And in notification is also we have issued, my lord. See, earlier Deputy Commissioner has issued the notice to overcome the technical difficulties, my lord. That should not be done in this case. So again, I advise the government, my lord, now the notification came to be issued. Please. That is the right method.
Delayed.
That is the right method, my lord.
You won't get any benefit. It will only delay.
Please.
Yes. One submission, if your lordships permit me, my lord, this issue will again crop up because section 42 does not permit subclassification. Now next election, my lord, if they keep on doing the same, I am just submitting as time. I leave it to lordships.
Subject matter of this petition.
I will leave it to lordships because this issue would come up again and that requires to be addressed.
Subject matter.
Yes.
116.
Obliged. Interim order may be kindly extended.
Interim order earlier granted is extended.
Highly obliged.
116.
This matter, my lord, we have filed a joint compromise petition.
ಮೊನ್ನೆ ಹಾಕಿದ್ದು you sought for adjournment.
Yes, my lord, your lordships, whether this court can record the compromise.
RSL ಮಾಡಿ ಅಂತ.
Yes, my lord, similar matter, my lord, this honorable court has recorded the compromise.
It might be recorded.
I am not, my lord. Otherwise, my lord, another submission would be. Another submission. With due respect, my lord.
You have to advise your.
Yes, my lord, my submission is, if this matter is referred to mediation in Dharwad court, then section 89 operates, my lord. If that is recorded and reported to this court can. So after reference, section 89 operates, my lord.
Not in a KLR matter.
Section 89, any dispute anta.
But it will be covered under, it will be recorded under KLR. A direction for, see, if para 4 was not there, there was no problem.
Yes.
Para 4 iradrinda problem ide.
Or, my lord, may I make one submission? Lord, the deputy commissioner has passed an order setting aside the order of assistant commissioner only on the ground of pendency of RSA. That RSA he has withdrawn. So the order of DC does not survive.
Is CS Shutter submitted that he will withdraw. No problem.
Yes.
But para 4 only you have reworked the shares.
Yes.
Of each of the parties.
Yes.
That is where the problem is. So if you have to have a reworking of the shares, it has to be by a decree of a civil court, not by a deputy commissioner. And innon baratte writ petition. It's not been done in a revenue jurisdiction agalla anta.
Correct.
If you deal with the property, they will be raised this question. RSA just move the matter and get it done, alva. It will be a decree.
Please.
Even in the RSA also, we have. Even in the RSA also, what has happened? It was a low color decree. Even the RSA court is also having not jurisdiction. Does not have, for that reason only, Millers, out of the court we settle the matter. The appellant who has filed my party Millers.
RA was disposed of in terms of compromise. Before the low adalat. So he preferred an appeal, my lord, under section 100.
Miscellaneous, Millers. That is also, Millers, another issue.
It is the difficult.
So better, Millers.
So RA it has been remanded back.
No,
it is
RA, there was a compromise in RA itself. That was challenged by him. So he withdrawn that.
Millers, myself, Millers, withdrawn the RSA. That Miller's RSA was not been.
Compromise WP challenge ಮಾಡಿ ನಮ್ಮ advisory jurisdiction ಇಲ್ಲಪ್ಪ ಅಷ್ಟೇ ಸಿಂಪಲ್ ಮಂಡೇ ಫೈಲ್ ಮಾಡಿ
Please.
ಕೇವಟ್ ಹಾಕಿ
Will undertake this. And one day Miller's, if it is one put, will undertake.
as per this
Please.
ಅದ್ರಲ್ಲಿ ಮಾಡಬಹುದು
Right.
not in this
Great.
Obliged.
just on Monday ಯಾವ್ದು ಫೈಲ್ ಮಾಡ್ತೀರಾ
Friday, my lord. Friday.
we'll have it on Monday
Please, my lord.
Please.
230 mood matter. 1 Shivrudra, Girish Rajesh.
Petitioner.
Shivrudra.
Lord, am I audible?
yes Mr. Shivrudra, you are
Obliged. Lord, this is the matter not pertaining to the nursing course, wherein Lord the admissions are approved, and during the examinations, Lord, the examinations are not being given only on the ground that the submission of the papers were delayed. Your Lordship, can you have a glance at annexus C at page 12, Lord? This is the number which was generated, registered number which is being generated to these petitioners, and these petitioners are to take up the examination which is commenced from today.
Today?
Please, Lord. Up to Saturday, Lord, it was of the view that they will give the examinations. No, Lord, they have told no, we can't give you now. That's a Lord. That is a problem, Lord. I am before my lords.
Who is the counsel for respond number 1 and 2?
Lord, Sudarshan appears in Bangalore, Lord. I don't know who appears in Dharwad.
You should have found out by now. Yarappa, Karnataka State
Nursing Examination Board.
Examination Board.
Nursing examination.
Yaru ilva. Shri S. Sudarshan, standing counsel for respond number 1 is directed to accept notice for respond number 1. And respond number 2.
Same, he himself appears for that also, Lord.
Aura ಇವರ ಜ್ಯೋತಿ ಮರಡಿನ
ಇಲ್ಲ ಜ್ಯೋತಿ ಮರಡಿ ಬರೋದಿಲ್ಲ ಅವ್ರ ನರ್ಸಿಂಗ್ ಕೌನ್ಸಿಲಿಗೆ ಬರ್ತಾರೆ
ಕೌನ್ಸಿಲ್
ಪ್ಲೀಸ್
S. Sudarshan is directed to accept notice for respond number 1 and 2. The respondents are directed to permit the petitioner to take up their examination for the first year GNM nursing scheduled to commence from today and thing ಹೇಳಕ್ಕಾಗತ್ತೆ.
Scheduled from today, from tomorrow onwards.
From the next examination. ನಾಳೆ ಇದೆಯಾ ಎಕ್ಸಾಮ್?
ನಾಳೆ ಇದೆ.
From the next examination scheduled tomorrow, that is 19th.
19th onwards ante.
19th onwards. Fees ಎಲ್ಲ ಪೇಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಎಲ್ಲ ಆಗಿದೆ, ಫೀಸ್ ಎಲ್ಲ ಪೇಮೆಂಟ್ ಆಗಿದೆ.
So all ticket issue ಮಾಡಬೇಕಾ?
ಹೌದು.
Respondent shall issue necessary all ticket and comply with all the other formalities
please
required to enable the petitioners to take up their examinations as directed above. And delivery ordered. Petitioner respondent shall also act on the printout of a uploaded copy of this order from the website.
Obliged.
2
Released on 18th March.
2 Shivrudra.
Same matter, Lord. No, of a different school.
Where is that registration number?
Here, Lord, at
Annexure C.
Page Annexure C, page 21, Lord.
Same order.
Lord, may be permitted for take hand delivery of this court.
Ordered.
3 Prakash
Obliged.
Javalkar.
Yes, Ms. Javalkar.
Respect of demolition which is trying to be taken.
Who is demolition?
Respondent number 1 and respondent number 2 to 5. They are trying to demolish, and in fact notices are also issued by the respondent number 6 and 7, and to which they are not complying with, and being helpless, even respondent number 6 issued a request letter to the concerned PI also, Even thereafter, the demolition is trying to be placed. Your Honor can see this particular first photograph.
The demolition has happened, Mr. Javalkar.
ಇಲ್ಲ sir,
Roof
this
is
is
gone.
my portion. This is yet to be demolished.
ನಿಮ್ದು ಒಂದು
This is my portion, and this portion belongs to the respondent number 226. This belongs to 226, and this is my portion.
Who
So
is demolishing this for what purpose?
they are demolishing in their property, my lord, but in fact.
The private property?
It is a private property. And in fact, it is damaging my entire structure. So you, my lord can also see, this is their portion, and even my roof is also trying to be damaged. This is the third photograph showing that the damage which is trying to be caused even to the roof also.
Shri Gurudev Gachanmat is directed to accept notice for respond number 6 and 7. Learned AGA accepts notice for respond number 8 and 9. Issue emergent notice to respond number 1 to 5. Counsel for the petitioner is also permitted to take out hand summons to said respond number 1 to 5 and file written acknowledgement of service of notice by hand summons by 24th February. The respondents are restrained from in any manner carrying out demolition of the property bearing CTS number 3161 bar 1 to 3161 bar 8 and 3162.
And 3163, total 3 properties.
3161 bar 8, 3162 and 3163.
Yes.
Till the next date of hearing, otherwise than in accordance with law. Relist on 25th February for the learned AGA and the counsel for the HDMC to make their submissions. Process fee and copies to be furnished by end of day 19th February, and acknowledgement to be filed, acknowledgement of service of hand summons on the respondents to be filed on or before 22nd February, failing which the interim order will stand automatically vacated and delivery ordered. ಏನಪ್ಪ?
The challenge was on the it may be taken up tomorrow.
ಚಾಲೆಂಜ್ ಆನ್ ಏನ್ ಸ್ಟೇಜ್ ಏನಿದೆ ಸೂಟು?
Suit is for declaration and
ಸ್ಟೇಜ್ ಏನಿದೆಯಪ್ಪ?
stage is for arguments, not
ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? 44 relist on 20th in the preliminary hearing category.
Serial number 54.
54.
It is 2008 matter, my lords.
Ah.
After 17 years, my lord, my submission and the contesting respondent, I am contesting respondent and a petitioner's submission has become one and the same. It may take around 3 to 4 minutes, my lord.
3 to 4 minutes, LR KLR matter.
Illa, my lords, previously the division bench has ordered it and he is conceding to it and I am also conceding to it. It may not take much.
54 relist on 24th.
Monday, my lord.
24th. 230. LR 230.
Serial number 40, my lords. So in this case, my lords, the compromise petition was, compromise decree was recorded after lapse of 15 years, my lords. Notice has issued, my lords. There is no stay. Now before the trial court proceedings are going on, my lords. Interim stay.
Stage ಏನಿದೆ?
I am for the petition case, my lords.
Stage ಏನಿದೆ?
Stage for the evidence, you know.
ಇನ್ನ ಟೈಮ್ ಇದೆ.
Next week, any date?
ಅದಕ್ಕೆ ಆಗೋಯ್ತಾ?
ಅದು ಒಂದು ಡೇಟ್ ಕೊಟ್ಟರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಡೇಟ್ ಕೊಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ತಮ್ಮ ಮುಂದೆನೆ ಮುಗಿದ್ರೆ ಒಳ್ಳೇದಿರುತ್ತೆ. ಯಾಕಂದ್ರೆ ಒಂದು ಮಲಾಡ್ ವಿದೌಟ್ ಪರ್ಮಿಷನ್ ಮಲಾಡ್ ಬಿಲ್ಡಿಂಗ್ ಇಸ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್.
ಅದಕ್ಕೆ ಮುಗಿತಾನೆ ಇದೆ.
Conversion order is issued against dead person forging the documents.
Yes, Mr.
My lord, serial number 97. The rejection of injunction order was challenged. I was to file an affidavit not to claim equity. I have filed affidavit.
You have filed the affidavit?
I have.
97 relist 20th at 2:30 p.m.
Yes.
Serial number 40, my lord.
I'm sorry. ಹಿಂಗ್ ಹೋಗ್ಬಿಟ್ಟು ಮತ್ತೆ ಹಿಂಗ್ ಬರ್ತೀನಿ.
My lord, serial number 36. There was a direction to the DDLR to conduct survey and to submit a report. May I pass on the report may be taken on record. JMCPC matter, my state is not a party.
For the respondent.
Since there was a dispute in so far as
36 and AG has filed a report of the DDLR
along with a sketch map.
Krishna, the same is taken on record. Copy kottidira?
Copy
copies having been furnished to the other councils, they seek for and are granted 10 days time to go through the same and make the submission. Relist on 18th March.
Please.
60. Oh, party in person. Quick reach agala. 60. The matter could not be taken up due to paucity of time. The petitioner party in person is present before this court. Relist on 18th March. Yes.
My lord, serial number 1, second list, my lord.
Second list 1.
Serial number 1, my lord. Hearing on IA, my lord.
Second list 1.
Last occasion, this honorable court has directed the respondent to produce the acquisition notification, my lord. AGA, my lord. Day after tomorrow, my lord. Serial number 1, second list, sir. Serial number 1.
Lord, any date, I am ready.
Day after tomorrow. Acquisition notification produce, madam.
Advocates are ready. Court is not ready.
Serial. Day after tomorrow, my lord.
24. To serial number 1, 24th.
Serial number 40, my lord, there is lapse on my
Serial
part,
number?
my lord. 40.
40.
My lord, I have to return the, my lord. I asked my counterparty after servicing the summons, you have to produce the acknowledgement. My lord, he has not sent it. But fortunately, the respondents have been represented.
2, 1, 3. No, 1 no person, 3 deceased. 2 and 4 are represented.
40, serial number 40.
Serial number 40, Girish Shiramat. ನೀವು ಇಲ್ವಪ್ಪ? ನಿಮ್ದು ಯಾವುದು? ಯಾವುದು ಇಲ್ಲ.
Serial number 27, my lord.
27.
Please, my lord has directed me to produce the documents, notifications. I am producing.
ಯಾವ 2011 matter.
Please, 28 KIDB matter. My lord has directed me to produce the
27, the Red Council for Respond number 1 has filed a memo with the notification. the same is
Notification,
taken on
28-1 and 28.
Relist on 24th. Copy kottidira?
Yes, I have, sir.
Serial number 91.
90.
91. 91.
91.
Kindly tomorrow at 2.
ಏನಪ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ?
My lord, I am a safety officer, my lord. Till today, government is also passed an order, but till today I have not given a position and salary.
91 relist on 24th at 2:30 p.m.
I'm sorry, my lord, it is 29, serial number 29.
29.
There is lapse on my part, my lord. Counterpart has not sent the regarding service, my lord. Fortunately,
2, 3, 4 they have appeared.
Appeared.
5 served.
Served.
In dismissal ಇದೆಯಾ?
ಇಲ್ಲ.
ಏನ್ ಮಾಡಬೇಕು?
Non-filing of acknowledgement.
Non-filing of acknowledgement ಇದೆ. Let me.
Since the respondents have entered appearance, there would not be a requirement for filing of acknowledgement by the counsel for the petition.
One sentence argument, my lord. Defendant number 4 denies that initially it is self-acquired property. There I am a purchaser for
17, relist on 24th.
Please, madam.
Yes, Mr. Vidhan. 107, way off. ಎಲ್ಲಿ?
Yes.
One not seven. When are you coming next? Not next week, after that.
Second week of March, my lord, any day.
107.
Lord, if your lordship is posting it at 2:30, I'll come. Otherwise, my lordship will post it.
There's no point in posting and not taking
Then
it up.
it's okay. Any day, my lord, I am okay with March.
Here people are asking, we'll post it. There's risk whether it is reaching or not. If you're coming out from out of the city, then we can't post it and not take it up.
March 10th.
10th. 107, 10th March. 10th March.
My lord, 103.
Sale number 49, my lords.
49.
So other brothers of the respond number 4 are already on record, my lords. So petition may be abated against respond number 4.
File ಮಾಡಿ.
Please.
My lord, 103, my lord. We are undertaking to file wakalat for R1, my lord.
File ಮಾಡಿ. Undertaking ಬೇಡ.
My lord, one submission.
Serial number 36, my lord. That last occasion
The report ಕೊಟ್ಟಿದ್ದೇನೆ. Report is taken on record. Copies serve ಮಾಡಿ. One submission. It is not correct to make submission insofar as 48 is concerned. Since my lord, already time is left, my lord, my senior requested me to make a submission. So my lord, here my lord, regional commissioner of joint director has passed an order pursuant to which my lord, Hadbast is taking on effect. Now they are trying to fix the boundaries. ಅಲ್ಲ ಆರ್ಡರ್ಸ್ ಅಂತಂದ್ರೆ ಅದನ್ನು ಸಬ್ಮಿಷನ್ ಹ್ಯಾಂಡ್ ಸ್ಕೆಚ್ ಮ್ಯಾಪ್ ಅದನ್ನ ಟೈಪ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು ಅಷ್ಟೇ. ದಟ್ ಈಸ್ ದ ಸಬ್ಮಿಷನ್ ಗಿವನ್.
48. Accepting the submission of the counsel for the petitioner, office objection serial number 28 is overruled. And AGA is directed to accept notice for?
My lord, in that 1 to
private parties ಯಾರು ಇದ್ದಾರಾ?
ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ ಇದ್ದಾರೆ. My lord, 1 to 6.
Notice to respond number 7 to 11. What do you have to show that you are in possession?
My lord, we are cultivating. That has been, with regarding to cultivation, there is no dispute by either of the parties. My lord, we have stated that we are all joint family members. We are cultivating the properties. Now there is an acquisition proceedings and a pipeline has been passed to the entire property. Now in view of that judgment, the survey sketch, which was horizontal, now it has become vertical. The entire acquisition is with regarding to the private respondent's property that has been gone. We are not disputing insofar as possession is concerned. None of the parties are disputing.
Even respondents are with you.
How though?
Respond number 2.
Yes.
A and A1.
A is the order passed. Pursuant to which, my lord, A1 Hadbast map has been prepared. My lord, here, my lord, north to south, that is the direction which has been issued by it. But next annexure B is the hand sketch map. We are cultivating all the properties horizontally. Now it has become vertical. So only in order to grab the compensation with regarding to that insertion of that pipeline, my lord, the respondents are trying to, wherein my lord, steps have been taken to disbursement.
Come only in 24
ಹೌದು
bar
ಹೌದು
4.
ಹೌದು ಒಂದೇ ಪ್ರಾಪರ್ಟಿ ಆಗ್ಬಿಟ್ಟಿದೆ. We are not disputing with regarding to the entitlement of
Issue emergent notice to respond number 7 to
7,
11.
please.
Returnable by 27th March. The respondents, respond numbers, yeah, who is acting on it?
My lord, it is the respondent number, that is the survey, respondent number 5. Survey supervisor and Tahsildar are now taking effect to.
Respond number 2 to 6,
please,
are restrained from acting upon the survey sketch at annexure A and A1 till the next date of hearing.
Please.
Process fee and copies to be furnished by end of day 20th February, failing which the interim order will stand automatically vacated.
Seal number 25 is concerned, my lords. Seeking for interim order, my lords. Seeking for interim order, my colleague has filed application for impleading. Seal number 25.
The orders matter, IA matter, repeat.
On tomorrow, my lords. And 27 is concerned for disposal, my lord, regarding this honorable court directed that KIDB to produce the final notification. It is for
a date ಕೊಟ್ಟಿಲ್ಲ.
ನಾಳೆ ನಾಡ್ದು.
Serial number 60, my lord. Even in violation of interim order, they are creating the third party rights. So could you please accommodate next week, my lord? Serial number 60. We have adjourned just now.
2012 matter ಅದು.
Yes, ma'am. They are creating third party rights, my lord. So
2012 matter ನೀವು ಇವಾಗ urgent.
My lord, 103 we have filed the wakalat.
Good. ಒಂದು undertaking good, file also good.
ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು.
Yes, madam.
My lord, serial number 96.
We would have passed.
My lord, serial number 96. Other day, my lords, one of the case law partners had mentioned that the matter be heard today. In fact, they pressed, despite the court stating that since the arguments have already begun in advance, advancement of the arguments already begun, the court in fact insisted that let the main matter be heard. But they insisted the matter be posted today, and they are absent today, my lords. My lords, I'll request for a longer date because we intend to complete the main matter before the honorable trial court.
96, nobody is here. ಎಲ್ಲ March end ಅಲ್ಲಿ.
Much obliged, my lords.
Sorry, 24, 25. Siddhant. ಅಲ್ಲ ಈಗ ಬೇಕು ನನಗೆ 25. ಅಲ್ಲ ನಾಳೆ ತಗೊಳ್ತೀನಿ. ಶ್ರೀಕಾಂತ್.
interim order extension ಎಲ್ಲೆಲ್ಲ ಆಗುತ್ತಲ್ಲ ಎಲ್ಲ ಕೂಡಿ
Sir, 98
25. ಏ
interim order extend ಮಾಡ್ತಿರಲ್ಲ ಡೇಟ್ ಹಾಕಿರಿ. ನಾನು
ಡೇಟ್ ಹಾಕಿದ್ದಲ್ಲ
20th ಅಲ್ಲ 30th ಅಲ್ಲ
ಡೇಟ್ ಹಾಕಿರ್ತೀನಿ.
40 ಡೇಟ್ ಕೊಡ್ಲಿಲ್ಲ.
Sir, 98 100.
25.
44 ಯಾವ ಡೇಟ್?
40 ಕೊಡ್ಲಿಲ್ಲರಿ. 24 24 2
24 1 ವೀಕ್
ಶ್ರೀರಾಮ 25 ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಅದು ಆರ್ಡರ್ಸ್ ಮ್ಯಾಟರ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಸ್ಪೀಕಿಂಗ್ ನಾಳೆ ಇಟ್ಕೊಳ್ಳಿ ನಂಗೆ ಅದರ್ ಪಾರ್ಟಿ
20th ಹಾಕಿರ್ತೀನಿ.
20th ಓಕೆ ನಂತರ 27 ಇದೆ.
25 ತಾನೆ ನೀವು ಕೇಳಿದ್ದೀರಿ.
25 ಒಂದು 27 ಅದು ಡಿಸ್ಪೋಸಲ್ ಮ್ಯಾಟರ್ ಅದು
27 24 2 ಅಂತ ಸಾಹೇಬ್ರು ಹೇಳಿ.
24 ಟು 24 27 27